Good morning. We're on the record. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with the DC Code Section 2571HC of the Open Meetings Act, OMA, I'm welcoming you to the regular scheduled meeting of the Alcoholic Beverage Cannabis Board. This meeting has been conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the District Central meeting calendar. The notice includes the time, date, agenda, and call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I'm chairperson of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your name. Mr. James Short.
Mr. James Short, present.
Mr. Bobby Cato.
Present.
Ms. Jenny Henson.
Jenny Hansen, present.
Mr. Edward Grandis.
Edward Grandis, present.
The board has 5 members in attendance for conduct of business today, and that constitutes a quorum. Before we get underway with today's hearing, this morning's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings are understood by everyone. There are 7 cases scheduled for this morning. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case has not been heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first case this morning is a protest hearing status, case number 23 PRO 00050. 1 IAGU, license number 124054. This case has been continued. For 1 week to July 26, 2023 at 10:30 a.m. at the request of the parties. We now move to our show cause hearing status calendar. The first case on our show cause hearing status calendar is case number 23 CIT 00100. Maze 64, license number 118648. Good morning, Mr. Oriana. Can you please elevate the rights of the government and the licensee in this case, please?
Good morning. It appears that only the government is present. Colin Sensi, your access has been escalated. That appears to be all, Chairman.
All right, thank you. Good morning, Mr. Sensi. Can you please spell and state your name for the record, please?
Good morning, Mr. Chairperson. Colin Cenci, COLLINCENCI, Assistant Attorney General with the Office of the Attorney General for the District of Columbia on behalf of the district today.
Good morning, sir. I see that the licensee is not here today. This matter then is scheduled for a show cause hearing on August 16th, 2023 at 1:30 p.m. I'm sorry. Hold on, let me see something. Hold on. All right, this matters, as I stated before, this matter is then scheduled for a show cause hearing on August 16th, 2023 at 1:30 p.m. Just want to remind you, sir, that 7 days before the hearing, you are required to disclose documents and witnesses that will be relied upon at the hearing. Failure by the part of either party to disclose documents and witnesses that will be relied upon in the hearing, unless good cause is shown, the board is empowered to prevent that party from relying on those documents, sir. Okay? All right, thank you very much for that. The next case on our calendar is case number 23 CMP 00037, Kiddes Lounge, license number 119361. This case has been canceled due to submission of an offer and compromise to the board for its consideration. The next case on our calendar is case number 23 CIT 00069, Virginia Market, license number 119980. Mr. Oriana, can you please elevate the rights of the licensee in Virginia Market, please?
Again, it appears that only the government is present.
All right, good morning. Mr. Chenchi, can you please identify yourself for the record, please?
Yes, Mr. Chairperson, Colin Genci, COLLINCENCI, with the Office of the Attorney General on behalf of the district today.
Good morning again, sir.
Morning.
This matter then is scheduled for a show cause hearing on August 9th, 2023 at 1:30 p.m. And again, I would like to remind you that 7 days prior to the hearing, the parties are required to disclose documents and witnesses that will be relied upon in the hearing. Failure by either party to disclose documents and witnesses 7 days before the hearing, the board is empowered to prevent that party from relying upon documents and witnesses that have not been disclosed. All right, thank you very much, sir. All right, the next case on our calendar is case number 23 CMP 00039 Glassy, license number 117346. Mr. Oriana, can you please elevate the rights of the parties in this case, please?
Taj Sohal, your access has been elevated. That is all, Chairman.
Thank you.
Hi, good morning.
Good morning, ma'am. Do you have a camera you can turn on?
Yes, 1 second. Hello.
Yes, good morning. Okay.
Good morning. How are you?
I'm well, thank you. Okay, Mr. Chenchi, can you please identify yourself for the record, please?
Yes, sir. Colin Genci, COLLINCENCI, Assistant Attorney General with the Office of the Attorney General for the District of Columbia on behalf of the district today.
Good morning. Ms. Sohal, can you please identify yourself for the record, please?
It's Taj Sohal.
Spell your name, please, ma'am.
T like Tom, A, J. Last name is Sohal, S like Sam, OHAL.
Thank you, ma'am. We have a court reporter, so I just want to make sure that they're able to spell your name properly. All right. Mr. Chenchi, are there preliminary matters in this case, please?
Not from the government.
Any preliminary matters, ma'am? Basically, do you have any? Just not substantive, just preliminary. Yeah.
I'm
No?
sorry. No.
You have okay, you don't have the preliminary matters. Okay. Then this matter is scheduled for show cause hearing on August 16th at 10:30 a.m. What this means that on August 6th, 7 days before the hearing, ma'am, both parties are required to exchange documents and witnesses that they were relying on the hearing. So therefore, based on this case, if you have a defense and you have witnesses who's going to testify or documents that you're going to rely on at the hearing, those documents must be exchanged with the government. Whose case is this? Whose case is this, Mr. Tenchi?
This is Mr. Seller's case.
Mr. Who?
Mr. Seller's case.
Mr. Seller. So the government, the Assistant Attorney General who's assigned to this case, they will send you their documents that they're going to rely on at the hearing.
Mhm.
And you also need to send them a copy of the documents you're going to rely on the hearing 7 days before the hearing. And you also need to send a copy of it to Abra Legal. Any questions, ma'am?
That will all be via email.
Yes, ma'am.
And then that is basically when I get the chance to, like, they send me what their like what I had received previously, which was like the proof of I guess like the accusation, and then in my case when I'm trying to contest it, like the evidence that I have.
Yes, and so you need to make sure that you exchange those documents 7 days before August 16th.
Alrighty.
And so 7 days before, so you count back what is 7 days from August 16th, and 7 days from August 16th is no later than August 9th.
But I can do it
So
before August 9th, yes?
you can
Or-
do it at any point. You can do it today, as
Oh,
long as it's not as long as it's done before 7 days. So you can do it
okay.
today, but as long as it's done at least 7 days before, and you exchange those documents and witnesses, and then on August 16th, we will have a hearing where the government will go first because they have the burden of proving that you committed the violation. And once the government presents its case, then you will have an opportunity to rebut that by having your documents and witnesses to state why is it that you didn't commit the violation.
Yes.
And the board will take the matter under advisement and then will issue a decision within 90 days after the hearing.
Okay.
But if the parties decide to settle this matter prior, the parties can settle this matter through paperwork, in the sense that if they send you a settlement offer and you sign it, and the board will just sign that on our legal calendar. So, but that's just the process. Any questions before I close this case, ma'am?
No, that's all.
Okay. All right. So I will see you then. If this matter is not settled, I will see you then August 16th at 10:30 a.m. Okay. Have a
Thank you.
great day.
Have a
Thank you. And I believe that your day is over with us, sir. You have a great day.
Thank you very much.
All right. The next case on our calendar is case number 23 CMP 00009, Half Smoke, license number 100855. This case has been continued to August 16th at 10:30 a.m. The next case in our calendar, we have a fact-finding hearing, and it's case number 23-251 00013, Aqua Restaurant, license number 60477. Mr. Oriana, can you please elevate the rights of the licensee? I see there's an ABRA investigator, I believe. The Mr. Empress, I believe, is the attorney representing the licensee. You should have Officer Hernandez, Vanessa Plates. I believe those are the folks who should be here to testify.
Sure. Emmanuel Empress, your access has been elevated. Officer Hernandez, your access has been elevated. Investigator Vanessa Plates, your access has been elevated. And John Kim, your access has been elevated. That appears to be all, Chairman.
Thank you. Mr. Kim, do you have a camera you can turn on, please?
Yes, I'll tell you what. I have a
That's-
camera. Let me see.
The camera is not on, sir.
All right. Now it's on.
Yes, I can see you. All right, good morning, everyone. It's a fact-finding hearing. One of the reasons why we have this fact-finding. All right, so let me have the parties identify themselves for the record. Let's start with you, Ms. Plates.
Vanessa Plates, Vanessa, last name Pleitez.
Officer Hernandez, do you have a little bit more lighting? So I can't really see you. It's very dark, sir. But please identify yourself for the record.
Yes, I'm Officer Hernandez with the 5th District. First name is Jose, last name is Hernandez.
Thank you, sir. Mr. Empress, can you please spell and state your name for the record, please? You're on mute, Mr. Empress.
My name is Emmanuel Empress. It's spelled Emanuel. Last name Mpras, representing Aqua.
Good morning, sir.
Good morning.
Mr. Kim, can you please spell and state your name for the record, please?
Yeah, this is John Kim, Jonkim.
What's your relationship to this establishment, sir?
I'm the part of the owner.
Okay, thank you, sir. All right, the background of this case is that MPT requested a fact-finding hearing regarding Aqua Club and Lounge located at 1818 New York Avenue, ABRA license number 060477, related to various incidents. On May 20th, 2023, a male patron was knocked unconscious. During the incident, patrons ejected from the establishment re-entered the establishment and knocked out the male patron and caused a laceration. Now, MPD requested a fact-finding here in this case, so let me set the table for what's going to happen today. This is a fact-finding hearing. The board has not made any determination. We're having a fact-finding hearing because the chief of police requested us that we have a fact-finding hearing. None of the parties this morning will be sworn because this is somewhat of an informal investigation or fact-finding. During a fact-finding hearing, the board cannot order a party to take any specific action. The party, however, can volunteer to take specific actions. And if the party volunteer to take a specific action, then it's binding on the party. But just want to let you know that because this is a fact-finding hearing and we're just gathering facts, the board cannot order the party to take any specific action. At the end of this hearing, the board will more likely take this matter under advisement, and the decision that the board can make is either take no further action, or if the board believes that a violation occur, we would then refer this case over to the Office of Attorney General for them to determine whether or not charges will be filed against the establishment. Any questions by anyone prior to us starting? I think Mr. I don't see our investigator. Ms. Platas has disappeared.
Can you see me
Okay.
now?
Yes, ma'am, I can see you.
Okay.
All right. So basically, what's going to happen is that I'm going to have Ms. Platas basically tell us what occurred. Then I'll have Officer Hernandez provide whatever input that he can provide. I would have some questions to ask Ms. Platas and Officer Hernandez. Once I've asked those questions, the other board members will have an opportunity to ask questions of those two witnesses. Once the board members have asked questions of the witnesses, then Mr. Empress, on behalf of your client, you can ask questions of the witnesses. And once you have asked questions, if your client, on behalf of your client, if you have an opening statement or if you have a defense that you want to present, then you can present that. But as I stated before, the board is just gathering. We are just doing a fact finding, try to gather information based on the request that was made by the chief of police to us to have a fact finding hearing. And just to start, I know that we had a fact finding hearing regarding an incident that occurred at this establishment on May 3rd, 2023 for a stabbing. And I think the respondent at that hearing, the licensee at that hearing, had agreed to retain MPD RDO. So I know that was what was agreed to at our hearing on March 3rd, 2023. And this incident occurred 17 days after. So I don't know whether or not RDO was in place at this time, but I will ask those questions later on. So let's start, Ms. Platas. Can you tell us, what is it that you have to offer regarding this incident, ma'am?
Okay. On Saturday, May 20th, 2023, I was
Can you turn up your
advised.
volume a little bit more, ma'am?
Yes. Is this better?
Yes.
Okay. Okay. So on Saturday, May 20th, 2023, I was advised by supervisory investigator Jason Peru that an incident had taken place at Aqua Restaurant located at 1818 New York Avenue Northeast, which involved a male patron a male patron being knocked unconscious with several lacerations. There was an MPD 251 report generated, CCN number 23027-617, that stated the following. On May 20th, 2023, while working club zone overtime at 1818 New York Avenue Northeast, officers observed patrons running out of the nightclub. At this time, officers proceeded to respond inside of the location. Prior to officers making entry into the location, security on scene stated that they needed an ambulance. Once inside of the nightclub, officers observed V1 unconscious but breathing. Officer Walls attempted to wake V1 and observed a laceration to the top of V1's right eye and his lip. Officers reviewed video footage that showed V1 and S1 exchanging words. Moments later, S1 punched V1 in the face, at which point V1 fell to the ground. While V1 was on the ground, S1 and S2 both kicked and struck V1 in the head repeatedly with a closed fist. No witnesses came forward. On May 20th, 2023, ABCA received a MPD fact-finding request letter from Robert Conti III, Chief of Police, which stated the facts provided in the 251 and added the following. The letter stated, "This is the most recent violent crime that has occurred at Aqua Restaurant. On February 20th, 2023, a victim was stabbed multiple times inside of Aqua Restaurant and transported to a local hospital. Officer Brian Cote, last name spelled COTE, prepared a criminal offense report for an assault with a deadly weapon, CCN number 23027-624. On February 20th, 2023, members of the Metropolitan Police Department 5th District were dispatched to Aqua Restaurant for a victim that was reportedly struck with a glass bottle. A preliminary investigation was conducted and it was determined that an assault occurred inside of Aqua Restaurant. The victim was trying to break up a fight when he was struck in the head by a glass bottle, causing injuries. The suspect then disappeared into the crowd and fled the location. Officer Jose Mejia prepared a criminal offense report for assault with a deadly weapon for the offense, CCN number 23027-617. Based on these incidents, a review of the operations of Aqua Restaurant is warranted to ensure that it is employing all available measures to protect the safety and health of its patrons. So on May 2023, at approximately 10 p.m., I visited Aqua Restaurant and met with the owners of the establishment, Mr. I'm not sure if I'm pronouncing this right, but Wei Zhou and Mr. John Kim.
Can you please, Ms. Platas, can you please spell those names for the record, please?
Yes, Wei Zhou is W-E-I, last name Z-H-O-U, and Mr. John Kim, first name J-O-N-G, last name K-I-M. So that's who I spoke to regarding the incident that took place earlier that morning. Mr. Kim explained that there was an altercation that occurred inside of the establishment that resulted in a male patron being knocked unconscious. Mr. Kim stated that his security staff responded quickly and were able to separate both individuals. However, one of the male patrons involved re-entered the establishment and knocked the other male patron unconscious. Mr. Kim stated that there was a lot of commotion and he was not sure how the male patron got back into the establishment. He stated that after the male suspect exited the establishment a second time, he walked right past MPD officers and got away. Mr. Zoe stated that on the night of the incident, the following security procedures were conducted. There were 14 in-house security personnel. The establishment had 25 cameras with recording capacity of up to 30 days. The establishment conducted identification checks, pat downs, wands, and now they're requiring male and female patrons to remove shoes at the front prior to entering to check their shoes. And then all patrons must be 21 to enter and consume alcoholic beverages. So I did receive surveillance footage on that night. On Wednesday, May 31st, 2023, I reviewed the surveillance footage of the incident and observed the following. I'm not sure if you wanted me to read what I wrote or if you wanted me to
just
play the
summarize
footage.
summarize what you saw, basically.
Okay.
Yeah, please.
So basically, there was a group of 4 individuals that were, I guess, having an argument or like a discussion. Two of the suspects had walked away, and then one of the suspects punched the victim. No, I'm sorry. Okay. So the suspect is seen punching the victim multiple times in the face. The second victim and another one of the suspects were seen trying to intervene and separate them. It looks like one of the victims tripped and fell on the suspect's foot, and once he was on the ground, the suspect started punching him. Security came, they intervened, they separated the individuals. I'm not sure what happened, but one of the suspects came back, picked up his hat, and saw the victim, punched him, and then another individual came. They were punching him and kicking him in the head, and that's when they ran out and they ran past security, past the police officers, and got away. So I attempted to contact the victim telephonically on May 31st, June 1st, and June 6th, but was unable to speak with him. On Tuesday, June 6th, 2023, I contacted Monet Walls, the MPD officer and author of the 251. Ms. Walls stated that on the morning of May 20th, 2023, she was called to respond to an incident that occurred at Aqua Restaurant. Upon her arrival, she was attempting to enter the establishment, but there were so many people running out that it was difficult to enter immediately. Officer Wall stated that when she entered the establishment, V1 was on the ground, non-responsive but breathing, at which time she attempted several protocol techniques to wake V1 up. However, nothing worked. Officer Walls requested medics to transport V1 to the hospital. Officer Walls stated that she did review footage on the night of the incident and the establishment did cooperate. Aqua Restaurant did have RDO on the night of the incident, and the establishment does have a security plan. However, there was no violations of the security plan observed.
That's it?
Yep.
All right, thank you, ma'am. Officer Hernandez, do you have anything you want to add to what was stated by the investigator?
No, not at this time. I mean, I'm literally here just to hear and observe, but there's nothing on our end more than, what the investigator found. So at this point, I'm kind of just here to listen. But if you have any questions for us regarding MPD's involvement and so forth, I'm here. They did have RDO that night. They had 2 individuals assigned to that location. One of them being Officer Walls. So other than that, I mean, I'm not sure what the security protocol was in terms of how many officers were or how many security personnel were inside of the location. But other than that, I really don't have any questions.
So so you're saying they had 2 RDO officers there, is that correct? That's what you're stating?
Yes, that night they had 2 RDO officers working, and they, for the most part, because of where Aqua is located, they are in the parking lot. But again, they're outside, so anything happening inside of the club, if they're not advised of what's happening, then there's not much room for them to do anything. I mean, we see people walk out of these establishments all the time. As soon as they hit the door, they start running towards their cars. And, it kind of alarms you, but at the same time, because it happens so often that it's normal practice for these kids to like run out of the club and just run to their cars. And then you're like, okay, did something happen? And you end up finding out that nothing happened. They just do this because that's, I guess, the exit of a lot of go-go's. But yeah, other than that, I mean, I'm not sure what else the officers could have done outside of just responding inside once they were advised that something had occurred.
Thank you. All right. I don't have any questions for either the officer or the investigator. Go ahead, Mr. Short.
Thank you very much, Mr. Chair. This is for Investigator Playtest. How are you this morning?
Good, thank you.
Okay, you said there were no violations found at all.
Not from the settlement agreement. No.
Do they have a security plan?
I'm sorry. Yes, the security plan. That's what I meant.
What does the security plan say about incidents that occur inside of the club, and how is the club supposed to respond to incidents such as the assault with a deadly weapon?
Give me 1 second. Okay, so procedures for handling violent incidents, other emergencies, and employing the Metropolitan Police Department. Did you want me to read it?
Please do, for the record.
Okay. If any employee of Aqua observes any acts of violence or other emergencies, they shall radio for assistance for another employee/security. Attempt to assist, a manager will be immediately notified, who will determine whether calling MPD or EMS is necessary. A first aid kit will be kept on premise and will be the responsibility of the shift head of security to produce if needed. In these instances, security will physically intercede to prevent or stop a violent individual from physically assaulting another person or themselves or hurting himself. In cases where security must physically force.
That's good. That's good for right now.
Okay,
And thank you very much for reading that onto the record.
thank you.
So, according to your testimony and your report, there was no violation because security was supposed to have contacted MPD, or someone was supposed to have contacted MPD. Did that occur?
Yes. According
Okay.
to the MPD officer and their incident report, they went out and notified the RDO immediately.
But the person was able to run past security and MPD. Is that correct?
Yes.
And then re-enter. Is that correct?
Well, I can't say that the individuals ran completely out, but because of the time frame of the video, it looks like they maybe got to the door and then ran right back inside. There was a lot of people at that moment.
Did anyone notify MPD while you watched the video, or did you get any testimony that someone from the establishment notified MPD?
Yes, you can see them calling MPD over in the cameras.
You calling how, on there with a radio or yelling and screaming? How did
The MPD's officer's car is right in front of the front door of the establishment.
Okay. And the officers were in the car.
Yes, and then a group of, I want to say 8 or 9 police officers were walking up from the street towards the entrance of the establishment at that time.
Had the attack happened at the time you're describing?
Yes.
Okay, if you could do it just frame by frame for me, because I'm having a hard time really understanding. You observed the assault take place, but on the video, is that correct?
Yes.
What immediately happened after the assault took place with the employees or security for this establishment, for Aqua?
Okay. So I could tell you the times. So at 2:48 and 51 seconds a.m., V2 is seen tripping and falling over S2's foot. Once on the ground, S1 is seen punching V2 on the back of the head as he turned around, getting up and running towards the front of the door of the establishment. Security.
Where exactly did that happen? If you can give us a geography of the club, where exactly did the assault take place?
On the main floor.
So the cameras got a pretty good view of it.
Yes.
Okay, watching the cameras then, how long did it take for security to get to where the incident was taking place?
Immediately.
Okay, so what did they do with the person who was assaulting the other person?
Well, there was a lot of people, so they were trying to like have people go outside, so they were escorting most of the people outside.
Had the police department been called at that time?
Yes.
Give us the exact time, since you gave us the exact time of the assault. Give us the exact time of the assault and the exact time the police were called.
Okay. So that happened at 2:49 and 28 seconds.
So you're saying the assault,
MPD,
the
sir?
assault took place at 2:49. Is that correct?
That's when, yes, that's when the suspects were running out. And at 2:50.07,
Excuse me.
MPD is seen
Please
entering
forgive
campus.
me. Please forgive me.
Okay.
Again, I want to know the exact time you saw the assault take place in the club on the floor. What time was that? You said
2:48 and 44 seconds.
okay.
And MPD is seen walking on the scene at 2:50.07 seconds.
No, let's don't involve them yet because they never came inside of the club, correct?
They did.
They came inside of the club.
MPD, they
Yeah.
entered the establishment. Yes.
So the assault happened at 2:44.
2:48.
2:48. What time did the officers come inside of the club?
2:50.
So they were there within 2 seconds.
About a minute and a half.
Okay, I asked you to give me exact times. You said at 2:48 the incident occurred. Then I asked you what time was the police department observed inside or notified?
At 2:50.
So
just 2 minutes.
2 seconds after the assault took place.
No, sorry. No, sir. That's 2 minutes.
I'm not understanding your answers. So
Two
maybe it's my fault. Let me
Hold on, Mick. Do you have? Can you upload your case report? Or do you have, Mr. Oriana? Can you give Ms. Platos an opportunity to upload her case report? Are you able to do that, ma'am? And so you can put it on.
Thank
you
you.
can
Thank
show
you,
him
Mr.
on
Chair.
the screen.
Yeah, that'd
All
be
right.
great.
Access has been granted.
Thank you.
Go ahead, Ms. Platos.
I'm pulling it up now.
Thank you.
Okay. So, the incident occurred here
At 2:48,
in 44 seconds.
4 seconds. Okay.
Okay. And then MPD is seen entering at
Okay, that's great.
2:50.
That's great. Now go back up to when the 2:48 and 44 seconds.
Okay. Right here.
Okay. And then you say the someone is seen tripping someone at that time, correct?
Well, that occurred right here. Yeah. So 2:48:51.
Okay. And it's, hold it right there for a second, please.
Mhm.
All right. Now, it's seen punching V2 on the back of the head, and getting up and to run toward the front door. Security immediately appeared on camera and is seen taking control of the situation. So exactly 2:49, you have more security is seen heading toward the door of the establishment. What security was that?
The establishment security.
So they were inside heading for the front door, correct?
Yes. Yep.
Okay, then the next thing happened was S2 is seen re-entering the camera view and retrieving his hat. Had anyone talked to him, or was anybody around him when he was re-entering and picking up his hat?
Not at that time.
He was there by himself. He just walked back in and picked up his hat, correct?
Yes.
Okay, then let's go to 2:49 and 28 seconds. S2 is grabbing S1 off of V1 and exiting the establishment directly past security. So you saw this on camera.
Yes.
The person who assaulted walked right past security and nobody even said anything to him.
Yes.
So that isn't that a violation of what you read as their security plan? That they're not supposed to let somebody just walk past who's assaulted someone? They took no action. Is that what you're saying?
Well, watching the video, they did attempt.
This is yes or no, investigator Plantes. Did they take any action when the person walked past them after he picked up his hat and was heading back out the door? Did anyone say anything to him or tried to impede him or hold him for the police or do anything?
No.
As you would expect security to do? Yes or no?
No.
So if they didn't, that's a violation of their security plan. Yes or no?
Yes, I assume.
So there was a violation that day, correct? Yes or no?
Yes.
So is it any way possible that you can revise your report? Because apparently let me finish, Mr. Chair. Thank you very much. You stated in the security plan that they're supposed to do something. They did nothing and they let him walk right past them. That's a violation of the security plan. And it's my desire as a board member that the report be updated or revised because there was a violation. And this is not the first time that this establishment has had the same issues. I would like that the record would honestly reflect what you saw, what you did, and what your report, which we just went over, stated happened on that night. Thank you. That's all I have, Mr. Chair. Thank you, investigator.
Ms. Plates, maybe you can clarify the record. I
Yes,
mean, what is it that you
I would
saw,
love to.
and what is it you saw, and
Okay.
what is it that you determined?
Okay. The security plan states that if Aqua employees observe a violent or other emergency, that they should contact MPD, right? And that is exactly what they did.
Close your screen, please, ma'am. Close your screen, ma'am. Close your screen, ma'am, please.
Okay.
I think you have something you want to say, Officer Hernandez.
Yeah, I understand that being the security plan, but security is there to not allow a situation to happen and then say, we're going to not touch anybody, but let's go get MPD, who I get it, we're outside. But in that minute and 20 seconds, 30 seconds, you had an individual that came in, did his thing, assaulted somebody, walked to the door and said, "Oh, you know what? I forgot my hat. Let me go back. Let me grab it." What if in that time frame, had security stopped him and then let us know that he was the suspect in the assault? Then that would have it would have resulted in an arrest, and the individual, would have been caught before he even went back in to assault the person the second time, or even the second individual. So I'm not understanding why their security plan just says hands off, let MPD deal with it. That's not a security plan. That's a let's supervise from up here, which is the same thing that cameras do, right? The cameras just watch and not really do anything outside of just capture the incident. So my question becomes is, how is that a security plan to just notify MPD? Now, what about the times that RDO services aren't available to them? So are assaults happening and they're just letting folks walk out and, let's call MPD, but MPD is, tied up or whatever the case may be, and they're not going to be able to respond for 5-6 minutes or whatever the case may be. Usually it's not that long, but we have a shortage of officers. So with that being said, it's like, what's the plan of action? Is the plan of action just to let folks assault people at the club, at Aqua Club, and just walk out?
Go ahead, Ms. Plates.
Can we maybe watch the video
Yes, Ms.
so that you
Plates.
can
I
get an
think
idea of what's
right. Yes.
okay?
So you can show the video. Go ahead, Matt.
Okay.
Tell us what we're seeing. And which yeah.
Okay, so the incident occurs right here. Do you see where I'm pointing?
Yes, ma'am.
Okay. Okay. So this is these are it's 1, 2, 3, and 4 right here. So right here, they're having a discussion or argument. You see two of the individuals walk away from the argument. Right here. The altercation is going to start shortly. So he punches him. They all start fighting. He falls. He punches him again. This is security right here, escorting them outside. This is security. This is another security personnel.
How can you pick them apart?
I saw them on that night. I saw them when I visited the establishment, and that's how I was able to recognize them.
Okay, but outside of the fact that you've seen them, like for example, like someone like me, right? I'm an officer and I'm looking at this and I'm like looking at the video prior to the altercation occurring, and I see no security visible in the middle of the crowd. I go to other ABC establishments, and other staff are you can see them in the mix, having security like written on the back, like very well like advertised, if you will,
Yeah.
right? That they're security,
That's something the owner could address.
right?
Once
Maybe
they
a change of
testify.
shirt. Yeah, maybe a change of shirt or something, because
Yep.
I'm seeing it and it looks like they're regular patrons at the club.
All right. Well,
And-
can I continue?
Yeah, by all means.
Showing the video. Okay, thank you. Okay, so there he goes. He picks up his hat, and the individual walks right back, and they hit the victim, and he's knocked out. The one person, and there goes security back, and they're going, and it looks like they're attending to the person that's knocked unconscious.
All right, Officer Hernandez, do you have something you want to say, sir?
I'm sorry. I know I said I was just going to sit back and just watch and listen, but in this instance, if you hire security, they're there to do a job, right? And that job is to stop altercations from occurring. And even after they occurred, you let it continue by allowing the person to walk by, and then the second time you let it happen again, where I don't see any type of any type of like movement towards the altercation. They're just nonchalantly walking over like, hey, let's see what's happening over here. So what is the sense of urgency from security staff to stop individuals from being assaulted? In that instance, there was a lot of wrong with the security that was done by them, right? And then on top of that, you say, yeah, they called MPD. They say, hey, MPD, we have an individual that got knocked out. But I'm wondering, was the suspect described to them? You see what I'm saying? So it's like it's easy to say MPD didn't do anything when they ran right by him, and it took them a minute and a half to, get inside the club. But you had an individual that was assaulted inside the establishment, and security did nothing about it. The security plan cannot be to let things happen and then contact MPD. That is not what security is supposed to do in an ABC establishment, especially when an assault is happening in their location.
The only thing I'll say, Officer Hernandez, establishments have security plans. I'm not sure when the security plan was drafted, and they have guidelines what should occur when an incident occurs. And our decision is whether or not they comply with their security plan. I know that you might disagree with the execution of exactly what should occur, but our decision, whatever decision that needs to be made, is to look at the security plan and to see did they comply with their security plan as written. So that's, I know that we might disagree with what the security should or shouldn't do during an incident, but our decision, it can't be whether or not it's, did they comply with their security plan. And that's the only time I believe that the agency can find there's a violation, is that the investigator would go out, look at the incident, review the security plan, and to see whether or not they complied with the terms of their security plan. But maybe at another juncture, if we need to revisit the security plan, then maybe we need to revisit the security plan. But we can't find, at least I don't believe that the board can find a violation because we disagree with them if they're complying with their policies. Go ahead, Ms.
No, that's understandable, sir. The only thing I'm, looking at is terms of the security plan stating that MPD is contacted. Yeah, in that sense, there was no violation because they contacted us, they let us know, hey, an incident occurred, but then we cannot keep putting everything on MPD and saying that MPD did nothing. You can't make that statement when your own security staff did nothing. And if MPD doesn't have all the information to be able to stop an individual and make an arrest, then we can't be after the fact finding out that the person that was assaulted ran past. With that being said, yes, you're absolutely right. There was no violation from their security standpoint.
And I think, hold on, Ms. Clayton, and one of the reasons in having a fact-finding hearing, I think that a lot of what you're saying, Officer Hernandez, is very instructive. The establishment's attorneys here, the owners here. So I'm hoping that they're listening to you to see whether or not they need to make improvements to how they respond to incidents. And I think that's, so when we have fact-finding hearing, it's just to gather facts. And as I said before, for people to hear, and maybe they can revisit, how is it that, how best could they have responded to this incident to ensure that it didn't occur? Because I just in reviewing this incident, and maybe it's because Ms. Plaintiff, because she saw all of the video and she saw the individuals, but I'm looking at the video and she's like saying, this is where the incident occurred. And I just see folks appear that they're just in a club, just doing what people do in a club. So I don't know, just from my perspective, it was, because I'm like, how did you know? But again, it's from the hindsight. I've seen all the videos, seen all the persons. So I'm not making that. I'm just saying, just as a lay person looking at it, I just saw people, at least initially, in my view, just looked like they were just in the club because everyone else. But anyway, that's just my personal view. You want to say something, Ms. Platos?
Yeah, I just wanted to note that their security plan was dated August 2013. That's it.
So that's something that we can revisit whether or not. But again, that's something that can be revisited. All right. Go ahead, Mr. Grandis.
Thank you, Mr. Chairman. Investigator, we really thank you for your report and thank you for being able to respond to the questions we asked you today. Did I hear you state that there were 18 cameras in the establishment?
When I spoke to the owners, they stated that there were 25 cameras.
Oh, 25. And looking at the security plan that is presented today, I think it only states that there were 4 cameras. That
They're
time,
only required to have 4 cameras.
they're only required by
The security plan.
by their security plan, right?
At the time
Which-
that it
which
was
is
written 10 years ago.
2013. Yes. Okay. So if there is 24 cameras, did you determine that the camera that we are looking through was the closest to the incident itself?
Yes.
There were no other cameras in that room?
There's no other cameras on the other side of the room. No.
On the other side of the room. Did we observe in the video that The victim was somewhat tossed across the floor and struck.
Well, he tripped and fell on the ground
Okay.
and then was attacked.
And then was attacked. Okay. From your knowledge of looking at the security plan and the interviews, it seemed that the security staff, some of them saw the suspect who went back in for his hat.
I can't say that for sure.
Did you inquire, did any of the security people, because I think your report said that this suspect walked directly past security.
Yes, you can see it in the video.
Yes. And from your conversations with the security that was present, did you determine whether or not they separated the
Okay.
suspects from the victim?
So I arrived the following. So this occurred at 2 in the morning on the 20th, but I didn't go to the establishment until 10 p.m. that same night to speak. And I spoke with the owners of the establishment, and they provided me with the incident report and the video footage. So my report was based on that. The owners
I thought you said
interview.
something. I thought you said something about them separating the suspects. I may have misheard you. So that was not discussed. If any of the security attempted to escort the suspects either out of the club or away from the victim.
So I based it on the information or the video footage. In the video footage, they look like they're escorting everyone out that was involved in the altercation. Yeah.
From knowing that they escorted out the suspects, should they have held the suspect until the police arrived, which was what, 2 minutes later?
They should have.
And that would not be a violation of the security plan?
No. So the security plan states that they should contact MPD. There's nothing in the security plan that states that they have to hold anyone. I'm strictly going based off of their current security plan.
From your experience going to our licensed establishments, do you ever observe, or have you observed a situation where the security staff held the suspect until the police arrived?
I don't recall.
Okay. Officer Hernandez, from what we've observed and being told that the security staff separated the suspect from the victim, is it your experience that licensees who have these security plans, having observed that there was someone unconscious on the floor, that they would hold that suspect for 2 minutes until the police arrived?
Yes, sir. Other ABC establishments, if they have parties, what they'll do is they'll hold all parties there until we arrive. And again, with RDO, you have them right outside. So had they, like I said, held them, even grabbed all of them, we would have determined who were the aggressors and we would have made proper arrests, and still provided medical attention to the individual that was knocked to the ground at the time before he was knocked out.
Thank you. Investigator, would you say that based on security plans that you have observed that are more recently written, that this security plan should definitely be reviewed, even though we can't, this is a voluntary request here, but that now that we're on notice that the security plan is 10 years old and that there are inconsistencies within the security plan and what you observed because they've updated their security process, do you think the security plan should be made more current?
I do believe it should be updated.
Could you just go over the past incidents that resulted in violations or actions by the ABC board? I think there was a list of things, investigative history. Could you just,
So I actually read the letter that the chief of police, the fact-finding request letter, he included other incidents that occurred at the establishment in February 2023 of
and
this year.
what was that?
February 20th, 2023. There was 2 incidents that occurred at the establishment. One was aggravated assault, and the second one was assault with a deadly weapon.
And that,
And
what month was that?
February 20th,
Mm.
2023.
And from what you can read from the record, did either one of those make it before the board for some type of action?
So, the ADW stabbing, there was a fact finding on May 3rd, 2023, and the board took no further action. But the licensee agreed to a security reimbursable detail.
And was there any other incidents? You said there was something on the 20th and the 23rd.
So, that's the only one that is noted in the investigative history. It just says AWD stabbing, case number 23-251-00009. I do not have that case report. That wasn't my case report, so I don't have that information in front of me. I'm not
Are
sure
you-
if both incidents were included or if it's just one.
Right. Other than being assigned as the investigator on this particular incident, have you been familiar with this particular establishment in the past?
I have not.
Officer, thank you for your testimony. Officer Hernandez, the same question. Are you familiar with this establishment other than in this incident?
I am. I'm the RDO coordinator for the 5th District, so I know Mr. Way. We talk all the time regarding his scheduling and things of that nature. But in terms of them having Part 1 offenses at that location, this is the second one from the first time in October, and before that, we haven't really had a lot of issues at Aqua nightclub. So even with the February 20th incident that occurred till May 20th, I mean, those are the 2 that have occurred in this year and even in probably the past 3 or 4 years, if I'm not mistaken.
And with the
Hold on, Mr. Grant. Mr. Empress, put your hand down, sir. You will get an opportunity once the board is done to ask whatever questions you need to ask, sir. Go ahead, Mr. Grant.
thank you. So the incidents that were recorded were like almost 3 in the morning. So going back to the investigator, just for the record, can you say that what time was their closing on the license for that evening?
On the weekends, it's 3 a.m.
And based on what you observed in the videos, did they take any action to close the establishment at that time, or did they? Do you know if all the patrons left at 3 a.m., which was a few minutes after the incident? So, from your knowledge of either in your investigation or what you've observed on various videos, did they close the establishment at 2 a.m.?
At 3 a.m. So after the
3 a.m.
incident occurred, they escorted everyone out of the establishment, and only MPD, EMS, and the unconscious victim was inside of the establishment, including like their staff. But yes, all patrons or most of the patrons were escorted out.
Most or all? 3 a.m. They're supposed
Well, there was 2 individuals that came back for the victim, so they were still in the establishment. That's why I said most.
Okay, thank you, Mr. Chairman. Thank you very much. I'm done.
All right, Thank you, Mr. Grant. Any other questions by any of the board members? Mr. Empress, can you come back in camera, please, sir?
Yes, sir, I'm here.
You're off camera, sir.
I can see myself.
I can't see you, sir.
Mr. Chairman, I don't know what's wrong. I see myself on the webinar, so my camera's functioning.
Well, when the hearing started, sir, I saw you.
Okay.
And then you disappeared. You raised your hand. I saw that you raised your hand, but when your hand was raised, I did not see you. I just see you. But anyway, just so I'm letting you know, I can't see you. All right. Basically where we are now, sir, I'm going to have some questions for the establishment, but you are free to ask questions of the investigator or of the Officer Hernandez, and then you can let me know whether or not Mr. Kim would have anything to state, because I have some questions I need to ask the establishment.
Sir. May I begin?
Yes, go ahead, sir.
Okay. I would like to start, please, with investigator, is it Plites? Is she still with us?
Mr. Empress, none of us can see you, so that makes it even more problematic. Everyone is on screen with the exception of you.
Let me turn off my video.
But everyone is here. You can ask questions of everyone, but none of us. Yes, now we can see you.
Okay, great. I just stopped and started it. Okay.
Okay, go ahead, sir.
I would like to speak. This is directed at investigator Plites. She's still with us?
Yes.
Yes, Mr. Empress. She is there. Everyone is here, sir.
Great. All right, Officer Plites, when you generated your case report, you included in bold the letter from MPD requesting the fact finding. Is that correct?
Correct.
And what was the date of that letter?
May 20th, 2023.
Okay. And who was the letter from?
Robert Conti III, Chief of Police.
Okay. At that time, just to clarify, Robert Conti was no longer Chief of Police. He resigned April 26th.
Mr. Empress, this is I don't mean to cut you, but this is just it's a fact finding hearing. We're having a fact finding hearing because the Chief of Police at the time, whoever the Chief of Police requested that we have a fact finding hearing. The board made a determination, sir, based on the request that came from the Chief of Police, that we're going to have a hearing. We have had opportunities where the Chief of Police have requested that we have a fact-finding hearing, and the board determined that we're not going to have that. So it's irrelevant who made the request. A request is made to us, sir, and the board independently, based on what occurred, this board determined that we're going to have a fact-finding hearing. So we voted. It was on our public record a while back ago that this board voted that we were going to have a fact-finding hearing, and it was scheduled today. So let's move on, sir.
All right, sir, I understand that. I'm just, I started with that because there are some inconsistencies in the report, inconsistent with the previous fact-finding hearing, where the record and the record thereof. This report goes on to state in page, I just want to clear it up. This report goes on to say that on February 20th, 2023, a victim was stabbed multiple times inside Aqua Restaurant and transported to the hospital. That never happened. It was never inside. And that was attested to by not only by the video that was provided, but by the MPD reimbursable detail and Officer Hernandez, who's present with us now. And then there was also a statement on that page where a victim was struck in the head by a glass bottle causing injury, and we determined that that also never happened. So the report is not entirely accurate, and I'd like to first point out those inconsistencies.
Are you talking about the case? What the board is concerned about is a case report that was done by Investigator Plites.
Yes,
that's the letter. So if you're stating if you're saying that there are incorrect information in her report,
yes,
fine.
sir.
But so I can't a letter. anyone can send a letter to us and they can state about whatever else is going on. But the only thing that really matters to the board, it's what's in a case report. So if you wanted, if you're going by Ms. Platus's case report, and if you're saying that she has incorrect information based on her investigation in our case report, that's fine. But this is not the place where we're going to talk about a letter that was sent to us by MPD to say if there are inconsistencies in that letter. That's irrelevant.
Yes, sir. Understood. Well, I'm moving on. Aside from the rest of the report, I have no issue with. Now, Investigator Plites, when you state that you saw security intervene almost immediately, separate the parties, and move them towards the entrance, is that correct?
Yes.
Now, were you able to see how many persons security was escorting out at one time?
I can't say. It was the entire group that was standing there.
Okay, it was the entire
Like I
okay.
showed the video.
Yes. Aside from, did you see any other footage as to how that S1 suspect was able to re-enter and assault for the second time V1?
No.
Right. And did you have access to all cameras in the establishment when you visited? To the footage?
So the owners of the establishment gave me camera footage for where the incident occurred and 2 angles for the outside of the establishment.
Is that what you requested? If you wanted access to other areas, was it granted to you?
I didn't request the other areas because there was nothing that you could see on the other cameras in reference to this specific incident.
And after this, after us viewing the video footage, you're reviewing your report. What is your conclusion as to any violation of the security agreement? In my opinion, there seems to be none. Would you concur with that as written?
That's what I stated, yes.
Okay, thank you. Okay, thank you very much. And Officer Hernandez, were you working or at the scene that evening?
No, I was not. I had 2 RDOs that were detailed to the club that night. And so, yeah, I had a Lieutenant Sequenta Gaines and Officer Monet Walls.
And did you discuss the events of the evenings with the officers in question that were part of the RDO?
I did. They just advised me that they were told, they were called by security about somebody getting into an altercation inside and somebody was knocked unconscious. They called the board and did a report and called and submitted an ABC violation regarding that incident.
Okay, very good. And Officer Hernandez, based on your knowledge and experience as an MPD officer, does private security have the authority to detain someone, and if so, for how long?
They can in their establishment. It depends on the security protocol in a sense. Anyone can detain an individual for a Part 1 offense or any type of offense, as long as it's safe to do so. You have, I don't know the number of security, but yes, you can detain someone until MPD arrives and they can be so that they can be questioned.
And so you advise that in any future, God forbid, any future happening of this sort, that all parties to an incident be detained so MPD can more or less sort them out?
If it's safe to do so, absolutely. If not, then, I wouldn't suggest, trying to stop somebody that has, a weapon or anything like that.
You'd have to
But
make a subjective determination then.
yeah, it's, if it's safe to do so, I would advise, yeah, if it was an assault that occurred like that, then it's, you separate parties and then you hold parties, especially knowing that MPD is right outside.
Okay. Well, I agree in your assessment that the security plan should be revised and updated. Aside from detaining individuals for MPD, what other recommendations would you have for the establishment?
So the other recommendation that I would have is based off watching what the video is and even going up to the lounge, is not being able to determine who's security and who's not security, right?
Okay.
Maybe a possible like a shirt change or so, where you can clearly pick out who is security, whether they be in a vest or a colored shirt or something,
Okay.
that's highlighted so that you can clearly see them even in a dark establishment.
Thank you. Thank you very much. And I know you can't compare apples to oranges, but you've been working with this establishment for several years and managing the RDO. Compared to other similar type of establishments, so how would you rate their overall performance?
For the most part, outside of these two incidences, they're a non-issue with us. So if I were to give them a rating of between a 1 and 10, I would give them an 8. The only reason why I'm dropping them 2 is, the security plan needs to be updated and these two incidents that have occurred. Now, while I understand that the incident that occurred in February, it wasn't where it occurred inside of the establishment, but it came directly from the establishment. So we have to put those two kind of together and saying that, that did occur. So yeah, that would be my, my opinion on that.
Okay, thank you very much. Investigator Pitez, regarding their investigative history, could you please confirm that your report has the correct investigative history for the establishment on pages 4 and 5 of your report?
That's what was in our records.
Okay, thank you very much. I have no further questions. I'm happy to answer questions from the board.
All right, Mr. Empress.
Yes, sir.
Ms. Playtest testified earlier that the security plan that she had for the establishment was from 2013. Is this the correct security plan that the agency has for this establishment, sir?
Chairman Anderson, I have a copy of that. To my knowledge, I can't answer that question 100%. I would assume it is. That's what the investigator had. But what I'm willing to proffer is that a full revision of the security plan to be done shortly.
The reason why I'm asking you that, sir, I'm looking at the case history for this case.
Yes.
And in case number, the board ordered this establishment in case number 2018-507 to submit a revised security plan and to submit a diagram showing security camera coverage. And that was a board order in 2018. And so if there's a board order in 2018 asking for a revised security plan, that's one of the reasons why I'm asking you whether or not the 2013 security plan, was that, to the best of your knowledge, is this the most updated security plan that this establishment has?
Sir, I'm unprepared to answer that question right now because I can't give you an accurate answer. I would have to check my records and check the ABCA records. But if it was ordered by the board and I was involved, then yes, you would have received an updated version.
And Ms. Plato states that she only has one from 2018. That's one of the reasons, 2013. That's one of the reasons why I'm asking you to confirm what is the most updated security plan that you have, because there are times that establishments have an updated security plan, and for some reason it has not been provided to the board. And I need to speak to our agency, the director. Yes, Ms. Plates, go ahead, ma'am. Want to
Okay.
say something?
Yes, so it looks like there was something submitted in September of 2018 with the 2013 security plan, but attached is the layout where the cameras would be, which is still 4, and aqua non-smoking policy, which is dated September 8, 2018. So it looks like they resubmitted the 2013 security plan and updated the cameras diagram and the non-smoking verbiage. Just FYI.
So
I just found the camera layout here, so I know that was submitted. I had it here on my computer.
no, I hear, but I guess I was chair of, without seeing the board order itself. I do not know specifically what else was asked of this security plan. If all that was, because it says, I know that the violation was that the establishment permitted smoking inside of the establishment, and the offer in compromise was that a warning would have been issued. I submitted a security plan, a revised security plan, that they were supposed to submit a diagram showing the security camera footage. But I don't know, without seeing the board order itself, I'm not sure if there were specifics in the board order requiring more detail in a revised security plan. So what I will ask you, sir, and again, this is an ask, and I think you have already somewhat alluded to it, but would your client agree to provide an updated security plan that is legally compliant within the next 30 days, sir?
Yes, sir, we would.
All right. So what I'll ask is that you provide us an updated, legally compliant security plan that basically lists your security procedures, the camera layout, because I think what Ms. Plato stated is that whatever diagram was provided to us only has 4 cameras, and I was told there's now 25 cameras. Is that correct, Ms. Plato? So I would ask that you provide us within 30 days and a revised, legally compliant security plan with a diagram. No, not. And would you also agree for an investigator to come to look at the facility to look at camera placement to see if recommendations can be provided regarding blind spots?
We would agree to that, and I wanted to let you know that it has already been done. I believe it was Investigator Jones that came and inspected all the cameras and their placements, but
Right.
You can feel free to check that with him.
All right, that's fine. Thank you. All right. So again, this is an ask, and you have agreed that within 30 days you provide the agency with a legally compliant security plan within 30 days. All right. Now,
Sure.
I have some questions that I need to be answered by the establishment, and either if you can answer or if Mr. Kim can answer. I want to be clear. What are the procedures that the establishment follows for permitting patrons to enter? What are the current procedures that are utilized?
I'm sorry. John, are you there?
Yeah.
Okay, I'm here.
Okay. So I'm sorry, Mr. Chairman. Would you repeat your question, please?
What are the procedures for what are the current procedures for permitting patrons to enter?
So I mean, we make them wait in line. We check their ID. We do a pat down. We do a wand. And also mention that they take their shoe off just to make sure there's nothing inside the shoe. And then they come in one at a time.
So you're saying there's one in. Is there a metal detector?
Yeah, we have metal detectors, the wands.
And do you do bag searches?
Yeah, we don't allow big bags. We only allow small purses, and we open it up and we search.
And so you're saying you also ask folks to take their shoes off?
Yeah, and they also just in case they take the shoe up and then we check inside, make sure there's no small objects or anything like that.
So how many security cameras does the establishment have?
Security camera?
Yes.
We have 24.
24 security cameras. And on a typical night, how much security do you have?
That night, we have 16.
16. Is it generally 16 or that night?
Generally 16. It's just our standard.
Now, is there security available in all areas where patrons have access?
Yeah, I mean the same event similar event every night. So we have a standard where they stand that we enough security could see the every space properly.
Now, what type of alcohol is served? You basically serve the gambit of alcohol as most of the establishments are correct?
Yeah, just beers and alcohol. It's the same as any other place.
Or so do you usually provide patrons bottles, glasses, or what type of containers is alcohol served in?
Only plastic cups.
So even beer also?
Yeah, we pour beers on the plastic cups, and we have a sign that says.
All right, now explain to me, because part of the problem that occurred in this case, it's my understanding that the suspect left and re-entered the establishment. So tell me about the procedures that are followed. How is someone allowed to re-enter an your establishment?
Okay, first we have a big deck outside deck, and the parking lot is a private parking lot that no customer could park. Only employees and their guests could park. So our security is pretty much trained. If something happens, just bring out the group that was involved outside to the outside deck where it's bright and where it's away from the crowd. And that's what they were doing. As soon as situation happened, they just grabbed the group that was involved and bringing them out. And unfortunately, they missed that one guy. Somehow I guess he dropped his head and he turned around acting like he was going to pick up his head, and then went over to the victim, hit him, and just was jetted out. But the other group, we were escorting them out to the outside deck, where it's nice and bright, and where the detail office is outside, so they could see them. But it just security missed that one or two guy.
In looking at your case history, it appears that there was violence in 2018, violence in 2020, and now new cases in 23. So what steps can the establishment take to prevent future incidents?
Like was talked about, we will advise the security plan, and also our make an appointment and do a request a security training to be conducted. Normally we do it every 2 years, but I'll make it sooner.
You said you're going to do what, sir?
Security training.
So how long? When is it that? And who provides security? I'm sorry, who provides the training? Yeah, who is your security? How is it? Are these employees? Are these contractors? Who are these
House is employee, but
employees?
but they get trained by I mean, last 3 years ago we had a professional training, and we do that every 2 years.
So when is it that now you're gonna have your security trained, sir?
As soon as possible.
So can you provide us with proof that you have gone that you're
Yes, once it's completed, I guess they'll give us a certification, and I could give it to my attorney, and he'll send it in.
all right? Any questions of the establishment by any of the board members, the licensee by any of the board members? Go ahead, Mr. Short.
Thank you, Mr. Chair. Good afternoon, Mr. Kim. Mr. Kim, I think I was on the board. In fact, I was on the board back in 2013 and 2018. Did you ever remember the suggestion or you agreeing that security personnel would have their own shirts or vests with security written on the back of them? You remember that?
I mean, that was a long time ago, but
I understand. Do you remember that?
I don't remember. But that night, if you look at the security camera too, I know it was kind of dark. Some of them is wearing a security shirt, some of them is not. And I had talked to them because it was coming to a closing time. They decided to put on their jackets, which
Okay,
is
I
covering them from.
understand that, but it might be even more required when you're closing, trying to get everybody out. But do you agree that if they all had the same shirt or vest or jacket on with security written on the back, would make your establishment safer?
Yes, I agree.
You agree to that?
Yes.
Well, hopefully that could be a part of the agreement whenever the investigator comes back out. But I think that you would find that the suggestions that the board is making are not to punish you at all.
I understand.
Most people who follow those instructions that we give or suggestions that we make when they revise their security plans, which should have been revised in 2018, but that's neither here nor there. What we want to do is make sure that you are protecting the public and keeping the public safe while you're in your establishment. Do you realize that someone could have died laying on that floor waiting for your security to bring in MPD and whatever else? That person was unconscious. They could have died. Is that possible?
I mean, look,
Well, let's just say this. I think it was possible. And you would want to have all of your ducks lined up, especially with security, in case somebody decides to sue you when an incident like that happens inside of your club or in your parking lot, because there have been people who have lost a lot of money and licenses because violence became a part of what their business model was. And we would like to think that you're not a part of that. So please pay attention to what we're trying to say to you today. And hopefully we won't be back here again stating we don't know why you didn't submit a revised security plan in 2018 that meets, as our chairman said, the legal requirements. Because all of those things we're talking about, blind spots, security vests, all those things are in the revised security plans for, I would say, 90 to 95% of all the establishments that have the same business model that you have. And their violence has been cut down since they followed those instructions or the board's suggestions. So thankfully, and thank you for being so cooperative today. And hopefully we won't see you anytime soon with
Me
another
too.
incident like this, because February to this month is a bit too close for me as a board member. I'm very, very concerned for you, your business, and all the clients that come in and out of the doors that you're selling alcohol to. What we saw in that video today was very dangerous. very dangerous. Security taking their vest off at closing time or they're getting ready to go home, that's not helping you or helping your business or the people. Because it looked like it was just one big gang inside of the place with the video we saw that I looked at. And so to stop that, have the security persons with appropriately designated with security on their bodies someplace. And they all should be the same.
Okay.
Thank you very much. That's all I have, Mr. Chair.
Thank you, Mr. Short. Any other questions by any of the board members?
Mr. Chairman?
Yes, Mr. Grandis.
Thank you. Mr. Kim, thank you for being here today and answering the questions that we have. Would you, in considering, and this may include your attorney to respond, but in updating the security plan, would you consider that when your security staff has to get involved with any of your patrons in the situation of an altercation, would you consider having them write down the names and contact information of these individuals that they have to ask to leave the club?
I'm gonna let my attorney answer that.
Mr. Grandis, I'll take that. Yeah, there's when possible, there's no issue with that. In fact, I've seen security plans where they say that they will make the attempt, but that information is not generally or freely provided by patrons.
I understand. The request, I understand where you're coming from. You just raised a question earlier about security holding people. You know,
We don't want to exceed our legal authority, sir.
Okay, so I'm saying in the context of a situation like this, trying to get contact information could be all they need to do, as opposed to holding people. So it's just that it seemed from looking at the video that the suspect who came running back in to get the hat and then going back to beat up more on the victim seemed very comfortable going back into this establishment as if maybe he's a known person. But we don't need to go there. It's just that I just think it could be very helpful to an establishment to try to get contact information. That in itself could perhaps negate some incidents in the future. So that's why I asked, could you consider that in looking at language in the security plan?
No, understood, and that's a valid point. And if possible, I don't see why they wouldn't make the attempt. But they can't coerce information out of somebody who's not willing to provide it.
Absolutely. Mr. Kim, are you familiar with the ability of an establishment to seek a stay away order from patrons who have been disruptive or a problem? Are you familiar with that concept?
Yes, I mean, if any situation happen to them, I mean, and we know who they are, we write their information down and we ban them. We don't allow them to come in anymore.
So your establishment has issued stay away orders on.
Luckily, not yet. I mean, that's our policy, but we haven't happened yet.
That's internal, Mr. Grandis. You're talking about barring notice of some type?
Yes.
I'm familiar with it, and I'll educate Mr. Kim with it.
Thank you. Thank you very much. Mr. Chairman, thank you.
Thank you. Any other questions by any of the board members? All right, I'm going to bring this matter to a close. Ms. Platers, any final word that you have, any final comments you want to make, ma'am?
No, Mr. Chairman.
Officer Hernandez, any final comments you want to make, sir?
No, not at this time, sir.
All right, thank you. Mr. Empress, you have the last word, sir.
Mr. Chairman, the establishment fully intends to meet its new obligations to the board as stated during this fact finding regarding the security training and the updated security plan to meet the current legal requirements. And they welcome any constructive criticism and advice as to how to better improve their business model. Thank you.
Thank you. One thing I want to say, and I actually want to thank the establishment because I know that we had a fact-finding hearing. Let me see. We had a fact-finding hearing.
Was it March, maybe?
And yeah, we had a fact-finding hearing on March 3rd, and this incident occurred on May 3rd is when we had a fact-finding hearing. And this incident occurred on May 20th. And your client had agreed at that time to have arguers. So I'm glad that the agreement was made to the board on May 3rd, and that on May 20th, when an incident occurred, there were indeed RDOs at the premises. So I want to thank your client for at least complying with the agreement that was made with the board to do that. So so that is a positive sign.
Thank you.
All right. So what we have agreed, the board will take this matter under advisement, and so we'll issue a decision we'll either take no further action, or we're going to refer this matter to the Office of Attorney General for further action. However, one thing that we have agreed to today is that your client will provide us with a revised, legally compliant security plan within the next 30 days, and that your client will also provide us with a copy of the training that your security staff will undergo. And I'll ask that about when do you believe that your client can provide us that information, sir? I'll have you decide on the time.
Sir, would the board be satisfied if we had both things done within 30 days?
Fine. That within 30 days, you'll provide us with training that with proof that the security has undergone training. Okay?
Yes, sir.
All right, so that's all that we've agreed, and as I said before, the board will take this matter under advisement and will issue our decision. Yeah. Yes, Mr. Short. I cannot hear you, sir.
Thank you, and pardon me. I know we've discussed it. I really think, as our police officer who just testified also, we need to suggest strongly or require that security persons be identifiable at all times if they are open. And I do know, Mr. Chair, since you and I are probably the two longest serving board members, that this is nothing new to you and I, that when we have people identified as security, it cuts down on some of the violence in these clubs. And so I'd just like to ask, could we add that as a part of your request or your agreement with this incident, this recent incident?
Mr. Short, we're happy to add that to the new security plan.
I believe.
Thank you very much. Thank you.
I believe in the legally compliant security plan that the security must be identified. I think that the reason why I didn't ask that, because I believe that under our requirements that the security has to be clearly identified. So if they're going to provide us a legally compliant security plan, I believe that is one of the requirements of a legally compliant security plan. Okay.
Regardless, Chairman Anderson, it'll be there.
All right. Thank you. All right. Thank everyone for their appearance today. Thank you very much, Ms. Plata. Thank you for your appearance, Officer Hernandez, Mr. Kim, and Mr. Empress. Have a great day. Thank you.
You too. Thank you.
Bye then. Bye-bye. All right, we're at the end of our morning's calendar items, and so therefore let me move to our legal agenda. The first matter on our legal agenda is a review of an offer in compromise in lieu of a hearing dated July 18th, 2023, for case number 22251. This is Kiddes Lounge, license number 119361. The offer in compromise is as follows: for charge one, operated outside of approved hours. Statutory authority, DC Code Section 25 762B13 is a fine of $1,250 payable within 30 days, or the license shall be suspended indefinitely until the fine is paid. Charge 2, expanded entertainment without approval, statutory authority, DC Code Section 25762B4. That charge has been dismissed. Charge 3, provide entertainment without the endorsement, statutory authority, DC Code Section 25113.01B1. There's a fine of a written warning. Charge 4, expanded to another floor without approval, substantial change, statutory authority, DC Code Section 25762B3. A written warning will be issued. I make a motion that the offer and compromise be accepted. Is there a second?
Jenny Hansen, a second.
Ms. Henson, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Ms. Grandis and I agree. The matter passed 5-0-0. Number 2, review of a settlement agreement dated May 13th, 2023, bond between Advisory Neighborhood Commission 5C and Aurora Market 2, license number 124890. Make a motion that we approve this agreement. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passed 5-0-0. Number 3, review of a settlement agreement dated June 1st, 2023, bond between Advisory Neighborhood Commission 6D and Makers Union Wharf, license number 124598. I make a motion that we approve this request. Is there a second?
Edward Grandis will second.
Mr. Grandis will second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0-0. Number 5, review of a settlement agreement dated July 10th, 2023, bond between Advisory Neighborhood Commission 6D and Lemani, Limani, license number 124626. I make a motion that we approve this request. Is there a second?
Bobby Cato, second.
Mr. Cato, second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passed 5-0-0. Number 5, review of a settlement agreement dated June 28th, 2023, bond between Advisory Neighborhood Commission 2F, the Shaw DuPont Citizens Alliance, a group of 5 or more, and Aslan Beer Company, license number 118555. I make a motion that we approve this request. Is there a second?
Jenny Hansen,
Bobby Cato, second.
Ms. Henson, Mr. Cato, second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0-0. Number 6, review request to reinstate canceled license dated July 12, 2023. License was canceled April 26, 2023, pursuant to board order number 2023-201. This is for Divines, license number 091199. I make a motion that we approve this request. There a second?
Edward Grandis will second.
Mr. Grandis will second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0-0. Number 7, review of a consent motion for continuance of show cause hearing dated July 18th, 2023, in case number 22 CMP 00030, assets, license number 113585. I make a motion that we grant this motion. Is there a second?
Bobby Cato, second.
Mr. Cato, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Hanson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Number 8, review of request for advisory opinion regarding the ABC Board's authority to issue an alcoholic beverage license at locations where property may use these restrictions. This is an FYI for the board. Number 9, review of the medical cannabis notice of final rulemaking. I make a motion that we approve this rulemaking. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Cato, I agree.
Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. We now move to our licensing agenda. The first matter on our licensing agenda is review application for safekeeping of license. This is for Divine's license number 091199. I make a motion that we approve this request through March 31st, 2024. Is there a second?
Ed Grandis will second.
Mr. Grandis will second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 2, review application for change of hours for Summer Garden. This is for 18th Street Lounge, license number 118846. I make a motion that we placard this matter. Is there a second?
Bobby Cato, seconds.
Mr. Cato, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 5-0. We now move to our medical cannabis licensing agenda. On our medical cannabis license agenda, the first 5 that I'm going to read, I'm going to make a motion that we placard these establishments, and then so I'll make a motion that we placard. So I'll read the first 5. So the first 5. Review of social equity license application for a new medical cannabis cultivation center license. This is at 821 Upshur Street Northwest. City Grow LLC, license number 125479. The second one is review of social equity license application for a new medical cannabis cultivation center. 2627 Evart Street Northeast, Amsterdam. ABCA, ABACA LLC, license number 125446. Number 3, review of a social equity license application for new medical cannabis cultivation center, 300 Vine Street Northwest, WGL Consulting LLC, license number 125471. Number 4, review of a social equity license application for a new medical cannabis manufacturer type 1. This is at 1341 Connecticut Avenue Northwest. So it's DSB LLC. License number is 125461. And the 5th one is a review of a social equity license application for a new medical cannabis manufacturer type 1. Location 2614 28th Street Northeast, Amsterdam's ABCA, ABACY LLC. The license number is 125477. I make a motion that the board placard these the social equity license application. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato. Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Cato. Mr. Anderson, I agree. The matter passed 4-0. We now have conditional social equity applications. This is from number 6 through number 33. I'm going to make a motion that the ABC board issues conditional license to the following applicants: Number 6 is the correction of a June 28th, 2023 approval for license type review of conditional social equity license application for a new medical cannabis manufacturer type 2, Sweet Trees LLC, license number to be determined. Number 7, conditional social license application for a new medical cannabis cultivation center, location to be determined. This is DSB LLC, license number to be determined. Number 8, review of a conditional social equity license application for a new medical cannabis cultivation center, location to be determined. This is for District Access LLC. Number 9, review of a conditional social equity license application for a new medical cannabis manufacturer type 2 license, location to be determined. This is District Access LLC. Number 10, again, another review of a conditional social equity license application for a new medical cannabis manufacturer type 1 license, location to be determined. This is City Grow LLC. Number 11, conditional social equity license application for a new medical cannabis cultivation center, location to be determined, City Grow LLC. Number 12, conditional social equity license application for a new medical cannabis cultivation center, location to be determined, Cutting Edge Cultivation LLC. Number 13, conditional social equity license application for a medical cannabis manufacturer type 1, location to be determined, Cutting Edge Cultivation LLC. Number 14, review of conditional social equity license application for a new medical cannabis cultivation center, location to be determined. This is HLS LLC. Number 15, review of conditional social equity license application for a new medical cannabis cultivation center, location to be determined. This is Webster Street Ventures Corp. Number 16, review of a conditional social equity license application for a new cannabis cultivation center, location to be determined. This is DC Farmhouse Cultivation Center LLC. Number 17, review of conditional social equity license application for a new medical cannabis cultivation center, location to be determined, VERIDIAN LLC. Number 18, review of conditional social equity license application for a new medical cannabis manufacturer type 2, Veridian, VERIDIAN LLC. Number 19, review of conditional social equity application for a new medical cannabis cultivation center, location to be determined, Smooth Enterprises, Inc. Number 20, review of conditional social equity license application for a new medical cannabis manufacturer type 2, location to be determined, Smooth Enterprises, Inc. Number 21, review of conditional social equity license application for a new medical cannabis manufacturer type 1, DINZ, DINEZ, Merano, MERRAO LLC. Number 22, review of conditional social equity license application for a new medical cannabis cultivation center, location to be determined, NTSS DC Corp. Number 23, review of conditional social equity license application for a new medical cannabis manufacturer type 2, location to be determined, NTSS DC Corp. Number 24, review of a conditional social equity license application for a new medical cannabis cultivation center, location to be determined, Wild Lotus Bomb LLC. Number 25, review of a conditional social license application for a new medical cannabis manufacturer type 1, location to be determined, Wild Lotus Bomb LLC. Number 26, review of a conditional social equity license application for a new medical cannabis manufacturer type 2, location to be determined, Optimal DC LLC. Number 27, review of a conditional social equity license application for a new medical cannabis manufacturer type 1, location to be determined, Biz LLC. Number 28, review of conditional social equity license application for a new medical cannabis cultivation center tier 1, location to be determined, True Bloom Cultivation LLC. Number 29, review of a conditional social equity license application for new medical cannabis cultivation center Tier 1, One Stop Wellness LLC. Number 30, review of conditional social equity license application for new medical cannabis manufacturer type 2, location to be determined, One Stop Wellness LLC. Number 31, review of conditional social equity license application for new medical cannabis cultivation center Tier 1, location to be determined, Ward Holdings LLC. Number 32, review of conditional social equity license application for new medical cannabis manufacturer type 1, location to be determined, Ward Holdings LLC. And number 33, review of a conditional social equity license application for new medical cannabis cultivation center Tier 1, location to be determined, District Smoke Spot LLC. I make a motion that ABC Board issue these conditional licenses. These conditional social equity licenses. There a second?
Jenny Hansen will second.
Ms. Henson, a second. The motion will have a roll call vote. Mr. Short.
Mr. Short, I agree.
Cato.
Bobby Cato, I agree.
Ms. Henson.
Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passes 5-0. Now we have the last agenda item on this agenda, which is number 4, which is a 150-point applicant. So review of the conditional license application for a new medical cannabis cultivation center Tier 1, location to be determined. This is for Quality Control LLC. I make a motion that this license be approved. Is there a second?
Ed Grandis.
Mr. Short and Mr. Grandis, a second. The motion will have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato. Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Cato. Mr. Anderson, I agree. The matter passes 4-0. All right, let's now move to the board temporary board temporary license and 1-day substantial change docket. I'm going to read the first 7. I will give the name of the establishment, the applicant, the type of license that's been requested, the date, and the license number, and the attendee. So the first request, and then I'll make a motion that these licenses be granted. These applications be granted. The first request, a request from Emily Grinstead, Grinstead, for a 1-day license class F with the birthday party since July 23rd. The license number is 125414, 60 attendees, 2 security guards. Number 2, a request from Krishan Landers, 1-day license class F, Rockin' at the Ridge, July 21st. The license number is 125400, 100 attendees, 2 security guards. Number 3, a request from Krishan Landers, a 1-day license class F, Rockin' at the Ridge, July 28th. The license number is 125401, 100 attendees, 2 security guards. Number 4, a request from Sophia Proctor, 1-day license class F, wedding reception, August 26th. License number is 125393, 77 attendees, 2 security guards. Number 5, Brightwood Pizza and Bottle, 1-day substantial change, private event. Nature of substantial change to use license off premises at the grand opening of Marketplace Plaza at Walter Reed. This is July 20th. The rain date will be July 21st. License number is 102866. The substantial change license 23SC00887. Number 6, a request from Heurich House Museum, HEURICH, a 1-day substantial change. This is Drafts and Crafts Producers Festival, nature of substantial change. Change user license off premises at Union Market Dock 5. This is on July 22nd. The license number is 100673. The substantial change license is 23SC00915. So I make a motion that ABC Board grants these licenses applications, approve these applications. Is there a second?
Ed Grandis will second.
Mr. Grandis will second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passes 5-0. For number 7, 8, and 9, Ms. Hanson will not participate in the vote on these matters. Then I will make a motion that we grant the applications for a one-day substantial change for this establishment. Now, for number 7, it's Keys. There's a one-day substantial change, a private event. Nature of substantial change use the license off premises at the District Wharf. This is July 23rd. The license number is 105012. The substantial change license is 23 SC 00949. Number 8, another request from East, a one-day substantial change, private event, nature of substantial change, use license off premises at the District Wharf. This is July 30th. The license number is 105012. The substantial change license is 23 SC 00950. And number 9, another request from Keys for one day substantial change. The private event, nature of substantial change, use license off premises at the District Wharf. This is on August 6th. The license number is 105012. The substantial change license is 23 SC 00951. I make a motion that ABC Board grants these licenses. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0.
Mr. Chairman,
Yes, Mr. Grandis.
I apologize, but did we ask Ms. Hanson?
Mr. Grandis. I made an announcement at the beginning of the list that Ms. Hanson will not be participating in this event. Thank you.
Thank you.
We now move on to the licensed administrative docket. On the licensed administrative docket, there are There are 19 applicants. I will make recommendations to the board. I'll make the specific recommendations to the board, what decisions should be made regarding these specific applications. And as stated before, there are 19, and I will give the specific recommendation. And I'm asking that the board approves the recommendations that are being recommended by the chair. The first applicant, it's a request from Salamander, Washington, D.C., license number 122218, their Retail C Hotel, change of hours application. Number 2, Central Michelle Richard, license number 075607, Retail C Restaurant, change of hours application. Number 3, Nando's Peri Peri, license number 122856, Retail C Restaurant, change of hours application. Number 4, Nando's Peri Peri, license number 122856, Retail C Restaurant, carry out and deliver endorsement application. Number 5, Meli Mezi Club, license number 117790, Retail C Restaurant, carry out and deliver endorsement application. Number 6, Breakthrough Beverage, license number 060518, Wholesaler A, Gifts and Loans application, Gift of Shores. Number 7, Breakthrough Beverage, license number 060518, Wholesaler A, Gifts and Loans application, Gift of T-shirts. Number 8, St. Vincent Wine, license number 114428, Retailer C Tavern, stipulated license for entertainment endorsement application. Number 9, Romney's Kitchen, license number 114693, Retailer C Restaurant, letter of request to expand the sidewalk cafe from 18 to 34. Number 10, Philip by Philip, license number 121216, Retailer C Restaurant, carry out and deliver endorsement application. Number 11, 600T, license number 1000515, Retailer C Tavern, corporate name change application. The new name is 600T LLC. Number 12, Right Proper Brewing Company, license number 097516, manufacturer B, class change application. It is now changing from a manufacturer B to a CT Tavern. Number 13, Deja Vu DC Lounge, license number 121029, Retailer C Restaurant, transfer to new location application, 2920 9th Street Northwest. We are referring this matter back to licensing. Number 14, La Chamere, CHAUMIERE, license number 000850, Retailer C Restaurant, stock transfer application. Number 15, Anna Free, ANAFRE, license number 108769, Retailer C Restaurant, stock transfer application. Number 16, Trini Vibes, license number 124738, Retailer C Restaurant, new ABC license application. Number 17, Ahora Market 2, license number 124890, Retailer B Beer and Wine, new ABC license application. Number 18, Balos, BALOS, ESTIATORIO, license number 124717, Retailer C Restaurant, new ABC license application. And number 19, Makers Union Wharf, license number 124598, Retailer C Restaurant, new ABC license application. I make a motion that ABC board approves the recommendation that was made to the board by the board chair. Is there a second?
Bobby Cato second.
Jenny Hansen will
Mr.
second.
Cato and Mr. Cato and Ms. Henson second the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Our last agenda item is the license administrative docket. This is for Street Rate. I make a motion that the ABC board grants the street rate to this applicant, Del Mar, license number 106119. It's a Retailer C Restaurant, and they're requesting a street rate endorsement application. So I make a motion that the endorsement be approved. Is there a second?
Bobby Cato second.
Mr. Cato second the motion. Will now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Cato, I agree.
Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passes 5-0. We're now at the end of our morning calendar and our morning agenda item. And so I will ask all board members, we are gonna go to lunch, and I'll ask all board members to return to executive session at 1:30, and our public agenda will start at 1:45. So all board members should return to executive at 1:30, and we will come back to have our public agenda at 1:45. Have a good lunch. See you in executive session at 1:30. Thank you. Bye-bye. Good afternoon, we're on the record. Good afternoon and welcome to the afternoon session of the ABC board. My name is Donovan Anderson, I'm chairman of the board. I'm joined at the moment by 4 other board members, Mr. James Short, Mr. Bobby Cato, Ms. Jenny Henson, and Mr. Edward Grandis. The board has 5 members in attendance this afternoon, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so the conduct of this hearing is understood by everyone. We have 3 cases on our calendar this afternoon. Once your case is called, I will ask the IT specialist to elevate the rights of each party to enable their camera and microphone, and then will you have the ability to enable your equipment. If you have any questions, please send a message through the chat, and our IT specialist can assist you with any technical concerns that you're having. So let's go to our afternoon calendar. The first case in our afternoon calendar is case number 22-251-00030, assets license number 113585. This case has been continued to September 20th at 10:30 a.m. And jumping out of order, the next case on our calendar is a protest hearing, case number 23-PRO-00037, Boulevard Lounge, license number 115385. This case has been continued to September 13th at 1:30 p.m. And now for the case at hand, case number 23-PRO-00004, Buddies DC, license number 123008. This is a protest license to renew the license. So Mr. Oriana, can you please elevate the rights of the parties in this case?
Sure. Carly Hampton, your access has been elevated. Guillermo Almeida and Jordan Nye, your access has been elevated. Sean Morris, your access has been elevated. And that appears to be all term.
Thank you. Yeah, we're still waiting for the investigator, Vanessa Plates. I believe she's an investigator for this case. Or no, who's the investigator for this case? Oh yeah, there she is.
Oh, it lists Mark Ruiz.
No, it's Miss Plates.
Okay.
And she's elevated. Yeah. All right, good afternoon, everyone. This is a protest hearing to renew a license for Buddies DC. And so let's start with the parties to identify themselves. And let's start with the licensee.
I am Grant Mason.
And I am Dr. Carly Hampton.
And you are, what are
the owners,
the owners of
Buddies
Buddies DC.
DC.
All right, thank you. Mr. Morris, please identify yourself for the record, please.
Good afternoon, Mr. Chairman. Good afternoon, members of the board. Sean Morris of the Morris Law Firm, LLC, appearing as counsel for the applicants.
I apologize, Mr. Morris. I apologize for that, sir. And I didn't know that, so I do apologize. All right. Let me have the abutting property owners spell and state your name for the record, please.
Good afternoon, Mr. Chairman. My name is Guillermo Almeida. It's Guilherme. Last name Almeida.
And I'm Jordan Nye, and my name is spelled Jordan. Last name Nye.
Okay, good afternoon. All right, hold on. Let's see. See. All right, so let me explain to the parties how the process will work this afternoon. So this is a protest hearing, and the way the process will work, we'll have opening statements by the, I'm sorry, let me, you know what, rather than me talking, let me, of course, you'll have opening statements by myself. Then I will ask, are there any motions, preliminary motions by the party? Then the applicant will have an opportunity to give an opening statement. The protestants will also have an opportunity to give an opening statement. After the applicants and the protestants have given an opening statement, we will have our investigator, Ms. Plates. She will go through her case report. Once Ms. Plates presents her case report, the board will ask questions of her case report. So I will ask questions of her about the report. Then the other board members will have an opportunity to ask questions of her regarding the case report. Once the board members have had an opportunity to ask questions of her case report, then you, Mr. Morris, will have an opportunity to question her about the contents of her case report. Once you have questioned her about the contents of her case report, now Mr. Almeida or Mr. Nye, who will be asking questions?
I will.
Okay, so then you will have an opportunity to ask questions of Ms. Plates of her case report. And one of the reasons I'm asking, I'm not going to have two people asking questions. Now, you can decide if one person wants to cross-examine a witness, and then the other person can also cross-examine a different witness, but it has to be consistent. Okay, so it's just one person at a time will ask questions. All right, so after Ms. Plates provides her case report after the protestants has had an opportunity to ask questions, then the board members can ask follow-up questions if the board members want to, because it's our witness. I am not going to allow the parties to ask additional questions once the board has asked questions. All right, so once the board has concluded its presentation, then Mr. Morris, you will have an opportunity to call witnesses and present documents and witnesses that's in the PIP. So you can call your witnesses, and then you will present your case. Once you present your case, once you've called your witnesses, then you, Mr. Nye, you'll have an opportunity to cross-examine that witness. Once you, Mr. Nye, has cross-examined that witness, then the board members will have an opportunity to ask questions of the witness. Once the board members have had an opportunity to ask questions of the witness, then I will give you another opportunity, Mr. Nye, to ask questions of the witness, but the questions you're asking can only be based on the questions that the board members ask. So it cannot be, oh, I'd forgotten to ask a question. If it did not come from one of the questions that the board member had asked, you cannot ask that question. So you will have that opportunity to follow up. And then Mr. Morris, you'll have, because it's your witness, you will have an opportunity to redirect your witness. So once you have presented, after you have presented all your witnesses, Mr. Morris, then the protestant will have an opportunity to call witnesses. And the protestant will call a witness. Once the protestant has done direct examination, then you, Mr. Morris, will have an opportunity to cross-examine the witness. Then the board will have an opportunity to ask questions of the witness. Then you, Mr. Morris, will have an opportunity to ask questions of the witness based on the questions that were asked by the board. And either you, Mr. Almeida, or Mr. Nye, depending who wants to conclude, you will have the last word in asking redirect questions of the witness. So once we do that, so once we have gone through there, we will have closing arguments. The applicant will go first, and for closing arguments, I would like you to be specific what it is that you're asking the board, and then the protestant will have the opportunity to do closing arguments, and the protestant will be specific in telling us what it is that they are requesting from the board. Now, any questions by either party? I'll start with you, Mr. Morris. Any questions you have there?
I don't believe so, Mr. Chairman. Thank you for that explanation.
You're welcome, Mr. Nye, Mr. Almeida. Any questions?
No, thank you.
No. And I need you, Mr. Almeida and Mr. Nye. Maybe I need to turn your volume up because I'm not hearing well. So maybe you can either go get close to the computer or turn your volume up, sir. Okay?
Okay, thank you.
Sure. All right. Now this is a protest hearing. So basically this establishment exists, and so it's to renew their license. Now, are there any agreements? And I'm just trying to find out from the parties if there's a way to shorten this hearing, if there's agreement to say, if the protestants, are they saying to the board that we don't want you to renew the license, or you can renew the license, but we want conditions on the license? And I'm just trying to find out if there's agreement to see whether or not we can truncate the hearing, or whatever it is, we're gonna take testimony. But I'm just trying to find out if as far as the protestants concerned, are they saying we should not renew the license? Are they saying that we should renew the license with conditions?
So we are not trying to deny the applicant a license renewal. We would like to reinforce the existing settlement agreement and essentially present why we feel like they are not operating in accordance with the current settlement agreement.
So could we have an agreement at this juncture to say that the board will renew the license, and then we will have testimony on whether or not, and because irrespective of what decision the board makes, if there's a settlement agreement, the settlement agreement will always remain with the license. So whatever decision that we make today, the settlement agreement will still remain with the license. And so therefore it's a matter of whether or not we will impose additional conditions on the license along with the settlement agreement. So you don't have to agree. I'm just asking. So if the parties agree to say that, well, yes, we agree that the license can be renewed, then the board will renew the license, and then we'll just have arguments. We'll have testimony on whether or not additional conditions need to be placed on the license, and we can take testimony on that, or then we can do a whole hearing and determine whether or not this license either should be renewed. It's basically whatever the party wants us to do. The parties want us to do.
We do feel that there need to be additional conditions added to the settlement agreement to make it more clear. I'm sorry, to the license to make it more clear how we feel they should operate.
All right. So what I will do, and Mr. Morris, I hear that the protestants are saying that they don't have a problem with the renewal of the license. So are the parties then in agreement that the license should be renewed?
Well, I think that's probably a question better for the protestants. Of course, the applicant would like the license to be renewed, with no additional conditions.
Well, that's the argument. Okay, right. There are two issues that the board has to make this afternoon. The first issue is whether or not we're going to renew the license. Okay, that's the first decision that the board has to make. And then the second decision that the board has to make, if the board decides to renew the license based on the presentation that's made today, should the board impose additional conditions, or does the board determine that the conditions on the license are appropriate, so we're not going to impose any additional conditions? So the protestants have stated that we are in support of renewing the license. And so I think, Mr. Morris, your response is that, yes, I'm in agreement that the license should be renewed. That's what I'm trying to hear from you, sir.
Correct. We are in agreement that the license should be renewed.
And that's all that is, and the rest of it. So, okay. So the parties are in agreement that the license will be renewed. So the board will renew the license. We then will spend the hearing to see whether or not any additional conditions should be imposed on the license. So the testimony that you should put on there, Mr. Morris, is that based on the current license that we have, based on the current settlement agreement that we have, we believe that no additional restrictions should be placed on the license. And then for you, Mr. Almeida and Mr. Nye, the arguments will then be that we believe that these are the additional restrictions that should be placed on the license, and the reason. And based on the testimony that you're given, why do you believe additional restrictions should be placed on the license? Okay. Are we clear?
Yes, sir.
All right. Yes. So what I'm going to do, I'm still going to have the investigator go briefly through her report to let us know what it is that she found, and I know that a different investigator was assigned to this case, and Ms. Clayton came in at the last minute, and she did a supplemental report. So that's what we're going to do. So this hearing then should not take the rest of the evening. I'm already packed. I was getting my snacks, because we're going to be here all afternoon. But I'm glad that the parties at least agreed to that portion. So what I'm going to do then, I'll ask you then, Mr. Morris, to give an opening statement. I'll have the protestant to give an opening statement, and then the board, then Ms. Platos will briefly tell me about the establishment from her perspective, and then we can start. So again, this hearing though will be whether or not, as far as the licensee is concerned, that the board should not impose additional conditions, and the protestants will tell us what additional conditions that the board should impose. Okay. Any questions before we start?
I don't think so. Thank you, Mr. Chairman.
All right. So you can give us an opening statement, Mr. Morris.
Thank you, Mr. Chairman. As you know, this matter is before the board on a protest from an abutting property owner regarding the renewal of this applicant's retailer's Class CT license. Neither the ANC nor any group of five has protested or otherwise expressed any concern regarding the renewal of the license. But because this protest has been filed, as you know, the board must determine if the renewal is appropriate, and as we just discussed, whether renewal with any additional conditions is appropriate based on the location and operations of the establishment. The issue most presently before the board, and is one of the factors that the board must consider regarding appropriateness, is whether the establishment will have a negative impact on the peace order and quiet of the surrounding vicinity. That's the grounds on which this protest was filed. And in the context of a renewal, as opposed to a new application, when the board considers that appropriateness and that issue, the board is required to consider the applicant's compliance history, including their compliance with any existing requirements placed on them by an existing settlement agreement. I think when all the evidence is presented to the board, it will show that the applicant has been visited some 20 times by ABCA investigators in the spring and early summer of this year, and no violations have been found, including no violations of its settlement agreement. In violation of any law or regulation related to the sale and service of alcohol, including noise violations since it opened under this new ownership. There have been no substantiated noise complaints during that time, and the applicant has been responsive in all respects to the concerns and complaints of the protestant. The evidence will show that the applicant has been willing to take and has taken steps above and beyond what is required by applicable law and its existing settlement agreement to address concerns and complaints. And I think when all the evidence is heard, especially the investigators' reports, which I think will be very compelling to this board with respect to the compliance history of this applicant and the likelihood, or not even likelihood, the whether it has in fact had any negative impact on the peace, order, and quiet of the community, that it'll be overwhelmingly clear that these applicants are operating their business in a manner that's compliant with District of Columbia law and ABCA regulations. They're operating within the terms of their existing settlement agreement, and that no further conditions are required to ensure the peace, order, and quiet of the community, and that renewing their license without further conditions is the most appropriate course for the board to take. Thank you.
Thank you. Mr. Nab?
Mr. Almeida is going to give you.
Yeah, I will give the opening statement. Thank you, Mr. Chairman. My name is, again, Guillermo Almeida, and my husband and I live at 1106 Lamont Street Northwest.
I apologize. I was, the way your name is written on it's Mr. Almeida and Mr. Nile, and so I thought, all right, so I apologize. So Mr. Almeida, go ahead. All right, I apologize. Go ahead, Mr. Almeida.
Thank you. That's okay. As I mentioned, my husband and I live at 1106 Lamont Street Northwest, which is abutting the applicant's establishment at 3234 11th Street Northwest. My family has lived here in this home for 20 years, and I have lived in the home for the last 12 of those years. We peacefully coexisted with the previous ABCA licensed establishment, room 11, at the applicant's address for more than a decade. And today I'll describe to you the impact the applicant's new business has already negatively had on our right to peace and quiet in our home. And I'll share with you many of the challenges we've faced since the applicant moved into the space at 3234 11th Street Northwest. Though their existing settlement agreement, which can be found in the inspector's report, specifically states that, and I quote, "There shall be no loud or live music performed in the establishment or played or performed on the patio and or sidewalk cafe, and sound emanating from any part of the establishment shall not be audible in residential structures in the vicinity or on the sidewalks across the street from and adjacent to the establishment," end quote. The applicant has installed and utilized outdoor TVs and speakers and has played music from these sources, as well as sources interior to the establishment, with enough volume and intensity of bass that has been heard on many occasions inside our home. These instances are not only in violation of the settlement agreement, as confirmed to me by Mr. Jonathan Bergman of ABCA Legal, but have had a negative effect on peace, order, and quiet in our home, which directly abuts the establishment and are inappropriate as such. We have experienced noise and vibration inside our home as a result of sound emanating from interior and exterior speakers, operation of the summer garden beyond the allowable hours, trash collection outside of allowable hours, and illegal construction, the last of which, while not under the purview of ABCA, have negatively impacted us and speak to the applicant's lack of regard for the rules and regulations that govern individuals and businesses in the District of Columbia. We've had many conversations with the applicant and their counsel, including during an ABCA-required mediation, and they have not addressed our concerns, but rather have pursued avenues to further exacerbate our issues, as evidenced by their recent application for an entertainment endorsement, which was denied as it was explicitly prohibited by their settlement agreement. There is a growing body of evidence in the scientific community that exposure to chronic noise has lasting negative effects throughout the body, increasing the risk of hypertension, stroke, and heart attacks. We have experienced this firsthand since the establishment opened adjacent to our home. We are asking that the board strictly enforce the existing settlement agreement, which is in place to ensure that the applicant runs a business that is appropriate and respectful of the predominantly residential setting it has chosen to open in, so that we may live in our home with peace, order, and quiet. We request that the board hold the applicant accountable to the existing settlement agreement and require the removal of exterior sources of amplified sound, and require that levels for amplified music inside the establishment be at a level that results in no music, noise, or vibrations from the establishment be audible or felt in the abutting neighbor's premises, our home at 1106 Lamont Street Northwest. We request that the board require the applicant to engage a third-party professional acoustical engineer to analyze and incorporate noise mitigation improvements within the premises to ensure that music, noise, and vibrations from the establishment are not audible or felt beyond the curb of the establishment or in any other premises at any time. And finally, we request that the board amend the existing settlement agreement to make us, the abutting property owners, a party to the agreement as well. Thank you, Mr. Chairman.
Well, we're not going to make you a part of the agreement because you're not a part of the agreement. But what the board can do is that we will issue a board order, and the board order will stand the board order will stand along with the settlement agreement. And so the board will order, if we decide to make changes, the board will issue an order to say, these are the terms and conditions, and it's a stronger order than a settlement. But the settlement agreement, as stated before, whatever decision we make today, the settlement agreement will still remain. Okay? All right. Ms. Playtest, that I know that you did a supplementary report, so just tell us who you are, ma'am, and how is it that you became involved in this case?
Hi, investigator Playtez with Vanessa Playtez with ABRA. This case was initially investigator Christopher Condon, who is no longer with the agency. Then it was reassigned to Kevin Puente, who is now no longer with the agency. So I received this protest a few weeks ago or a week ago. So I conducted a supplemental protest investigation for a renewal application for Buddies Inc., trading as Buddies DC, which is located at 3234 11th Street Northwest. Buddies DC is a tavern license, and the application is being protested by an abutting property owners, Mr. Almeida and Mr. Nye. The protest issues for all parties are adverse, or for the parties are adverse impact on peace, order, and quiet and noise from the licensed establishment. On July 7th, 2023, I spoke with Mr. Almeida, who reiterated all of the information that was provided to the former ABCA investigator. Mr. Almeida stated that he and the owners of Buddy have not been able to come to an agreement and that the protest hearing will be moving forward. Mr. Almeida stated that the establishment has speakers located outside of the establishment and he can hear the music inside of his home. Mr. Almeida stated that the establishment has recently installed a jukebox and new speaker system inside of the establishment, and he can feel the vibrations inside of his home. Mr. Almeida stated that the establishment has completed illegal construction and received a stop work order from the Department of Building, DOB, which he will present as evidence. Mr. Almeida stated that employees of the establishment constantly park their vehicles in the bus zones. He also stated that the establishment was getting their trash picked up outside of regular hours and was advised that the establishment was advised by the Advisory Neighborhood Commission, the ANC, that was not allowed. Ms. Almeida did state that since then they have not had any issues with the trash pickup, but would like to note that in the report. Buddies is located in a mixed-use 4 zone. According to the zoning regulations, the purpose of the mixed-use 4 zone are to permit moderate density mixed developments and facilities for shopping and business needs, housing, outside of the center core of Washington, D.C. According to the District of Columbia's GIS, There are 13 licensed ABRA establishments operating within 1,200 feet of Buddy's DC. Out of the 13 ABRA establishments, 5 ABCA establishments, 5 have settlement agreements, 6 have summer gardens, sidewalk cafes, and 5 have summer gardens. According to the District of Columbia GIS system, there are no schools, public libraries, or daycare centers within 400 feet of the establishment. According to investigator Condon's initial protest report, Buddy's DC is made of a white colored brick. There's a sidewalk cafe in front of the establishment on 11th Street Northwest and a summer garden on the side of the establishment that is right at the corner of Lamont Street Northwest and 11th Street Northwest. The summer garden is closed in by a black fence, and the summer garden has 2 TVs and a speaker inside of the summer garden. Summer garden is partially covered by a roof, and he stated that Buddy's DC has a single bar top directly when you walk into the establishment. There's also seating on the side of the establishment away from the bar top. There is also a kitchen behind the bar top. The inside has plant decorations hanging from the ceiling. So Buddy's DC has a carry out and delivery endorsement, sidewalk cafe endorsement, and summer garden endorsement. Buddy's DC current hours of operation are 6 a.m. to 1 a.m. Sunday through Thursday, and 6 a.m. to 2 a.m. Fridays and Saturdays. Buddy's alcoholic beverage sales, service, and consumption are 11 a.m. to 1 a.m. Sunday through Thursday, and 11 a.m. to 2 a.m. Fridays and Saturdays. The establishment was monitored 10 times from March 15th to March 26, 2023 by investigator Condon, and an additional 10 times by ABCA investigators from May 19th to July 1st, 2023. There was no ABCA violations observed during those periods.
Can you go through, you're saying it was monitored 20 times? So I need
Since March.
Since I need you to go through each time that it was monitored and tell us what it is, the day, the time, and what was observed.
Do that. Okay. So it says Wednesday, March 15, 2023, from 4:45 p.m. to 4:55 p.m. No ABRA violations found. ABRA investigator Aaron Peterson monitored the establishment. No noise emanating outside of the establishment were observed. Thursday, March 16, 2023, 8:20 p.m. to 8:35 p.m. Regulatory inspection was conducted. Photographs taken all around the entire establishment. No noise heard out front of the establishment. Patio doors to the side. Summer garden was open. Investigator Conan advised Mr. Mason to close the patio door to the summer garden at 10 p.m. Mr. Mason agreed. No music or TV noise was occurring in the summer garden. The summer garden has 2 TVs and 1 speaker. The sidewalk cafe has no speakers or TVs. The inside of the establishment has 3 TVs and a projector and 4 speakers. 2 speakers are for the jukebox and 2 speakers are for the TV. The kitchen wall is shared with the abutting property owner. The abutting property's first floor is sharing a wall with the establishment. So then it says Thursday, March 16, 2023, 10:51 p.m. to 10:57 p.m. No ABRA violations found, no music, TV, noise observed emanating outside of the establishment. Photographs of the parking signs in the vicinity of the establishment were taken. So then it says Friday, March 17, 2023, 11:10 to 11:20 p.m. No ABRA violations found, no music, TV, noise observed emanating outside of the establishment. Patron voices heard from the Summer Garden. So Saturday, March 18, 2023, 10:33 p.m. to 10:40 p.m. No ABRA violations found. No music, TV noise observed emanating outside of the establishment. Approximately 5 patrons outside on the Summer Garden. The 2 TVs on the Summer Garden were on, but no volume was on. The speakers on the Summer Garden were off. Monday, March 20th, 2023, 11 p.m. to 11:15 p.m. No ABRA violations found. Establishment was closed. Wednesday, March 22nd, 2023, 10 p.m. to 10:20 p.m. No ABRA violations found. Approximately 10 patrons inside of the establishment. No patrons on the Summer Garden or Sidewalk Cafe. No noise emanating from the establishment. Saturday, March 25th, 2023, 12:15 to 12:30 p.m. No ABRA violations found. Parking available. No loitering or loud music observed. ABRA investigator Kevin Pointe monitored. Sunday, March 26, 2023, 12 a.m. to 12:15 a.m. No noise complaint made to the ABRA hotline. ABRA investigator Kevin Pointe responded to the establishment. No ABRA violations found. Sunday, March 26, 2023, 7:41 to 7:55 p.m. No ABRA violations found. Approximately 5 patrons outside on the Summer Garden. No noise observed emanating from the establishment. Friday, May 19, 2023, 10 p.m. to 10:45. No ABRA violations, ABCA violations. No loud noise, no loitering, no parking issues, no trash concerns. Saturday, May 20th, 2023, 11:30 to 11:45. No ABCA violations, no loud noise, no loitering, no parking issues, no trash concerns. On Monday, May 22nd, 2023, 3 p.m. to 3:15. No ABRA violations, no loud noise, no loitering, no parking issues, no trash concerns. Tuesday, May 23rd, 2023, 3:15 p.m. to 3:45 p.m. Again, no ABCA violations, no loud noise, no loitering, no parking issues, no trash concerns. Wednesday, May 24th, 2023, 3:45 p.m. to 4 p.m. No ABCA violations, no loitering, no noise, no parking, and no trash issues. Friday, June 2nd, 2023, 9 p.m. to 9:15 p.m. No ABCA violations found. Saturday, June 3rd, 2023, 10:45 p.m. to 11 p.m. Again, no ABCA violations, no loud noise, no loitering, no parking issues, no trash concerns. Thursday, June 22nd, 2023, 10:55 a.m. to 11:15 a.m. No ABRA violations found. No loud noise, no loitering, no parking issues, no trash issues observed. And then Friday, June 30th, 2023, 11:10 p.m. to 11:50 p.m. No ABRA violations, no loud noise, no loitering, no parking issues, no trash issues observed. And finally, Saturday, July 1st, 2023, 7:15 p.m. to 7:35 p.m. No ABCA violations, no loud noise, no loitering, no parking issues, and no trash issues observed.
Thank you. You can resume.
Okay. So according to the initial protest report, the area surrounding Buddy's DC is serviced by the 52, 54, 59, 63, 64, 70, H2, H4, and H8 buses, routes, and limited residential permit parking from 7 a.m. to 8:30 p.m. on 11th Street Northwest, directly in front of the establishment on both sides, and 11th Street Northwest. The block in front of the establishment on 11th Street Northwest is primarily residential only parking during weekday business hours. The side street on Lamont Street Northwest is limited to residential permit parking from 7 a.m. to 7:30 p.m. Further north on 11th Street Northwest is limited to our parking for non-residential parking. According to the initial protest report, the DC Office of Unified Communications confirmed that there were 5 calls for service between March 15, 2022 and March 21, 2023. As of this day, OUC has not provided an updated calls for service request. So as of right now, there have been 5 calls, like I said, from March 15, 2022 to March 21st, 2023. I conducted an ABCA records check and requested updated information for noise complaints from supervisory investigators and was advised that Buddy's DC has 1 unsubstantiated noise complaint and no ABCA violations since its opening in 2022.
That's it?
Yes.
Let me ask you a question. Are you familiar with, if I'm just looking at the establishment, Johnny's All-American? Are you familiar with that establishment?
I am not, but I do have the license.
I'm just trying to curious what type of, if I see that's on the same block, it's in the 3200 block of 3226 11th Street Northwest. I'm just trying to figure out what type of establishment is that? What type of endorsements, if any, that it's
I
got?
can tell you. You said Johnny's?
Yeah, John is, yeah.
Okay, so Johnny's All-American has carry-out and delivery, holiday extensions, and sidewalk cafe endorsement.
You know what are their hours?
Yes, their hours of operation are 7 a.m. to 2 a.m. Sunday through Saturday, so 7 days a week. And their sales, service, and consumption hours are 9 a.m. to 2 a.m. 7 days a week. Their their sidewalk cafe hours for operation and sales are 10 a.m. to 11 p.m. Sunday through Thursday and 10 a.m. to 12 a.m. Fridays and Saturdays.
Did you tell us, tell me about just the location. Did you tell me what type of zone this was?
Yes, it's a mixed-use 4 zone. Primarily residential, but they do have a few establishments within the 400 feet radius.
Okay.
It's 13 establishments within 1,200 feet of the establishment.
All right. Give me one moment. Any additional questions? I was looking to see if I could find the placard notice to see what it is that was being requested from the
Sorry?
establishment. Now, I said I was looking to see if I found the placard notice to see what was placarded. Do you have that?
I don't. I can try to retrieve it.
No,
You would like me to?
no, that's any other questions by any board members?
Mr. Chairman,
Go ahead, Mr. Grandis.
thank you. Investigator, thank you for a very thorough report, and you've had a long day with us, so we appreciate you staying awake as we have to. So thank you. In the report you submitted, were there any photographs?
So in the initial protest report, there were. My supplemental report did not include any additional photos other than an updated 1,200 feet map because the one that was in the previous report was incorrect. it stated that there was only 4 establishments within 1,200 feet. But it was actually, I don't know what occurred, but the map was actually 400 feet versus the 1,200 feet, so it made the difference.
Yes.
In 1,200 feet, like I said, there's 13 establishments.
So the photographs that you're mentioning are part of the investigative report that was
The
done?
initial,
Yes.
by the initial investigator.
Can you show us those photographs?
Yeah.
Thank you.
Mr. Arena, can you please allow Ms. Fuentes, I'm sorry, Ms. Plates to share her screen?
Access has been granted.
Thank you.
Okay. Can you see it?
Yes.
Yeah. Okay. So this is Exhibit 1. Let me, 1 second. So Exhibit 1 is a copy of the protest letter from the abutting property owner. Exhibit 2 is the copy of the zoning information related to the establishment, mixed use
Yes.
4.
Is the establishment in this photo?
No,
Oh, okay.
no, this is just the zoning.
Okay.
Yeah.
It's a representation. Right.
Yep.
Okay.
This is GIS information related to 1,200 feet, which this is actually 400 feet.
Yeah.
Of the establishment.
So before you move away from that one,
Mhm.
what is that green line pointing to?
This one? It's just telling you that that's where the establishment is located.
So the establishment, okay, and where would the abutting property owners
It would
be?
be right here, this strip.
Okay. Along what street is that?
This is Lamont.
So along Lamont is the abutting property owner's building.
Yeah.
Okay, thank you. You go forward.
Okay. Exhibit 4 is parking signs. Exhibit 5 is parking signs. 6 parking signs. This is Exhibit 7, which is the 400 feet for schools, libraries, daycare centers, public charter schools, which you can see there is none. So, okay, Exhibit 8 says photo of 11th Street facing north. Establishment is located towards the left of the image. See if I can turn it. There you go. So,
Once again, the stop sign is at the corner of 11th and Lamont.
yeah, I think the establishment is here.
Where's your little cursor
Not,
thing?
yeah, it's not in the picture.
Oh, okay. Okay. Thank you.
Yeah. This right here, Exhibit 9, it says photo of 11th Street facing south. Establishment is located towards the right side of the image. So it would be here.
Okay.
But this is further down the block. This right here
Yes.
is Johnny's, I believe.
Okay.
Yep.
Okay. We can go on. Yeah.
Exhibit 10 is photos facing west on Lamont Street Northwest.
Okay, so in this photograph is
It's the
either,
establishment
okay, and where would the abutting building be?
right here.
And there's nothing, what you're saying, that the walls of each building are touching each other. There's no walkway.
Correct.
Okay, thank you.
Okay. This is photos facing east on Lamont Street, which I believe is the opposite, the other side of the street. This right here is photos showing the abutting property that shares the same wall as the establishment. So that's their home.
And where would the establishment be?
Right here.
Okay.
Okay. 13. That's the abutting property house, their home.
Okay.
Okay, let me see. 14 says photos of the summer garden of the establishment on 11th Street Northwest. 15 is photos of the front of the establishment on 11th Street.
And where would Lamont be on that?
It would be on this side,
On the right side?
past the Summer Garden, though.
Yes, yes. Okay.
I mean, yeah, the Summer Garden. Okay, so 16 inside. This is the inside of the establishment, which is kind of dark. 17 is photos of the Summer Garden, which
Okay,
this
so
is Lamont Street right here, and then this would have been 11th.
and where would the abutting property be?
This beside this.
So
on this side.
so that dark area is a wall.
Let me see. It looks like it's a fence here.
Okay.
All right. So this is exhibit 18. This is this trash, where the trash area is, directly beside the Summer Garden.
Does that the trash, does that abut the property owners? Or is that a different area? If you don't know, that's fine.
I'm not sure. I'm not sure.
Okay.
Okay. So exhibit 19. This is the photo of the kitchen. 20. This is the calls for service. Received from OUC. And this is the settlement agreement, exhibit 21.
So let me ask you, and I know you inherited this
Yes.
particular protest. When you went inside, could you on any of the pictures show us where speakers are?
Not in any of the pictures.
Okay, and did you observe any of this? Did you observe speakers inside inside the property?
Well, because of the turnaround of this case, my supplemental case report, I did not go inside of the establishment.
Okay, so okay, and on the outside, on either the Summer Garden or the Sidewalk Cafe, and I believe the Sidewalk Cafe would actually be closer to the abutting property. Is that
The
okay?
Summer Garden.
Yes. Did you notice any speakers in that location?
When I went to the establishment, the Summer Garden was closed. I did not see any speakers, but according to Investigator Condon's report, there are 2 TVs and a speaker. Hold on one second. It says the Summer Garden is closed in by a black fence, and the Summer Garden has 2 TVs and a speaker inside of it.
Okay. So I think you can close this because I like to then turn your attention to the settlement agreement. Can you pull that up? You don't have to show it to me. Can you get to it though for yourself?
Yeah.
Okay. Are you there?
Yes.
Back then it was called voluntary. Okay. I'm looking at number 1, noise suppression. Can you read the first sentence of that for us?
Yes. Noise suppression. There shall be no loud or live music performed in the establishment or played or performed on the patio, Summer Garden, and or Sidewalk Cafe.
Okay,
Sound
thank you.
emanate.
Yeah, no, thank you. So when it says or played or performed on the patio, Summer Garden, and or on Sidewalk Cafe, it would seem like to me that there would be no speakers in those areas.
I'm not sure. What it says is
Played or performed.
no, it says there shall be no loud
Yes,
or live music performed.
perform the patio
It doesn't say anything about played.
where the speakers are. Okay. Okay, so then read the second sentence.
sound emanating from any part of the establishment shall not be audible in residential structures in the vicinity or on the sidewalk across the street from and adjacent to the establishment on 11th and Lamont Street.
Okay, so when the protest was filed in the documents that you received, were there any protests regarding sound in the abutting property? Is that one of the complaints of this
That's-
protest?
Yes, that is what Mr. Almeida stated.
Okay, so in your listing of the 20 visits, I may have missed it, but did any of the visits go to the protestants' property and determine whether sound was being audible in the residential structure?
There was one, give me 1 second. So it says on Sunday, March 26, 2023, 12 midnight to 12:15. It says noise complaint made to ABRA hotline. ABRA investigator Kevin Puente responded to the establishment. No ABRA violations found. In reference to this specific date, I'm not sure if he went inside the home or if he was allowed to go inside the home or not,
Right,
or if he contacted them.
right, but that's not in there. But what it does say, there was no
No
audible
ABRA violation.
ABRA violation when he was inside the establishment.
Correct.
So we really don't have any information from the investigators regarding or not contacting the protestants specifically about noise in their apartment.
Correct.
Okay, thank you. Okay, there's a sentence that starts with applicant will encourage. Can you read that sentence for us, please? It's in the same
Which
paragraph.
is in the same paragraph?
Yes, ma'am. Just lower down.
So applicants will encourage employees and patrons by posting signs or other printed notation to be I'm sorry, it's really blurry. To be considerate of residents in the neighborhood after departing the establishment by keeping conversation and other noises at a level that will not disturb the peace, order, and quiet. And I want to say that word is tranquility.
Yeah.
It's stamped right there.
It's good work. You did it, yes.
Of residents in the enjoyment of their homes or generate a noise complaint.
So did in any of the investigative reports and including your visits, did you see any signs posted such as being requested here?
Like I stated, when I went, the summer garden was closed and I did not enter the establishment, and there's nothing noted from the prior investigators. So I don't feel comfortable answering that question for sure.
You don't know,
I don't know.
but it is part of the voluntary agreement.
Yeah.
Okay, thank you. Mr. Chairman, I have no more questions, and thank you, investigator.
You're welcome.
Any other questions by any of the board member? I hear none. Mr. Morris.
Thank you, Mr. Chairman. Thank you, Investigator Playtez. Just a few questions, some which will be clarifying in nature, if you'll indulge me. You testified that Investigator Condon and other members of ABCA staff visited the establishment over 20 times over the course of several weeks in March of 2023, and then in May and July through July of this year. Is that right?
Correct.
Okay, thank you. Did you at any time conduct any visits to the establishment?
I went to the establishment twice.
Okay, and do you recall what hours of the day those visits were that you went?
Because of the nature of the timing when I received it, I went during the day. I can tell you right now, give me 1 second. So I went on Thursday, June 22nd, 2023 at 10:55 to 11:15. And then the second time I went on, I want to say, no, it wasn't that date. Oh, it was this one. Tuesday, May 23rd, 2023, 3:15 to 3:45 p.m. So
Thank
it
you.
was during the day.
Thank you. I just wanted just to clarify exactly when you were there.
Yeah. So
But
the other visits were for the investigator that had it prior to me, but after the initial person that generated this report, which was Kevin Puente.
okay, thank you. And although you visited during the day, several of the visits made to the establishment, several of those 20 visits were during late night and weekend hours, correct?
Yeah, I want to say that mostly
Okay.
around nighttime.
And at no point in any of those visits, even during late night hours, there were any substantiated claims of loud noise emanating from the summer garden or the establishment itself, right?
Correct.
Okay, and not when these ABCA visits occur, neither the licensee nor its staff is given any advance notice that someone might be coming, are they?
No.
I think you also mentioned that there were 5 calls for service. Are those, when you say a call for service, is that a complaint that comes into ABCA regarding some issue?
No, that's the Office of Unified Communication. So it's basically when they call the police, when the
Okay,
police is called, or when they call 311.
understood. Okay, and would those 5 calls for service been included in these 20 investigative visits?
No,
They have been
because
additional.
the dates on it's Exhibit 20, if you guys want to look at it. The dates are August 8th, 2022, August 26th, 2022, November 7th, 2022, November 19th, 2022, and then January 22nd, 2023. The visits were made in March and in May and July. May and June of 2023. So all these calls were prior to this. But like I said, I requested um updated calls for service, and they have not submitted it to me.
Okay, but those 5 calls for service all predated the protest and
Yes.
were separate and apart from the visits referenced in the protest reports.
Yeah, these were MPD calls.
Okay, and
If
none
you
of
look,
those.
it
Pardon
says
me.
it on
Go
there.
ahead. Sorry, my fault.
It's okay. No, I was just saying, if you look at the exhibit, it says agency and it says MPD.
Okay. And just to clarify, none of those calls for service resulted in a violation of any DC law.
Not that I'm aware of.
Okay. All right. So we're, so in addition to those 20 visits from ABCA staff, there were 5 calls for service to MPD. And with respect to all those visits, there's never been a substantiated noise violation or any ABCA violation at all.
No.
Okay, now, and when the investigative report, when it says that there are no ABCA violation, that would include a violation of the settlement agreement, wouldn't it?
Any ABCA violation.
Okay, so we just talked a little bit about the noise suppression provisions in the settlement agreement. And it says, as you read into the record, that there shall be no loud or live music performed in the establishment or performed on the patio. So presumably, at no point during any of those 20 compliance visits was any loud or live music being played on the summer garden. Is that a fair conclusion?
Well, according to the report, there was no violations found in every visit. So
Okay, thank you. So if there were loud or live music being played on the summer garden, would you agree that that is already embodied in the existing settlement agreement and would lead to a violation?
Correct. Especially because the settlement agreement states that it says sound emanating from any part of the establishment shall not be audible in residential structures or in the vicinity on the sidewalk across the street from and adjacent to the establishment on 11th Street and Lamont Street. So if I were to drive by and I can hear the music across the street, it would be technically a settlement agreement violation. The 2 times that I visited the establishment, the Summer Garden and Sidewalk Cafe were not operating.
Okay, but at other of these 20 visits, it was open and operating and no violation was found. Is that right?
According to the report, correct.
Thank you. If you'll just give me just my indulgence just for a moment. And predating the protests also, I believe, again, point of clarification, since Buddy's began operating, there have been no other violations or substantiated complaints regarding the method and mode of their operations. Is that right?
Correct.
Okay. I don't believe I have any more questions, but if I could just review my notes one moment.
Sure.
Thank you. I don't have any other questions for the investigator.
Mr. Almeida?
Thank you, Mr. Chairman. Would I be able to share my screen to share a video and ask Inspector Playtez a question?
All right. All right. Mr. Oriana, can you allow Mr. Almeida to share his screen, please?
Access has been granted.
Thank you. Okay, where am I? Oh. Okay. So I'll start by asking just a couple questions before I share the video. Inspector Playtez, could you explain to me why there's no mention of my email complaint that I submitted as Exhibit F1 to the complaint email address for ABCA?
Mr. Almeida, well, I think you need to be specific in asking her, what is your Exhibit F1? No record, nothing is in the record, so you have to, in asking a question, be specific what it is that you're asking her about, because no documents have been moved into evidence, okay?
I appreciate that, thank you. Okay, let me open it up. Okay, so Exhibit F1 that I'm showing here on my screen is a chain of emails that has been submitted as an exhibit where there's a complaint on April 3rd that I submitted at 11:39 p.m. showing that the patio was open 49 minutes past the allowable time, and that includes images and also a video from my front porch security camera. And there's no mention of that in the report. Can you explain why that is the case?
Sure. So as an investigator, I rely on the information that was provided to me by the supervisor that is in charge of keeping the record. And that was not included when I requested it. Therefore, I noted what was provided to me.
Okay. I would like to enter this into evidence, if that's possible.
Hold on, Mr. Morris, any objection?
No objection.
So this is exhibit what, sir? What exhibit is this, sir?
F1.
So exhibit F1, so protestants exhibit F1. Has been moved into evidence.
Okay. My next question, I will be sharing an exhibit, Exhibit G, which I submitted, and it is a video of a video that I took from inside my home on April 13th, which was the same day that I filed another complaint and had Inspector Ruiz come into my home, which was the first and only time I was able to get an ABRA inspector inside my house to substantiate a complaint. So I'll be sharing a video of the sound from the patio being heard inside my home. And the question to Inspector Playtest is why that's not mentioned in the report here. How do I do that? Play.
Share that as a screen.
No, I'm sharing the whole screen. Play. That's weird. There we go. And I won't play.
I'm not hearing anything, so I'm not sure what is it that you're asking us.
So you have to turn your volume up to hear, but what's audible in this video, and I shared it with, and I'll replay it, sorry, since I'm talking. I shared it with Inspector Ruiz when he came to my house, is you can hear, in addition to the sound of people's voices, the sound of background music coming from the speakers in Buddy's patio. And I don't understand why there's no mention of this entire interaction I had with Inspector Ruiz, where he confirmed to me that this was a violation, but then nothing shows on any record that that was the case. So I can play it again if you all don't mind turning on.
I mean, did anyone hear? I didn't hear anything, so that's what I'm just. My volume is now at 100. So why didn't you? Because I didn't hear nothing.
Okay. Oh.
Enter that into evidence.
Okay, and I would like to enter that into evidence as well, please. Exhibit G.
Mr. Morris?
No objections.
Without objection. What exhibit is this?
Exhibit G.
Okay.
Inspector Playtests, sorry, I didn't give you a chance to answer the question as to why that was not in the record.
So I guess my first question, can I ask you a question? So did you show him the video, or was the music on and audible in your house when he arrived at your home?
It was both. So he heard it in person, and I showed him the video because at the time that I filed the complaint, the volume was even louder than it was when he came to the house.
Okay.
And he did say that, iPhones are not intended to be recording devices. They tend to suppress background noise. So if I captured it on my iPhone, that it was in fact loud.
Okay. So as an ABRA investigator, I cannot, like, if it was me and I went to your home, I would not be able to substantiate a noise complaint based on the video that you recorded. I would have to witness it myself. And to answer your question, I'm not Investigator Ruiz. I have not spoken to him, so I can't answer that question in reference to why it's not in my report. I checked ABRA records, And as of this time, there's no ABR violations
Mhm.
noted in the history.
Yeah. Okay, I will stop sharing my screen. I have a few questions. Okay. In your visit to the establishment, did you verify if the applicant was complying with their certificate of occupancy, which lists an inside capacity of 37 and exterior capacity of 28? Because there are the business has this outdoor capacity occupancy of 28, yet in the images on page 26 and 28 of the investigator's report, there's at least 10 Ford tops shown in the summer garden for a total of 40 seats, and 2 fire pits with an ambiguous numbers of chairs around them. And in Exhibit H that I submitted in a conversation with the Department of Buildings, they stated that they alerted the Department of Health and ABCA that the business was potentially exceeding their occupancy load, yet there's no mention of this in the report.
I'm sorry, was there a question?
Yes, did you verify that the occupant was complying with their certificate of occupancy?
Like I stated prior in my testimony, when I visited the establishment, the patio in the establishment was closed. So no, I did not verify that information.
Okay. I would like to submit Exhibit H for evidence.
What is Exhibit H?
Exhibit H is a letter from the Department of Buildings that stipulates that ABCA was alerted that the occupant may be exceeding their occupancy load, yet that does not appear anywhere in the report here.
Mr. Morris?
I'm going to object. This is an email that states that someone of that Department of Buildings said they would alert ABCA that this business may be exceeding their occupancy load, but it doesn't provide any evidence that that notification actually occurred.
Okay, that's fine.
All right, so we will, so we're not gonna, so this document will not be, this document will not be a part of the evidence. Okay, let's move on.
Okay, I do want to point out that pages 26 and 28 of the inspector's report do show.
Hold on, Mr. Amita. I thought you said okay. So are you agreeing that it should not be a part of it? I heard you said okay. That's why I made the ruling I did.
My apologies, Mr. Chairman. I'm okay removing Exhibit H for the reasons that Mr. Morris just mentioned, but my question about the occupancy stands.
So you can ask whatever you can ask questions that you want to answer, and you can you ask the investigator a question, and she answered to the best of her ability. So she has answered the question, and Mr. Morris said objected to the document, the documentary evidence. You said that you would withdraw it, and so it has been withdrawn. So that's not a part of the evidence. Okay, go ahead, sir.
Okay. My next question is, there's no mention in your report. Why is there no mention in your report that the occupant's mechanical system in Summer Garden has both a stop work order and a danger sign posted by the Department of Buildings, as indicated by Exhibit C, which I will share. And there's no mention that that is the reason why there's no activity on the Summer Garden, because they are in fact shut down by the Department of Buildings at the Summer Garden. Is there a reason why none of that is in the report?
Yes, those are documents that you did provide to me. However, without me having confirmation from the Department of Building, I was unable to submit that as my evidence because I couldn't verify it.
It is physically posted on the space, so it's something that should have been visible to you when you visited the establishment. So I would like to submit Exhibit C into evidence, please.
And what is? I'm sorry. What is? Can you enlarge that, please, sir?
Yes, Exhibit C is a notice of infraction from the Department of Buildings that stipulates the stop work order and the associated fines for the work that was completed at the property without permits.
Mr. Morris?
I'm going to again object, and I'm going to also interpose a continuing objection over this line of questioning. This is not a Department of Buildings hearing, and whether or not there was an issue with the Department of Buildings issue at any point has nothing to do with the renewal of this license. And I'll also just like to point out that it seems that this line of questioning is more probative of Mr. Almeida's conclusions with regard to ABRA investigators as opposed to the licensee's compliance with its settlement agreement. We have a settlement agreement that we've already talked about here, that everything we're talking about here we've determined would if indeed were substantiated, would have been a violation of the noise suppression provision. We have testimony from the investigator that there have been no substantiated complaints. And my understanding, based on the way the chairman sort of put forth the way this hearing was going to go today, was whether there needed to be an amendment of the settlement agreement, not whether we should be having a discussion of whether in fact in the past this applicant may have violated their settlement agreement. This is not an enforcement hearing. It is a renewal hearing. If there are issues with regard to violations of the settlement agreement, the manner in which that would be conducted is through an enforcement and in a show cause. It is not appropriate for a renewal. And as Mr. Chairman said, the conclusion has already been reached that this license should be renewed. And the only issue before the board is whether additional provisions in the settlement are needed to protect the rights of the protestant. And it seems that everything that we've been talking about here is whether in fact ABRA should have found violations of the settlement agreement in the past. So with that having been said, I'm going to would like to interpose a continuing objection and ask the protestant to limit their questions to issues regarding things that the applicant should do above and beyond what is already in the settlement agreement to protect their rights as an abutting property owner. Thank you, Mr. Chairman.
I agree with Mr. Morris in one sense that if there are violations of a settlement agreement, this is not the proper forum to bring violations. I mean, in the sense that their enforcement actions, and I was myself looking at the settlement agreement, and the settlement agreement does have a provision where the party has an opportunity to attempt the issue, to correct the issue prior to. Ms. Plater has testified that when she went to view, at least the two times that she went to view the property, the settlement agreement, I'm sorry, the summer garden was closed. So I have not heard that there's been any, and Ms. Plater, you did not see the sign when you went to view, the two times you went to see the property, is that correct?
I don't recall seeing anything, but I will say that because the patio was closed and there was no one at the establishment, I did not approach to physically look at what was posted or if it wasn't posted. So it may have been posted, but I do not recall seeing anything.
All right. I'm not going to allow this document to be part of the record. I don't believe it's relevant to the decision that we have to make. So I'm not going to allow this document to move into evidence. Okay. All right. Let's move on. You have any other questions you want to ask?
I do. Okay. Ms. Playtez, Investigator Playtez, sorry. You mentioned that there's 2-hour parking and residential parking in the vicinity were you able to speak with the applicant about where their employees park during their shifts?
That report was generated by a previous investigator. I'd have not, I spoke to the owners of the establishment over the phone initially, but I did not ask them about the parking because it was already included in the previous protest report.
Were you able to physically verify that there is in fact no school within the 400-foot radius shown in Exhibit 7 of your report?
Yeah, like I stated to you when we spoke, our GIS map does not show that there's a school within 400 feet of the establishment.
Um, I would like to share an image that I took from the DCGIS that does show that there is a school, Harriet Tubman Elementary School, within 400 feet of the establishment, if that's okay, Mr. Chair.
But all right, let me ask. All right, hold on. Ms. Platos, can you explain? Tell us about the GIS map that's done. Tell us about that.
So the establishment is centered in the middle of the GIS, and it has to be within 400 feet radius of the establishment. If you were to point or MapQuest, let's say, the direction between the establishment and the school, it may be within 400 feet, but it is not in a 400 feet radius of the establishment. And I can show you the GIS map that was provided to us by the legal department, which is what I presented in my report. Well, who Condon presented in his report.
And after this, Mr. Amida, Harriet Tubman School preceded this establishment.
Correct.
So I guess what you are basically stating is that the ABC board should not have issued a license to, I think, with this establishment Brothers. That's the name of the establishment that they took over from, because I think the settlement agreement, I'm sorry, not Brothers, it's Room 11. Now from 2012. So I'm not gonna allow any testimony on your demarcation of whether or not you disagree with the 400 feet. The 400 feet, the agency has already established, and as going back as 2012, that there is no schools within 400 feet of this establishment. And based on my previous work, I am familiar with Harriet Tubman, and I know that Harriet Tubman, that elementary school, has been in that area prior to 2012. So I'm not gonna. So if our GIS system says that there's not a school within that, based on our demarcation, I'm not gonna have any testimony on your. I'm not going to have you present any evidence on, because you disagree with that, because it's yeah. All right, so let's move on from there.
Mr. Chairman Anderson, the only reason we were pointing that out is because there's obviously a flaw in the investigative report if it's saying that there's not a school within 400 feet. And so what we're trying to point out here is we're asking for the investigator here to point out to us why there is these flaws in the report, and could there be other flaws in the report, and that's why it's relevant.
But Mr. Nod, this is what, all right. This case has gone back 2012, okay, because the settlement agreement that we're talking about goes back to 2012 when the other establishment, Room 11. So in order for Room 11 to have received this license, it was clear that there was not a school within 400 feet of the establishment, because if a school, so what you're saying to us, so I'm not even talking about this case report or this investigation. You're stating that when this license was, when the initial license was issued, at least in 2012, that's based on this settlement that is talking about the settlement agreement that we're talking about today, that this license should not be issued. Because you're saying that, yes, that's what you're saying, sir.
No.
Because all right.
The current report says the same thing that that settlement agreement said. The report should be updated. Report should indicate that there is a school within 400 feet. They are grandfathered in because they were given a license. We're not denying their.
Then it doesn't matter. Then it, well, no.
It does because it shows that the report is flawed.
Mr. Knight. Mr. Knight. All right. If the liquor, all right, this is how we issue liquor license, sir. If the license is there prior to the school, then the license is grandfathered in if it's there before the school. If the school is there, we're not going to grant a license. Okay. So what you're saying, you disagree with our measurement. What I'm saying to you is that the agency has established that there is not a school within 400 feet. And I think what Ms. Plata stated, it depends how it's measured, sir. We have a formula that makes that determination. I think what Ms. Plata has basically stated is that if you were to do a MapQuest, it probably gives you a different interpretation. But how it is that we measure it, that how we measure distance for all cases, this is appropriate. So I'm not going to entertain any more testimony whether or not there is a school within this location. I'm not going to. So let's move on from there because this is not an issue that we're going to discuss today. So let's move on from that issue. And as I said before, we're going back to 2012 when, I'm sorry, and I don't know when this license was issued, but what I have in front of me is a settlement agreement when the parties, and I don't know if this was the first time the license was, let me see. So I'm not sure if this is when if this was the initial license when, or was this a renewal in 2012? But and it's the same argument that I stated to you just, sir. The settlement agreement that you have goes back to 2012. And unless we terminate the settlement agreement, this settlement agreement will continue indefinitely with this license. So this settlement agreement will remain with this license until it's terminated. So all I'm stating is that based on our measurement, there is no school within 400 feet of this establishment. Let's move on from that issue, okay? All right.
Indulgences.
And I just want to correct the record, and I just want to mention one other thing in the record. If there's another establishment that predated the school, so therefore we would have an exception to the rule because there was another liquor license within the 400 feet. So therefore, as we progress, especially with having charter schools in DC today, so you have a lot of charter schools are new in your neighborhoods, and you will have liquor license in these within the 400 feet of the school. However, the reason why a license will be issued is because these liquor licenses were grandfathered in because they existed in the community prior to the school. So whether or not there is a school within 400 feet of this establishment, it is not relevant to our case today. Okay.
We agree. We agree that it's not relevant. Yes. We were just trying to point out the issues in the report.
All right. Any other questions? Any other questions?
Not at this time, Mr. Chairman.
All right, thank you very much. Any questions? I'm sorry. All right, so so both sides have asked questions. Based on the conversations here, any questions by the board members before I move the board rests its case? I hear none. Ms. Plater, thank you very much for your presentation today. You are now free to go. Thank you. All right. What time is it? It is, we started, all right. All right, so Mr. Morris, do you wish to call a witness, sir? And one of the things that I'm gonna do, I'm gonna try to take a break every 2 hours if this matter goes on. So just let everyone know that I'll try to do a scheduled break, maybe a 5 or 10-minute break every 2 hours. This hearing started, I believe, at 10 to 2. So if we're still going on to 10 to 4, which we probably will end up taking a break just to do that. Okay, so I guess I know everyone says people want to go to the bathroom or anything like that. So I'll try to do a break every 2 hours. All right, so Mr. Morris, do you have a witness you wish to call, sir?
Yes, thank you, Mr. Chairman. My first witness I would like to call is Mr. Grant Mason.
Where's Mr. Grant Mason? Okay. Mr. Mason, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
There's a, go ahead. Yeah, there's a delay. All right, but your witness, sir. Okay, go ahead.
Thank you, Mr. Chairman. Thank you, Mr. Mason. Mr. Mason, are you one of the owners of this establishment, Buddies?
Yes, I am.
Can you very briefly describe the concept of Buddies for the board?
Buddies is a neighborhood sports bar. We call ourselves more than a sports bar because we offer different cuisine than normal sports bars would offer, but it's centered around community. It's affectionately named after my father, and I seen this space as being kind of the center block of that 11th Street corridor, which is filled with restaurants and bars. And the concept is about bringing people together. And I think that so far we've done our best at doing that, being very inclusive and very welcoming, and also very considerate of the community in which we're in. And so we've strived to make sure that we could, exist in this space. Can you hear me?
I can, thank you. I can, thank you. And why did you choose this location and neighborhood to open Buddies?
I frequented the neighborhood prior to the pandemic. During the pandemic, a particular establishment closed. So we're looking at over almost 3 years ago at this point. It sat vacant for quite a while. I was able to get in contact with the owner of the property, and I gave him a pitch of what I wanted to do with it. He was very welcoming to it, and it seems as though the neighborhood has been very much so. It's been a place where people really enjoy coming, getting food, getting a drink, communing with each other, and I think that so far, we've met some resistance, obviously. Well, in particular, only these two gentlemen. But we're trying. We're trying really hard to make it in a business that's very difficult, as it already is. But so far, so good. People seem to like it.
And can you explain to the board the importance of the summer garden in particular to your business concept?
The summer garden is really great because we sit on the corner, and it allows a lot of visibility. It's also a place that people really enjoy sitting outside. It's our new world that we live in, and because of where we are, that corner is a big corner in the neighborhood, and it has always been. It's always been a big corner. The previous business used it, and they've had some issue with these same two. Well, Gee as well. So this is not a new thing we're facing. So
Okay. And you mentioned that the reception of the community has been positive.
yes, very much so.
And does that reception include the operation of the outdoor patio in the summer garden?
Yes,
And am I right that you circulated a petition in the community to gauge the community's support for the summer garden and your operations out there?
yes, we did.
Okay, and am I right that approximately 150 people in the neighborhood signed the petition?
Yes.
Yeah, I'm gonna see if I can technologically do this, Mr. Chairman, but if I have the ability to share my screen.
Mr. Oriana, can you please allow Mr. Morris to share his screen?
Some of those guys.
Access has been granted.
Okay, bear with me just a moment. Okay, I don't know if is this visible? If it's not, I apologize.
You have to. We gave you access. Now you have to.
Yeah, and I'm getting a message that it's not allowing me to share it.
Mr. Oriana did. He said that he granted you access, so you should not. Mr. Oriana, can you please check again, please, since he said he's getting it?
Well, if I can't, we'll discuss it via testimony. This is a document that's been marked as an exhibit. It's been submitted to the board. It's been marked as applicant's exhibit 1.
But I think also, as you know, before I'm going to move into evidence, we need to have testimony on the document before.
Understood.
I'm going to object to the testimony on this line of questioning because we've already agreed that the license should be renewed. The petition itself doesn't seem relevant, nor can it be confirmed where these signatures came from, what time period it came from, and so we'd object to this in this line of questioning at this time, and even so, asking that the business be allowed to have loud music would be a petition for that would be in direct violation of the settlement agreement that they have in place.
Mr. Morris, and I had a question myself too. While we're going here, the protestant has agreed to renew the license. And what I want this to be focused on is whether or not there should be additional conditions on the license outside what is in the settlement agreement. So, okay.
That's fine, Mr. Chairman, and as long as the protestants are similarly limited in their questioning.
But I'm saying
I'm fine with that.
But I'm just saying is that okay, the community loves your restaurant, loves the establishment, and that's fine. All they're asking for is additional conditions. Now, if they had not agreed to renew the license, then yes, this line of question would be perfectly fine because you would be showing that they are an outliner in the community. But again, because they are the abutting property owner, they do have stand-in to protest this license. But I think that I get it, but we can move on from this line of question. I think your time is better served with your witness telling us why this is an asset or not an asset to the community, and why is it that they believe that they're complying with the settlement agreement and there should be no additional conditions. I think that's what I want to hear.
Thank you, Mr. Chairman. Just very briefly, and
the long and short of it is that I am going to sustain the objection. So let's move on.
And just very respectfully, Mr. Chairman, I just want to say this testimony with regard to the use of the summer garden is directly probative to the issue of further restrictions to the ability of the applicant to use their summer garden. We do have provisions in the existing settlement agreement that talk about no loud or live music performed in the summer garden. And to the extent that these protestants want to further restrict beyond what is already in the settlement agreement with regard to the use of the summer garden, the importance of the summer garden, both to the applicants and to the service of the community, is probative of that issue. Because if the protestants seek the board to impose much more severe restrictions on the ability of this applicant and licensee to use their summer garden and to be a welcoming place to members of the community who are maybe more comfortable sitting outside and maybe want to enjoy an outdoor summer garden. If that's restricted, then the reception and the interest in the community of using that summer garden to its fullest extent and to its fullest benefit is probative. So that, just respectfully, Your Honor, Mr. Chairman, so you understand what I'm getting at here with the
fine. That's fine. You can ask some minor questions. I mean,
Thank you.
Go ahead, but we don't need to spend half a day with that, sir. Okay.
Okay. And since you opened in November of 2022, is that right?
Yes.
And since you opened, have you received any complaints from any other members of the neighborhood with regard to your use of the summer garden or with respect to noise emanating from the premises?
No, I have not. We also have abutting neighbors on the other side of us as well that connects, just as these abutting neighbors do. And they have taken no issue, nor have they complained of the sound being an issue. In all honesty, we have taken mitigating measures to make sure that the sound could not reach a level that could be, a real nuisance in the community. And I think that is shown why when everyone comes out, we've reduced the sound on the speakers to where they can't even go over a certain level. We've also been in their home to make sure that with a reader, trying to make sure that we're being good neighbors. We've gone out of our way in an effort to make sure of that.
Okay. Do you have any live music in the summer garden? Have you ever had any live music in the summer garden?
We have not. We don't have live music. We're not allowed to. We don't have live music. I mean, people's voices are the loudest things that have ever been on that summer garden. It's never been anything louder than someone's voice. So that's why we don't have any violations.
What about music being played at the summer garden?
Nothing is above. There's no sound emanating that's above anyone's voice. Never. There's nothing that's loud.
Okay, and the interior of the establishment has a jukebox, am I right?
Yes.
And is that jukebox serviced by a third party?
It is serviced by a third party, yes.
And have you worked with that third party to ensure that the volume is kept at a manageable level?
Yes.
Okay, and have you also taken steps to mitigate any bass that might emanate from speakers within the interior of the establishment?
Yes, the speakers are hung. They're hung in the ceiling. There's a wall that separates that the sound needs to get through in order to get to the wall that's on geese. That's abutting. The speakers, the sound, the bass has been removed from the speakers because of the because geese said that they could feel vibrations. So yes.
Okay, and since you've opened, have you ever been cited by either ABCA or any other DC agency regarding noise emanating from the summer garden?
No.
Have you been cited for any noise emanating from the interior of the premises?
No.
Have you been cited for any other noise-related violation?
No.
Have you ever even received a warning?
No.
Thank you. I don't have any other questions for Mr. Mason. I'd like to ask a few questions of Dr. Hampton, if I could next.
No, sir. You'll get a chance later on. So now it's
Thank you.
All right, who's gonna do the cross-examination? Mr. Amelia or Mr. Nile?
I will.
Okay, so Mr. Nile, do you have any questions of Mr.
Yes. So, Mr. Mason, Mr. Hampton, sorry.
Mr. Mason.
Mason, sorry, Mason. I got confused there for a second. Mr. Mason, can you just confirm there is two large flat screen televisions on the property line outside, right?
They are not on the property line. They are on our property, but yes, there are two large TV screens.
And the backs of them face our property, right?
Yes.
Okay. And they're on the summer garden, right?
Yes.
Okay. And in between them, there is a speaker, an extra speaker, that is used to amplify the noise from those TVs, right?
That is correct. There is a speaker there.
And that speaker is what plays the noise for the TVs. The TVs don't play the noise themselves, right?
No, the TVs have sound on them themselves.
Oh, so they play in addition, the TVs have sound and the speaker has sound together.
They do. They can, and they have been played simultaneously while we've been in your home.
Okay. And the speakers for the TVs, which are backwards facing us, those speakers are facing towards us, right? On the TVs?
They're facing down. They don't face backwards, they face down.
Okay. And you're saying there was never an instance that sound got loud enough that we could hear it from our house.
I'm not saying that there was never an instance we stay within 10, 15 feet of each other. I'm certain that if you walk out on your patio or standing at your front door, you could hear noise. Yes.
Was there ever an instance where you could hear the noise from across the street on the sidewalk?
I'm not there 24 hours a day, but there have been things put in place that prevent that from happening. So in the beginning, when we first started, which we're talking about November or December, prior to us coming to your home and doing those things, there may have been a time where something was allowed to get loud, but they were changed so that it would not happen.
Okay. Of course, indulgences while I pull up a video that we've already provided. Okay, go ahead. To share it.
We have to be able to share.
I ask that you watch this video, which was taken on
December 10th.
December 10th of this year, of 2022.
Sometimes a clock isn't just a clock, so it's better to be prepared. Keeping gun lights are already easy to test, and self-test
As you can,
is one with no copay through the health care. With Biomax now, you'll have reliable results in 15 minutes with self-test that uses the same technology.
You'll notice the video was taken across the street from the garden. Is that correct?
yes, that is correct. And as you can clearly see, there is no one out there. There's no sound being playing. It's also
But the TV
early in the
itself, you
day.
can hear the TV,
That
right?
is not-
Objection, Mr. Chairman, I'd like to interpose an objection here. First of all, it has not been established where the noise is coming from. We have a cell phone video that's taken standing on a corner. There's no way to determine where that noise is coming from, first of all. And second of all, the chairman has already limited this to additional restrictions. This is again an effort by Mr. Nye and Mr. Almeida to prove that the settlement agreement that's currently in place was violated. This is not an enforcement hearing. It is, and the hearing here is to determine whether additional provisions are required. If, and we'll just assume arguendo for the purposes of this, if indeed that noise was emanating from the establishment to the extent it was audible across the street, which is not established and is not proven by the video here. If it were, it might be probative of whether there was a violation at that time of the existing settlement agreement. It has no bearing whatsoever on whether additional restrictions are required to be placed on this licensee. So I'd object to this line of questioning. I'd object to any further questioning regarding this video.
All right, I'm looking at the settlement agreement, okay? The settlement agreement says there shall be no loud or live music performed in the establishment or played or performed on the patio, summer garden, or sidewalk cafe. Sound emanating from any part of the establishment shall not be audible in residential structures in the vicinity or in the sidewalks across the street from the adjacent or establishment. And maybe, am I hearing chatter? Is that what I'm hearing? Or am I hearing something else? I mean, if I'm hearing chatter if I'm hearing people sitting on the sidewalk cafe and I'm hearing chatter, and if it's in the middle of the day,
We can play it again.
I'm not sure. So when we talk about sound, I think we're more so talking about entertainment in the sense that you're playing some music or some type of entertainment. I'm not sure that anyone contemplates that if we're talking about neighborhood chatter, that people sitting on a patio. I don't know. So maybe I am confused here because I'm reading the settlement agreement that we're talking about. I think that I guess my interpretation of settlement agreement is that we're talking about music from an entertainment perspective, not chatter.
Mr. Chairman, if I may, this is television. If you listen to it carefully, you'll hear that it is the news and that they're playing television loud enough to obviously an empty patio, as he stated, loud enough that's to be heard across the street. And we'll play it again. But the reason why it is relevant and why it is important is one of the conditions we'd be asking is that they remove these televisions and remove these speakers, which is not in their current settlement agreement. What we're asking for is these are a violation, and what they're asking is that they are be able to keep them, and they're not going to use them, or they're not going to violate as long as ABCA is not there to be able to catch them doing it. We're asking that this is a violation, shows a violation. The speakers themselves are amplified noise that Mr. Mason just said, I can't be there all the time. So our lives are going to be affected by the fact that there's loud televisions with speakers. We're asking as a condition that they not allowed to have speakers on that patio. If it was just chatter, we wouldn't be here. If there's nobody on the patio, we can play it again for Chairman.
Can you please show us a recent video, please?
After this.
And I'm going to again object.
All right, hold on.
I'm going to object to them playing this video again.
Mr. Morris, hold on 1 minute, please. All right. Mr. Mason,
Yes, sir.
you have competent attorney representing you, sir. You can only speak if your attorney asks you a question, sir. You are not allowed to speak if you are not asked a question by your attorney during this time, sir.
Yes.
All right. Mr. Amida and Mr. Nal, only one person can speak, not two, just one. Okay. All right. There was an objection by Mr. Morris.
I'm going to just interpose a continuing objection to showing this video. We don't know when this video was taken. There's no indication of where the noise is emanating from. And again, even assuming for purposes of this discussion, if the noise were emanating from the summer garden of Buddy's, it would be a violation potentially of the current settlement agreement. And there does not need to be any revision or additional restriction above and beyond what is in the existing settlement agreement. And I'm just going to object to Mr. Nye and Mr. Almeida's continuing effort to turn this protest hearing into an enforcement hearing and to turn it into a critique of ABCA's ability to enforce settlement agreements and their ability to undertake proper investigations and to critique their determination of whether a violation of a settlement agreement exists or not. This is a protest of a renewal, and we're talking today about whether additional restrictions in a settlement agreement are required. You have everything that Mr. Almeida and Mr. Nye are presenting to the board. They are potential evidence of a past violation of an existing settlement agreement. They are absolutely not probative whatsoever of whether additional restrictions are required. And therefore, it's frankly a waste of this board's time. If they would like there to be enforcement of a violation, then their method of doing that is to file a complaint with ABCA, for an ABCA investigator to come out to find a violation, and then for there to be issued a show cause order. That is ABCA's providence, not Mr. Nye or Mr. Almeida's. It is ABCA's providence to determine if the existing settlement agreement is being violated or has been violated and to issue a show cause. It is not appropriate to use this board's time in a renewal hearing that the chairman has already said should be limited to whether additional restrictions are necessary, i.e. that the existing settlement agreement does not prohibit the things that they are complaining about, and therefore additional restrictions are needed. Everything that they have presented, whether it be noise within their home, and I'll submit to the board that that video wasn't able to show any evidence of where the noise was coming from either. So I would just ask the board, please, in the interest of the economy of this board and in the interest of respecting what this hearing is today, to limit Mr. Nye and Mr. Almeida's efforts to try to turn this into an enforcement hearing, or to try to turn it into some indictment over whether ABCA can adequately enforce an existing settlement agreement. It's just, it's not suitable and it's not appropriate given the limitation, given the nature of this hearing and the limitations that Mr. Chairman has put on the scope of this hearing.
One of the reasons why I, as chair, always advise parties to settle a matter, it's because at the end of the day, this is your home and this is your business and you have to coexist. And if the parties have settlement agreements, then both parties, there's some give and take, and both parties are happy at the end of the day. But then unfortunately, when the board has to make a decision, whatever decision that's been made by the board, one side is going to be happy or might not be happy, but we're not going to have the same type of relationship at the end of the day. So because it becomes contentious, because we make a decision and we move on, and these parties, they still have to coexist. And so that's one of the reasons why I, as chair, have always supported the parties settling their matters, because at least at the end of the day, they can come to a meeting of the mind. I'm going to sustain the objection. The reason I'm going to sustain the objection is because I don't know where the sound is coming from, sir. It's yes, you have a video. I'm hearing noise from across the street, but I don't know if it's coming from this establishment or where it's coming from. And I think one of the things that, and I think Ms. Plates had also testified earlier, although you might experience noise, and noise, it's not substantiated until the ABRA investigator, and how we normally do it. One investigator is in your apartment and one investigator is in the establishment. And both parties have to agree that the noise that's heard in your apartment is the same noise that's been generated in the establishment. And so although you might be hearing noise, if our investigator cannot come to the apartment, to your house, and substantiate it, then it's not an ABRA violation. So I just want to say that to you. That's how violations are stated. So I know you had stated before that Mr. Reeves came and he heard noise in your apartment, in your house, but it was not established that the noise was coming from their establishment. That's the only way you can, that's the only way. So even if it was, even if the noise was coming from the establishment, unless there's one investigator in the establishment and they both concur that this is the same noise, then there's no violation. So I think, as I said before, I sustain the objection because there's noise, but I don't know where the noise is coming from.
Mm-hmm.
It's not.
I can lay that foundation, Mr. Chairman Anderson.
I'm sorry, sir?
I can lay that foundation through questioning.
No, but what I'm saying though, you can't lay the foundation because do you have testimony to say the same noise that someone within the property recording the same noise that you're hearing from across the street? Because if it's only one-sided, we don't know where this noise is coming from. So that's part of the problem that we're having. So yes, you can provide recordings, but I don't know if this is the same noise that's coming from inside of the establishment, and only an ABRA investigator can substantiate a noise complaint because they have to be there at the time to substantiate that the noise that you're hearing is the exact noise that's coming from the establishment.
Okay.
All right, so let's move on.
Mr. Mason, are there any other televisions on the street in the within 400 feet of your buddies?
Yes,
Where is the television on the street?
there's the television on Johnny's All American has a television
In
right next door to.
In December of 2022, was there ever a television on the street anywhere else?
I can't, I don't know what else was there in December of 22.
Okay. So did you ever notice a television outside anywhere else in December of 22?
I know that we have televisions. I can't speak to anything in December.
Okay.
I know
So
it's
you
there
haven't
now.
noticed one though. To
You
your
said
knowledge,
what?
to your knowledge, there isn't one other than yours in December.
I can't speak to December.
Okay. And
And
to
that mischaracterizes the testimony.
I'm sorry, is there an objection?
Mr. Nye, I believe, is mischaracterizing the testimony. Mr. Mason has testified that in December of 2022, he didn't know either way whether any other televisions. He did not say to his knowledge there were none. So it is a mischaracterization of the testimony.
Mr. Morris, this is cross-examination, and I believe that your hold on, Mr. Mason. When I'm speaking, no one is supposed to speak, okay, sir? You will be able to speak when I'm done speaking, and then if there's an objection, I will make a determination whether or not you should or shouldn't answer, and so therefore please do not speak, okay? But as I stated before, this is cross-examination. I believe that the client, Mr. Mason, you have answered the question, and let's move on. We don't need to be quibbling about it. I think that, okay, so let's move on. All right.
when did you install the speaker outside?
The speaker was installed on December 10th.
Okay. And that's in 2022?
Yes.
Okay. And as you stated before, you've taken mitigating methods to reduce the sound from that speaker and from those televisions. Is that right?
Yes.
Okay. And one of those methods you said was to restrict the sound going out of those devices. Is that right?
Yes.
But as you stated before, you're not always at.
The sounds have been altered so that they cannot go past a max volume. So whether I'm there or not, they cannot be played over a certain volume.
Mm-hmm. And so the types of events that you intend to play over these televisions, they'd be sporting events, right?
Yes.
And sporting events, people are usually pretty rowdy and loud at those events, right?
They can be, but that's not necessarily the case.
And so how would you mitigate people being rowdy and loud looking at two televisions with speakers in order to accommodate the current settlement agreement?
I can't mitigate anyone being rowdy and loud in a conversation that they have with someone else. That has nothing to do with me.
And prior to, did room 11, the prior establishment, did they have televisions out on the patio?
I don't believe so. I don't know what they had on their patio at the time. They've been closed for over 3 years at this point. I have no idea.
Okay, so do you know if they had speakers on their patio?
I have no idea. They've been closed for over 3 years. I don't know what they did or did not have.
And currently, you can't use your summer garden patio, right?
I can use my patio. I can't use a certain area of my patio.
What area can't you use?
Underneath the part that's covered, because the covering itself, underneath the part that's covered.
And why can't you use that? You said you were going to explain. Why can't you use that?
I can't use the part that's covered because we're waiting for a sign off from an inspector.
Okay. And that area that's covered, that has the televisions under it, right?
That is true.
Mhm. And so currently, are you even using those televisions?
Yes.
Okay.
I
And
can't
do you
have
play
any
sound from them?
pictures. You said what now?
Do you play sound from them?
There is sound that emanates from those televisions.
And when you expect to have 40 people on the patio, the sound is going to have to be louder when you reopen it, right?
No, the televisions show what needs to be shown. The sound itself has no indication other than people being quiet to be able to listen to it. If the sound is turned completely up, which we established by coming to your home, you still can't hear it over someone's voice.
So that leads itself to, why do you need the speaker anyway? If you're saying people are going to be too loud to hear the sound of the televisions anyway.
I'm not saying they're going to be too loud. You're saying they're going to be too loud.
Okay, so back to my question. So why do you need the speaker?
The
Why do
speaker,
you need the speaker and the television speakers? Why do you need all of them?
the speaker, the speaker is there for the guests in enjoyment. It's not always sound. It's not always sports playing. There's not always things playing on a television that emanate with the speaker. The speaker is not to be loud, so we made sure that it cannot be loud.
So my question was, if people are being loud and you have 40 patrons on the patio and the speaker is playing and they can't hear the words or the sounds that are being said from it, why do you need the speaker anyway?
If I can't speak to them being loud, that's their choice. If they're loud, I can only put signs up like I have, asking them to be mindful that we have neighbors, and that's it. Their voices, I can't stop people from raising their voices. I can only ask them to be quiet as just like I have and have continued to.
So is it necessary to run your business to have the speaker, to have amplified noise coming out of that speaker on your patio?
It is necessary to run my business, yes.
Why is that?
Because it provides an opportunity for patrons to enjoy the summer garden while listening to news or whatever it is at a very low level. And if it's important to them to hear what's coming from them, then they will police themselves by letting people know to quiet down so that they could hear the things.
So you're saying the patrons will police themselves, that they're gonna be quiet so they can hear the noise?
Yes, I would. I've seen it happen before. If it can only go to a certain volume. If somebody wants to hear something, they'll ask someone to reduce their noise level if it's that loud. But in most cases, very seldom, if ever, it is that loud. It may have happened where someone's voice is loud. I can't speak to it never happening, but it's not anything that we're disseminating.
Has Mr. Almeida, my husband, contacted you in the past telling you that the speaker is too loud and that we can hear it inside our house?
Yes, he has contacted me.
Okay. And do you remember how many times that's happened?
It's been several times. One key time and why we're gotten to this place is because he sent me a message saying that it was beating like a club, in which the ABCA investigator walked in there maybe 10 minutes later and said, I can't hear anything coming from here until I get inside. To which he messaged me again after that, complaining again while the investigator was still in the space.
Do you know if that
At that time, I figured out that
Hold on.
no way I could compromise.
Mr. Nile, please give him an opportunity.
Yes, at that time, I realized that no matter how low I play my music or how low it is, you guys were always going to find something. So that's why we're here, because we're the quietest people in the corridor. Yet we're the only ones that have to deal with this. So go
So
ahead.
do you know if that inspector ever came into our house and listened to our levels of what's going on in our house? Do you know if that happened?
I don't know who has been in your house, but you said that there has been an investigator in your house, and there's been an investigator in my place. And still, they don't think that the level at which we're playing is an issue. And that's why we came in your house in the first place, to try to make sure that we could keep it at a level. But that has not worked, amongst other things. And go
So,
ahead.
but you've also sought an entertainment license, is that right?
Yes, we have.
And what kind of entertainment do you want to seek? Were you seeking?
We would like to be able to do trivia nights. We'd be able to do karaoke. We'd be able to do comedy shows. There are a bevy of things that fall under the entertainment license that we need an endorsement to do. And we were under the impression that we would be able to get those things because they don't require the music to be loud or live, not music. And so, Mike, we should be able to do those things, but we are informed that we could not get those without an entertainment endorsement. So we applied for one.
Isn't it true at one point you said you wanted to get a DJ inside your space?
We would love to be able to have a DJ in our space at some point in time on a Friday or Saturday night, occasionally. Yes, we would like that.
So currently,
We don't.
the jukebox system that you installed in your space, isn't it true that Mr. Almeida, my husband, reported to you that that system creates vibrations that we can feel in our house? Isn't that true?
Yes, he reported it, and I immediately called the company and had them reduce and take the bass completely out of it immediately.
And
So,
so don't you think
which is
a
part of our
DJ?
settlement agreement, right? If you
I'm sorry,
call
finish
us,
your statement. Finish
no,
your
I was
statement.
saying, which is part of the current settlement agreement. If you call us, we have something like 30 days to a minute, and I've done things within 24, 36 hours. You guys text me, I do the best I can to make sure that it doesn't happen again.
Hasn't Mr. Almeida provided you resources to get sound mitigation between the two properties?
He has sent some things over to me. I have taken the steps that I have taken so far, and those steps have come into a place where we have no issue from anyone other than you guys about noise, and we have neighbors that we ask that live on the side of us that are closer to the sound than you are, and they don't have a problem with it.
So, have you ever reached out to someone to mitigate the sound in between the two properties?
Yes.
Who did you reach out to?
I reached out to the people who put the speakers up in the first place to make sure that the sound did not carry. And the practices in which you use to make sure they don't is how the speakers were hung so that it would not. So I don't know what else I can do at this point.
Did they do anything to the speakers after you reached out to them?
Yes.
What did they do?
I can't speak to the things, but I know that whatever has been done it has generated no noise complaints for us.
The system itself, it plays loud music, right?
It plays music.
It plays music
I don't
that's
deem it to be
loud
loud.
enough that people can dance to it, right?
No, people don't really. I can't say that they. I mean, maybe they can dance to it. Depending on considering the speakers are 5 feet from them, yes, they can hear them.
And people pick the songs that they want to play, and they can play any type of music. Is that right on that system?
This is true.
Okay. So they can play music that produces a really heavy bass on that system.
There's no bass in the speakers. So I mean, like I said, I don't know what else to do.
And you make revenue off of that system, don't you?
I do make revenue off that system. It's a very minimal amount. It is more for the guest pleasure than it is for revenue.
Isn't it true that at one point when we asked you about the system, that you stated that you needed the system to make revenue and that it was more important for you to make revenue than to take out the system? Is that true?
No, that's not true.
So other than asking the company that installed the system to fix the system, what other remedial methods have you taken to reduce the sound and vibration between the two properties?
That is it.
Okay. Would you be willing to reach out to other experts to do that?
Yes,
Without a noise
if I had someone other than you guys complaining about noise, yes, I would. I definitely would. But you guys started complaining about noise when the TVs went up before there was anything. So at this point, it's kind of tough for me to believe what I hear from you in regards to noise.
Okay. So one of the things that we're asking for is a condition that you have to seek out methods to reduce the sound in between. And what you're saying to me right now is that you're not willing to do that.
I'm not saying that. I'm saying that I've already done that several times over, and that's why I don't have any noise violations.
So
Because
one of the,
I am the quietest person in that corridor.
so you're not quite answering my question, which is that if there were additional conditions, would you follow them? Would you, if there was a condition that you would have
No,
to,
if there were additional conditions, I would definitely follow them. Just like I've tried to make sure that I followed everything.
okay, just like you followed all the conditions of your settlement agreement, right?
Yes.
Okay. Indulgences. Isn't it true that you recognized there was a sound issue and that you and Carly or Dr. Hampton came to our home in an effort of trying to reduce the sound? Isn't that right?
We know that we know that you made us aware that you felt like there was an issue, and so we made sure that we came over directly to you to address it with you.
And the two of us, the four of us, we tried to decibel read and make readings of those sound levels. Is that right?
Yes, we have.
And are you aware that the decibel reading in the video that you submitted, as taken from our front porch, was indicating that that you were at the very time in violation of the DC noise ordinance 2701?
I'm going to again object, Mr. Chairman, to lines of questioning that are intended to establish that there has been a past violation. Mr. Chairman has already said the questioning should be limited to additional conditions that need to be put into the settlement agreement to address the protestants' concerns. It is not a hearing on whether there was a previous violation.
Mr. Chairman, if I may respond briefly,
Right.
the reason why this is important is they, as noted, they have a settlement agreement, and as noted, they have we're addressing the fact that there are violations to that. We're not enforcing those violations. Obviously, those are not in the ABCA investigation. But what we're showing here is that there is a blatant disregard for the current settlement agreement, which is why additional conditions are absolutely necessary on their licensing agreement. We need something here that is enforceable, that is beyond what the settlement agreement says, because it's so blatant that there was TVs that were solved, noise that's elevated above allowed, and we also don't have an investigative report that shows that what happened inside our home. So without those facts, we have to show that there are constant violations going on, that there's a disregard. Additionally, if you look at the disregard of why their patio is currently shut down, there's a disregard of rules and regulations overall repeatedly. They're not using a permit, having a business that they're not going to follow the rules here consistently. It shows that there's a pattern here. And the reason why we have to show that this pattern exists is so that the board can make a correct determination that these conditions are absolutely necessary for this liquor license. We obviously want this business to strive and do well. We want this business, there's been a business there for years. This is a totally different type of business than what's been in this community and neighborhood. This is a mixed-use neighborhood, as I said, with residences on both sides. And what we're dealing with here is a situation where somebody moved into a space that was a bar and installed speakers, installed television screens, cranked up the volume, and now wants to have a DJ and have a party and turn it into what is essentially a club. And so what we're pointing out here is that that shouldn't be allowed. and that the edging here of doing the things that they want to do is what is concerning to us and why the board needs to put these restrictions on. So showing the violations is important to show the board that their conditions are absolutely necessary above and beyond what their settlement agreement is right now.
Mr. Chairman, if I can respond briefly. First of all, I object to the characterization of what the applicant has planned. First of all, this is not a hearing on an entertainment endorsement. An entertainment endorsement hasn't been placarded. If it is placarded, these protestants would have a right to protest that, and maybe that issue could come before the board. So that is, it's absolutely immaterial. And then the idea that just because this business wants to apply for an entertainment endorsement and perhaps occasionally have a DJ that they're trying to turn it into a club is absolutely lacking in any foundation whatsoever. And I'll also point out that Mr. Almeida and Mr. Nye will have an opportunity to put on a case here as part of their protest. Their cross-examination of Mr. Mason is not an opportunity for Mr. Nye to himself testify. And again, and I will repeat myself, the chairman has specifically limited the scope of this hearing to whether additional restrictions are necessary, whether the existing settlement agreement is insufficient to provide protection to these protestants. What the evidence that they continue to put on is that apparently they believe ABRA enforcement is insufficient to protect them, not that the settlement agreement is insufficient to protect them. If they have an issue with ABRA enforcement, they should go to their ANC, they should go to somebody else, but it is not the fault of the existing settlement agreement. And we have an ABRA protest report where there were 20 visits from ABRA investigators, different times of day, different times of year, all throughout the spring and summer. We also have 5 police reports, and none of them revealed a violation of this settlement agreement. Now, if Mr. Nye and Mr. Almeida want to take issue with ABRA's ability ABCA's ability to enforce the terms of settlement agreements, they're welcome to do that. This is not the place to do that. And Mr. Nye is apparently unwilling to limit the scope of his questioning according to the chairman's directives.
All right, this is cross-examination. And I think that Mr. Nile and Mr. Almeida, you'll have an opportunity to present your case. So I need you to limit your questions to questions that were asked on direct. So let's kind of wrap this up, because I think we're moving far afield from questions that were asked on direct. You will have an opportunity to present your case and present what you believe that you want us to hear and what decision was to. But we're in cross-examination, and cross-examination is not a point where one is going to present their case in chief. And I think that we're kind of moving towards that, sir. All right, so I need us to get back to strictly cross-examination, and you'll have an opportunity to present your case when it's your time to present your case, okay? Let's move on. Do you have any other questions that you need to ask?
No, this is.
Thank you. Any questions of Mr. Mason by any board members? All right. Do you need to redirect Mr. Morris?
I do not. I'm willing to call my next witness.
All right, thank you. All right. How long do you think this witness is going to be, sir? I'm going to take a break, but I will try to take the break out. Is this your last witness? Or you have
This will be my last witness, and I believe the amount of time that Dr. Hampton will testify will be largely determined by the scope of the cross-examination, as it was with Mr. Mason.
All right, fine. We'll do this witness, and then we'll take a break after this witness testifies, since I don't want to necessarily, or unless the board wants to take a break at this juncture. Or should we just push through? All right. I'm trying to get, The board is gonna take a break. So it's 4:20, I'm sorry, it's 4:20. We're gonna take a break until 4:30. So we're off the record until 4:30. So I'll ask that everyone, you don't need to log off, just mute your volume and take us off video. So we're off the record until 4:30. All right, thanks. We're back in the record. Mr. Morris. Great. 1, 2, 3, 4. Okay, I have sufficient board members. All right. Do you have another witness you wish to call? Mr. Morris.
Thank you, Mr. Chairman. Next witness I have is Dr. Carly Hampton.
Dr. Hampton, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
Yes, I do.
Are you a witness?
Thank you, Mr. Chairman. Dr. Grant, you're one of the owners of Buddy's as well, correct? I'm sorry, Dr. Grant. I'm sorry, Dr. Hampton.
Yes, I am. Yes.
And what is your relationship with Grant Mason, the other witness and other owner here today?
He is my fiance.
Okay, can you give the board a little background on yourself and your background?
Yeah, so I am a DC native. I grew up in Southeast DC. I went to high school in Northeast. I went to North Carolina A&T for undergrad and Old Dominion and got my doctorate in physical therapy. During that time, afterwards, I had, moved all about the country for my different clinical rotations. And I ultimately felt like I needed to be back home. Things were looking different, things are changing, and I wanted to move back to the city I grew up in. And so here I am living in DC and Northwest and working downtown and open Buddies.
Okay, and what's your day-to-day role at Buddy's?
Oh, essentially, it's kind of like everything that needs to be done, whether it's social media or if I need to run food to a table, pretty much everything but cooking food and making drinks. Essentially, more of like a managerial role, making sure that we have supplies that are needed, making sure customers are comfortable, people have what they need, dealing with different complaints, dealing with, complaints from our next door neighbor. Addressing emails, things of that nature. Kind of a lot of everything except, again, cooking food and making drinks.
And again, and as part, along with Mr. Mason, have you had a role in making outreach to the community with regard to the sort of offerings that the community wants Buddies to have?
Correct. I am the one who actually came up with the petition to see if this is something that the community wants. If they are, because we did hear from our next door neighbors, it was apparent that they were not for us having the televisions, Mr. Niles and Mr. Amita only, actually. And so I created the petition to see if, okay, is this an actual issue? Do we need to see what other people in the neighborhood feel? And a strong majority of people were for that. So asking individuals when they come in, not only about the environment that they're in and the entertainment as far as the televisions and the music that we provide, also asking them what other things would they like to see from us, because again, we are essentially new to this. I'm a physical therapist, and it was a sense of like, okay, let's see what the majority of the community wants. So kind of surveying, getting feedback, and moving about. Some people want to see the State of the Union address, so we put it on. We had a neighbor who had his business was being presented on Bloombar on what was that, HBO with John Leguizamo or what have you, and he wanted to have a little watch party for that, and so we hosted that at our space for them too. Hence what Grant said earlier, we're more than a sports bar. We've hosted Councilwoman Nadeau at our space for her to have office hours where people in the community could come in and sit down with her one-on-one and express their concerns and their needs. Because again, we're more than a sports bar. We're a place that is built to be inclusive. Everyone should feel welcome, people from different backgrounds and those things. And, again, more than just a sports bar.
And is having a vibrant summer garden important to your business?
Very much so.
Okay, and have you worked with Mr. Mason to take steps to make sure that any noise emanating from the summer garden doesn't disturb your neighbors or other people in the community?
Yes, we have.
Okay, briefly, I think Mr. Mason already testified a little bit too. Can you describe some of the things you've done to try to make sure that any noise emanating from the summer garden is kept to an absolute minimum?
Yeah, in addition to what Grant had spoke about in terms of limiting the sound level so that no one outside of us, you know, even us, can even turn up the volume over a certain level. It's been set by an audiovisual person. Most of us are not tech savvy, so we don't know how to jump over that. So that has been set. We also bought a decibel reader and met with Mr. Niles and Mr. Amita to measure sounds from our speakers with the volume completely up, standing directly under the speakers, holding it, standing on their porch, and also going into their home in their living room, you know, at where their window is, leaning over as far as I could, listening to see if I could get a reading on the sound from outside as well.
Okay, yeah, and you just testified that you have controls on the volume, so your staff isn't able to turn it up any louder than you were able to.
Correct.
And
If
is that
anything, they can turn it down.
okay? And is that something that you undertook in response to some of the concerns raised by Mr. Almeida?
Correct, because of the concerns they had.
And similarly with removing the bass from the speakers?
Correct.
And similarly with lifting the speakers off the floor and mounting them in the ceiling so they wouldn't cause vibrations in the walls?
Correct, because that was, and we were informed that was the best way to mitigate vibration and sound. So we took those steps, yes.
Okay, now all of these things that you undertook voluntarily and in an effort to both comply with your settlement agreement, but also just to be good neighbors to Mr. Almeida and Mr. Nye, right?
Yes, and we've done even more than that, yes.
Okay, and you've communicated directly with Mr. Almeida via text message and phone, correct?
Correct.
And he has both yours and Mr. Mason's cell phone number, doesn't he?
Correct.
And he's able to text you when he has complaints or concerns or thinks he hears things, right?
Correct.
Okay. Now I think you acknowledge, and I think we all agree that there are occasional times that we don't do everything exactly that we're supposed to, or things are outside of our control, including, you know, people speaking loudly or maybe staying on the patio later than they're supposed to. Now, there have been a few instances where people have been on the summer garden past 11 p.m., correct?
Yes.
And have you taken steps in those instances to try to move them along and get them to wrap up?
Yeah, we do not serve after the hours that are allowed on our on our license, what we're allowed to serve on the garden. So we cut all service off, we'll remove the food items, we'll even turn the televisions off because again, the patio is closed. We do everything but forcibly remove people. We inform them the patio is closed.
Okay, and there have been a couple of times that Mr. Almeida has complained about people cheering during sporting events coming from the summer garden, right?
Yes.
Okay.
There was once, yeah.
Yeah, and I viewing the submissions made by Mr. Almeida, it looks like two of those instances were April 1st and April 3rd of this year. Does that sound right?
I like, oh, okay, yeah, Final Four. Yes. Oh, yeah.
So during the Final Four basketball games and during the NCAA championship game, people were a little bit louder than normal.
So correct. However, Mr. Amita had sent a message saying that people were outside cheering very loudly. However, at that time, I literally went outside and there were 3 people sitting at a table. No one else was at the patio. There were about three people at the table with a cup of water. There was no cheering or anything going on because the game was over. Mr. Almeida, unfortunately, I feel that he may I don't know. His interpretation of the sound is his own, because again, he complained once that the sound was very loud and to his knowledge was thumping like a club. As I began to write a response to him, because at this moment I was in the space, the woman from Abra had walked in, an investigator, informing us that we were not loud. She couldn't hear anything. She was getting ready to leave. Mr. Almeida sent another text message saying that it's still thumping like a nightclub. And to my response, it was like, okay, I'm not going to respond, because to me, I don't feel like he's being truthful, because Abra just left and he's saying this. And the same thing occurred with him complaining about cheering when the game was over and there was literally only 3 people on the patio.
Thank you. And this instance that you just described, where Mr. Almeida texted you and said it was thumping like a club, how long ago was that?
This was on the March 25th. That was the day. Yep. And then you can even see from the text messages, because I
Okay.
did not respond.
Have
Mhm.
you had any direct communications with Mr. Almeida since that time?
Oh yeah. I mean, we've had direct, because again, he abuts our property. So I saw him, I'm not sure, a few weeks ago.
Okay. Have there been other instances where Mr. Almeida has complained to you about problems he thinks were caused by buddies, but which had nothing to do with your operations?
Yeah, I think he had concerns with rodents, because before we even opened, when there was renovations going on, we had a conversation about how his retainer wall in his front yard was collapsing because the rats were like tunneling through his ground and stuff like that.
What about with noise that he
Oh,
thinks is
yeah.
emanating from your space?
Yeah, there was an instance where he was texting like several days in a row in terms of there's been like a really loud noise. It was like 6 a.m. every single day. We went to the space, because he was saying people were working. No one was working at 6 a.m. We go into the space, nothing's happening. We tell him we don't know where the sound's coming from. We can't hear it every morning at 6, only for him to text us back stating that it was his own coffee pot malfunctioning.
Okay. Now, Mr. Mason has talked a little bit about some of the steps you've taken to try to mitigate noise and mitigate vibration. These aren't specifically required by your settlement agreement, but you do know your settlement agreement does require you to reduce noise coming from the premises, right?
Correct.
Okay, and it also has a requirement that you post signs around the establishment asking your patrons to be considerate.
Yes.
And you've done that?
Correct. They're inside and outside the establishment, specifically underneath the televisions. There's a sign underneath each television that states for patrons to please be mindful and respectful of our next door neighbors, and to keep their noise levels down. And that's also inside the bar as well.
Okay, and as part of this process, without going into specifics, as part of this process, you have expressed a willingness to enter into an amended settlement agreement that with the ANC that would hopefully address some of Mr. Almeida's concerns. Is that right?
Correct.
Sorry, is there an objection, sir?
Yes, there's an objection here. I don't understand how it's the process of amending the settlement agreement at this time is relevant to what's before this hearing right now.
That's fine. I'll withdraw the question. I wasn't going to go into any specifics, as those would be confidential settlement negotiations anyway. So I'll withdraw the question.
Fine, let's move on.
I don't have any other questions for Dr. Hampton. Turn it over to for cross-examination.
Mr. Nile or Mr. Almeida, who's going to do it? Who's going to do it?
I'm going to cross.
Go ahead, Mr. Nile.
Dr. Hampton, just for the record, you admit that there are times that we've complained to you that it's been too loud, right?
Correct.
Mm-hmm. And do you acknowledge that there have been times that the music has been too loud?
Not necessarily. I know there are times where you have complained that the music was loud. I was not in the space. And so I have reached out to our manager who was there because again, you guys are our neighbors. And if it's affecting you, I want to make sure that it's not. So I have reached out to the staff to inform them to turn the music down. Every single time they're just like, it's not loud. I don't care. Turn it down because you guys said it was. And then there were times where you had complained and I was physically in the space and it was like, it's not loud. To the point that even Mr. Almeida, when he came in during the Councilwoman Nadeau's meet and greet with everybody in the community, he sat in the space and also informed me that the sound really isn't an issue, that there was the vibration was his concern. Because
So
he said it's not loud in here.
when I'm at, how often are you at Buddies?
I'm sorry?
How often are you at Buddies?
Essentially almost every single day. Yeah, I work and then I go there. I'm sorry?
When do you work?
Oh, I work Tuesday through Friday.
At Buddies?
No, I work as a physical therapist during the day as well. I do both. Buddies doesn't open until 5 p.m. So yeah.
And you're there every night?
Not every single night, but majority. But and it's not like I'm there from open to close.
Okay. So when do you typically leave?
There's no set time. Some days I'm there until 2:33 when we're in the process of closing because we spent an hour or two cleaning. So it just varies on the day.
Can you estimate how many times you're there till closing?
I mean, in what time frame? It's it's been 7-8 months, so it's hard for me to kind of pin it down.
Are you there every Friday and Saturday night till close?
Not every single, no.
Okay. So when you and Grant aren't there on on Friday and Saturday nights, who's in charge?
So we have a bar manager and we also have another partner.
What's your bar manager's name?
His name is Alonzo.
Alonzo what?
McFall.
And he's there every Friday and Saturday?
No, not essentially, no.
Okay. And
it varies.
And are you two the only two owners of Buddies?
Essentially, yes.
Oh, who are the other owners?
There are no other owners.
Yeah.
Hold on. Mr. Mason. You remember when you were testifying? I never heard Dr. Hampton open her mouth and say one thing, sir.
Yes,
I'm
sir.
asking you to do the same thing. When she is testifying, you have already had your moment. So please, sir, please do not speak. Thank you.
Who are the other owners, Dr. Hampton?
There are no other owners.
Okay, so your LLC is made up of just you and Mr. Mason?
I'm going to object. This is beyond the scope of direct and has nothing to do with the issue. It's completely irrelevant.
Why are we going on this road, Mr. Pyle? Why are we going on this road? Why?
Well, my concern here is that there's other people who are consistently stating that they're one of the owners of the restaurant. And I'm trying to figure out if people are managers or owners and what kind of authority they have. And so the concern here is that if somebody else is, if Carly and Grant are coming forward today and saying, well, we're going to be able to manage this, if there's another owner out there that's not involved in this process that's saying, well, I can do whatever I want because I'm an owner, that's what I'm just trying to figure out here. We don't know because it hasn't been disclosed to us who the actual owners are, or if there are investors or somebody who has a power there to overturn any of the things that they're saying that they've done.
But you don't need to respond, Miss. I'm gonna overrule the objection. Let's move on from there. As far as I don't think there's any question that the people who are in front of us are owners. It's irrelevant. And as far as you're concerned, Mr. Nall, if there are other folks who are owners, and if Abra shows up and the person says that they're an owner, and if we go back to the office and they're not on license, then that's a violation. All right, so let's move on from there. Go ahead.
Thank you, Chairman. Indulgences. No further questions.
Thank you. Any questions by any board members? Thank you. Yes, Mr. Short.
Thank you, Mr. Chairman. Dr.
Hampton.
Dr. Hampton,
Yes.
do you know the date that the original owners who opened up the corner there, do you know the date?
Yeah, are you referring to room 11?
No, I'm speaking of, yeah, room 11. When did it open?
I don't know. I think they opened in 2012 or something like that. Yeah, I'm not sure. It was like a settlement agreement is in 2012. So it was either 11 or 12. I'm not too sure.
I can tell you, I think that you're right. I remember when they came before us also, and the
Mm-hmm.
concerns the neighborhood had. So that's the reason why I asked that question. Thank you very much for your answer. That's all I have, Mr. Chair.
Okay.
Thank you. Any other questions by the board members? All right. Mr. Nile, and do you have any questions for the witness based on the question that Mr. Short asked?
No.
Mr. Morris, any redirect?
Very, very briefly, just one question for Dr. Hampton. Dr. Hampton, you understand, even if you are not present at the establishment, you are, as the owner of the establishment, you're bound to ensure that the settlement agreement is followed and that all the provisions that you put in place to ensure that the settlement agreement and the noise provisions in that settlement agreement are followed is your responsibility?
Correct. And that's part of the management, making sure that everyone is aware of that.
Thank you. I don't have any other questions for Dr. Hampton.
All right, thank you very much. Do you have another witness, sir?
I do not, Mr. Chairman. The applicant's case is complete.
Thank you. All right. All right, Mr. Nal or Mr. Almeida, how do you plan to present your case?
Yes, I'm going to ask Mr. Almeida questions right here.
All right, Mr. Almeida, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Your witness.
Can you please, Mr. Almeida, can you please state your name for the hearing?
My name is Guilherme Almeida.
And what do you do for work?
I'm an architect.
And where do you work?
I work at Hickok Cole. It's a local architecture firm here in DC. I've been there for about 14 years.
And how long have you lived in this neighborhood?
I've lived in this neighborhood for about 12 years. And prior to that, I moved to DC when I was 18 years old to go to Catholic University, so I haven't really lived very far from here since then.
And how long has your family had this house?
This house has been in my family for 20 years.
And prior to Buddy's coming in, were you aware of the business that was in place at the location next door?
Yes, Room 11. It was a business that I frequented a lot and have a great relationship with the owners of the establishment, going so far as to connect them with some of my best friends who have done architectural work for them since they've left the neighborhood.
And did you ever have any issues with Room 11 as a business?
Nothing beyond a normal neighborly relationship. Sometimes their trash would get smelly and they would clean it up. There were a couple times when the establishment was closed that the employees decided to rock out at 4 a.m. and they turned the music up very loud. And I went over there and they stopped doing it. So we had a very civil relationship, a very neighborly relationship that continues to this day. And so when the applicants say that they did not have a good relationship with me, that is quite a surprise. And yeah.
Anyway, so when Room 11 was in business, did they have any speakers on that garden patio?
No, they did not. They did not have speakers, and the patio was in fact of a smaller footprint than it is currently.
What was the footprint?
It previously had a landscape border of about 3 feet that went along 2 sides of the patio, and it was not enclosed with a roof structure.
What was the occupancy at the time when Room 11 was there?
The occupancy is, I believe, 28, which is still what it is today.
And currently, how many seats are on the patio next door now?
Well, currently there are no seats on the patio because the patio is closed. So all the seating on the patio has been removed.
Prior to it being closed, what was the seating that Betty's had in place?
In the investigator's report, there are 40 plus seats shown.
And so that's a significant increase, right, from room 11's occupancy. Is that right?
Correct.
And was there any any speakers of any sort in front or on the side, outside at room 11?
No, the only speakers they had were inside of the establishment.
So they had a sound system inside. Did you ever, other than the few instances, two instances that you claimed, or did you ever have any issues with the speaker system inside?
No.
Can you discuss the differences of the interior that room 11 had to the interior that Buddy's has now?
Yeah, the room 11 space was broken up into two spaces because it was previously two retail masonry buildings that were only combined by a couple of doorways, whereas the Buddy space now was one large contiguous open space.
And how did that happen?
Well, there was a extensive renovation that Buddy's undertook last year.
And so currently it's one space?
Correct.
And in the investigators report, they said there was one bar. Is that true?
That's true.
And other than sound, is there anything else that affects your living in this house, living next door to Buddy's?
Yeah, there are vibration issues, which are can be a result of a myriad of things. The way wall assemblies are built, the way flooring assemblies are built, the way the building is structured, when structural work was done to the building, how it was done, how it was undertaken. And then on top of that, we have been experiencing smell-related issues from a non-compliant kitchen exhaust that was recently installed up against our property line.
Was that kitchen exhaust there when room 11 was there?
No, it was not.
Who installed it?
The applicants.
And can you discuss times when you complained of noise or vibration issues with Buddy's?
Yeah, I mean,
If you can go chronologically, that'd be helpful.
There were several instances that I shared in emails and text messages, but I can list out the dates. Where did I put that? On January 15th at 9:59 a.m., February 8th, 10:50 p.m., February 10th at 11:31 p.m., February 18th at 12:16 a.m., February 19th at 12:14 a.m., March 4th at 6:54 p.m. from the patio, March 4th at 10:57 p.m., March 25th at 11:49 and again at 1:10.
Are these documented? Are these instances documented of the complaints you made?
They're documented in text messages or emails.
Okay, should we have the text messages? Can you pull up the text messages? I'm just going to enter them, I'm not going to question them.
Okay. I will share exhibit, excuse me, sorry, for sharing exhibit 4B. Oops.
And what is 4B?
4B are text messages between myself and the applicant over that period of time. And then there is also a PDF that was submitted with email communications exhibit 4A.
We're going to ask that 4D get entered into evidence.
4B.
4B, I'm sorry.
Mr. Morris.
I don't necessarily have an objection, but I'm just going to object and ask that a foundation be laid for the admission of these documents.
I thought we were just talking about 4A. So what documents are being asked to move into evidence?
We're asking that just 4B, which is text messages between the parties, which Mr. Almeida just said these are the text messages between him and his parties, and he produced it.
So 4B is text messages then, Mr. Morris.
Again, I just would request a foundation as to where these were obtained from, just as some establishment of authenticity.
Okay.
Mr. Now, so I mean, who send these text messages? Are these text messages that Mr. Almeida sent?
Yes, they're text messages between the parties, between Mr. Almeida and Carly and Grant.
So these are text messages that Mr. Almeida sent
Yes.
or responded to. Is that correct?
Yes.
This is 4A. Okay, so I'll move 4A into evidence.
Sorry, it's
4B. 4B.
I'm sorry, 4B.
Thank you.
Thank you, Mr. Chairman.
You're
Okay, moving on. Now, these are the text messages. Were there emails?
Yes, there were also emails.
Let me see the email.
The emails are
4A.
Exhibit 4A. Yes, there were emails.
4A. And are these emails, the emails, look at them, are these emails in the same condition as they were when you had them before? Have they been changed in any way?
No, these are the emails that I submitted in April for our original hearing date.
But these emails are between you and the applicants, right?
Correct, with the exception, yes. The last email contains a letter from the neighbors adjacent to us as well.
Okay, so that letter has names of other neighbors on it.
Correct.
Okay, I'd ask to admit the emails and the letter as 4A this time into evidence.
Mr. Morris?
I don't have any objection.
So what exhibits are these again? These are for what?
4A. It was submitted as 4A.
Exhibit 4A moved into evidence.
Now, discussing not going into the specifics of the letter, but can you briefly describe to us what the April 19th letter in 4A is depicting?
The letter that we sent to Grant and Carly on April 19th that's signed by several neighbors, including the neighbors that are adjacent to me at 1108 Lamont Street, outline several things that many of us witnessed that we wanted the applicant to correct or had essentially took issue with. So
Was that including noise?
That is including noise, yes.
Okay, thank you. Yeah. How many neighbors signed on to that letter?
There were 3 neighbors at 1108 Lamont Street next door, and then 2 neighbors that live down the block.
And I'm going to go back to where we're at. So does this list of all the instances that you said earlier where you made complaints, do these emails and text messages cover those showing the evidence of those complaints?
I believe they do. I'm just looking to see whether in there were further exhibits that I attached at a later date that highlight other occurrences, but for the most part, these emails are a big bulk of it.
Now, how many times have you called ABCA in relation to noise complaints or vibration?
I think I've called ABCA 3 or 4 times. One time I spoke with Inspector Kevin Puente, and I explicitly stated that there was noise inside my house, but he did not come to my house or in fact even ask me what my address was. So the only time I was able to get an inspector in my home was when I got Inspector Ruiz on the phone, and it was very early on a Thursday. It was about 7 o'clock on a Thursday, and I insisted that he come into my home in order to hear what I was hearing. But that was the only time I was able to get an ABCA inspector to come into my house.
Did you ever restrict an ABCA representative from coming into the house?
No, I did not.
Would you have welcomed an ABCA representative to come into the house?
Absolutely.
And can you tell us anything else about your interactions with the ABCA representatives?
Well, I have found ABCA to be frankly unresponsive, including to the night that I called about the patio being open beyond the allowable hours and left a voicemail, didn't hear back, so I wrote an email that I didn't hear back from for several days later. So in that particular instance, there was no way that ABCA was going to substantiate it because they didn't respond to it until several days later.
So have you tried to enforce the settlement letter, the settlement agreement that's in place currently?
The only time I was able to have a direct conversation was when Inspector Ruiz came to my house on, I believe it was April, oh, excuse me, I'm sorry. April 13th, I believe, which was a Thursday. Yes, April 13th. Prior to that, I was making an effort to just communicate with the applicants and not go to ABCA every single time. But I now understand that that is the route I should take.
Now, have you ever recorded or had the ability to record noise coming from the TVs or the sound system on the patio loud enough that you could hear it across the street?
Yeah, that was the video we watched.
What date was that?
Oh, that was December 10th. I'm sorry, was that December 10th?
Without replaying the video.
Yes, December 10th, 2022.
And to your knowledge, where was that sound coming from?
It was very clearly coming from the televisions in the Buddy's patio.
Is there any way it could be coming from anywhere else?
No, because there's no other televisions nearby that would have been audible from my cell phone.
Well, did you
microphone.
perceive where the sound was coming from?
Yeah, I mean, I crossed the street specifically to take that video for that purpose. So.
And did you inform the applicants of when that took place?
Yes, we did.
And have there been times when the applicants haven't been responsive to your requests, if ever?
Just a couple times. I would say more often than not, they do respond to my text messages, but the problem is not solved. So there is a physical response, but not a solution.
Has there been issues with the applicants not being there when when the noise sometimes happens? Not physically being at the location?
Yeah, I mean, I think there are some times when they're not at the bar.
And is that when it's loud?
There have been occasions when it's been loud and they haven't been at the bar, yes.
And what, if anything, do you know, is the vibration still going on? Is it still affecting you?
It's lessened from when the initial round of complaints came in, but it still does occur at times. And we have not heard, other than that the bass was taken out of the speaker, that there were any other mitigation measures taken into account. And as an architect, I know, the various different avenues that vibration and sound can take. And so it's very known to me that there's a whole host of things that can be and typically are done to establishments like this to absorb and mitigate vibration and sound.
And what are those things? What would you recommend?
Vibration isolating mountings, absorptive material, whether in walls and ceilings. A lot of the things have to do with the way spaces are built as well. You have to build for acoustic isolation. If you don't, then it's much harder to mitigate these things. So if, for example, you mount a speaker on the underside of a beam that's holding a structural brick wall, and that structural brick wall is attached to my house, then that is going to reverberate into the structure of my house. And it's difficult to solve these problems, but there are ways. It just takes a professional and effort.
Have you ever suggested or tried to help the applicants in mitigating this?
Yes, after our ABCA sponsored mediation, I wrote an extensive email that I took quite a bit of time to research and reached out to industry colleagues to understand how they could, in a sort of reasonable, cost-effective manner, engage a party to determine what the issues are in their space and how to mitigate them so that we don't have these issues on our end. And we did not hear back from Mr. Mason in response to that very extensive email, which is actually in Exhibit 4A that we've already submitted as evidence.
And how much time have you devoted to dealing with these issues?
It's taken up a lot of my time. I mean, when you are in your home and you're hearing the wall thump when your head is on the pillow, it's very much an all-consuming thing and makes it very difficult to find the peace and tranquility that you need to live in your home, right? This isn't just a passing sound. When it occurs, it can be heard quite extensively in our house, and it's very difficult to deal with it, particularly in the evenings when you're trying to sleep.
And when the music was loud on the TVs, what, if anything, could you hear from in the house?
When the music is loud on the TVs, including when Dr. Hampton and Mr. Mason came into our home to do the decibel reading, we could hear it in our living room. So because of the proximity, there's really not a scenario where any speakers on that patio won't be audible in our home, which again, per the settlement agreement, you're not allowed to hear amplified sound in our home. And whenever those speakers are on, you can hear it in our home. So,
can you describe the speakers, how they're faced and how they're mounted, and how they would project sound?
They're speakers. The issue for the patio is not how they're mounted, it's that they're in close proximity to the windows of our living spaces, right? So if you have a speaker that's 10 feet away from your house, from your window into your living room, when you're sitting in the living room, you're gonna hear it. Even with, double paned windows that we have in our house.
Can you hear what is being said on the television?
Yes. You can hear the Arby's commercial when it's playing on the TV. You can hear the game. You can hear the announcer. So imagine sitting in your living room and hearing somebody else's TV going on at all times, and you have no ability to control it other than to leave your house.
And yeah, tell me more about how it's affected you emotionally or physically.
It's been very difficult, particularly in the context of the applicant telling me that I'm a liar and making this up. I have started seeing a therapist to try to cope with this. It's been very difficult engaging, with being at home, frankly, because this is my sanctuary, the place that I'm supposed to go for rest. And when you come home and there are noises that you can't control, you have no silence, no quiet, that has been really, really difficult. I have spent hours and hours away from work trying to work through these things and frankly, just dealing with some of the emotional issues that have come from it. I don't have anywhere else to go. This is my home. At the end of the day, I can't close the door and go home and sleep somewhere else. This is the place that I have. So.
And do you have any personal bias against Buddies, or is there any sort of truth to the fact that you would want to do this to go after Carly and Grant or anything for that reason?
No, absolutely not. I was very happy when I saw a business going in next door, because the previous business was a business that I spent a lot of time in. Part of the reason why I live in this neighborhood is because it's nice to be able to walk out your door and interact with neighbors in places. That is why we are not and have never approached this protest as us trying to deny them a liquor license. This is about the conditions that allow us to coexist peacefully, and having music being played so that it can be heard inside our home is just not one of those conditions. So we absolutely want them to do well. We frequent all the businesses in our neighborhood. I might be a little bit too old to go to Wonderland at this point, but generally we frequent all the businesses in the neighborhood, and we're not looking for them to close. We want them to thrive and be a part of the community, but we are also a part of the community, and this is our home. So.
Okay. And what, if anything, what conditions are you asking for today that you think the board can impose that would better this relationship?
Well, I think it's clear after the amount of time that we've had to come to terms. We postponed the hearing at one point when they engaged Mr. Morris, because we felt like we were going to potentially have a better avenue for communication, and the applicants have stated to us that, and to everybody here, that their business doesn't work without speakers on the patio. But our home does not work with their music in our home. So yeah, we need those speakers to not be playing music outside, and we need whatever music plays inside to stay inside their space. They're welcome to do whatever they want in their space, as long as it stays in their space and not in our space.
I mean, have you ever done anything, or anyone in this household ever done anything to affect their ability to do their business?
No, I have contacted the Department of Buildings about the building-related issues that we are facing as a result of the construction next door, and that I'm sure has impacted their business, but that's not something I did. That is the reality of where we are.
And currently the patio is not being used, right?
Correct.
And what is your concern when the patio is going to be reopened?
My concern is that the speakers will be playing music, people will be out there, the speakers will elevate the tone of the patio, and we will be hearing louder and louder noise inside our home.
And specifically talking about the sporting events, can you talk about that and how people react and how that isn't conducive to their current settlement agreement?
Well, I think there's a whole lot of language in the settlement agreement that talks about being respectful and keeping volumes at a reasonable level, but you know, a sporting event riles people up, right? And so when we saw the speakers go up, we were worried, and in fact, were proven right when we witnessed loud cheering late at night on the patio that we could hear in our bedroom. So yeah, that's our concern with the current setup.
And just finally, this isn't something that's happened just once or twice. It's happened several times, right?
No, I think as you'll all see by the text messages that we submitted and the dates that we provided, that this has not happened just once. And so, you know, I foolishly thought that the conversation with them was going to be something of importance, but now I understand that, you know, the ABCA formal process is the vehicle through which we are able to present our concerns a little bit better to the board.
No further questions.
Mr. Morris?
Thank you, Mr. Chairman. Thank you, Mr. Almeida. You testified that you've called ABCA several times to complain about noise emanating from Buddy's. Is that right?
That's correct.
And was it your contention by making those calls that you believed that noise emanating from Buddy's was a violation of DC law?
No, that it was a violation of their settlement agreement.
So if the existing settlement agreement, correct?
Correct, the existing.
So if there were noise indeed emanating from the premises, as you complained to ABCA, it's your contention that that would be a violation of the existing settlement agreement. Is that right?
Correct, the noise being heard inside my home, yes.
Okay. When is the last time you called ABCA and reported a potential violation?
The last time I called ABCA, I believe was, if you give me a second. I believe it was the April 13th date when Inspector Ruiz came to my home.
Okay, and did you ever follow up with Inspector Ruiz following that visit?
I did. In fact, I emailed him several times and called him and left a voicemail and never heard back from him. And I also included him as one of my witnesses, but he is not here today.
So none of the calls that you made to ABCA and none of the visit, and including this visit from Inspector Ruiz, resulted in a citation or violation to Buddy's, either a DC law or a settlement agreement. Is that right?
To my knowledge, yes. I called and requested information on that and was not given any. So because I don't see it in the inspector's report, that's what I'm assuming.
Okay. You submitted a couple of exhibits. One, I just want to note, the letter that you submitted as Exhibit 4A-5, you testified that these other neighbors signed off on it. Did you draft that letter?
I did draft the letter, yes.
Okay. Now, I noticed that the letter was unsigned. Is there a signed version?
No, I mean, I communicated all of this through email, so I don't have my own physical signature on it. If that's something that the board needs, I'm happy to get them.
Okay, do you have any other proof that these individuals actually consented to their names being put on that letter or shared your concerns?
Well, I mean, I have my word because I'm testifying under oath, but I also have my email communications, and I guess I could pursue phone records, but I'm happy to get these people to contact you. If there was any issue with the veracity of the letter when it was sent back in April 19th, I would have appreciated it being brought up, not in the hearing.
Okay. Just wanted to clarify that.
Okay.
You also testified that you've reached out to the applicants via text message and email on several occasions to complain about noise and vibrations and time of trash collection, right?
Correct.
And the trash collection issue was addressed and is no longer an issue, right?
Correct, yes. The Department of Consumer and Licensing Protection issued fines to their previous trash collection service, and I believe they have a new trash collection service now.
Okay, and the applicants have been responsive to you with regard to the other concerns, right? Responded to your emails?
Well, they did respond to my email, but their response was basically telling me that I was complaining about something that never happened. And so I had to respond with several additional dates and proof that it actually did happen more than once. So,
Okay, now I'm looking at the string of text messages, and I see a text message on January 15th complaining about music emanating from the space, and Grant Mason responds and says that the jukebox company had set it up and that he would turn it off. Is that an accurate depiction of that exchange?
that's accurate. I believe that what occurred was that the jukebox had just been installed and the system was not set up properly yet. So it turned on its own early in the morning and we could hear it clear as day in our bedroom.
Okay, and there's also messages on February 10th where you complain about the bass coming through the wall, and Grant Mason responds talking about meeting to discuss it. Is that right?
Correct, yeah.
And Mr. Mason testified that he came to your home and there was a decibel reader. That also occurred?
That did occur. That's the instance we were talking about where in the exhibit that you submitted, the decibel reading outside on our porch is actually higher than what's allowable by the DC noise ordinance.
Okay. Just trying to establish the fact that Dr. Hampton and Mr. Mason have responded to your text messages, have said they would turn down the music. That's all accurate, right?
It is. However, when they came to my house and heard the music in my house, their conclusion was that it was fine that you could hear it in my house, even though the settlement agreement says you should not be hearing anything inside the adjacent properties.
Okay,
so while they engaged us and we tried, there was not a conclusion that was satisfactory because, again, hearing music in our home is not allowed per the settlement agreement and is not something that would be conducive to us having any peace and quiet in our home. And that is evident in another video that you submitted that was taken inside my home. So,
but is it fair to say that your complaint is with what you believe to be the unresponsiveness? I think that was your word from ABCA investigators.
Unresponsive in terms of, I'm sorry, from ABCA investigators?
Yes.
It has been very difficult to get an ABCA investigator to come here when I call. That is a part of it for sure.
Okay, so it's less the issue of the provisions in the settlement agreement and then your ability to enforce it. Isn't that right?
And also the applicant's understanding that it's okay for some of these things to occur. Again, the settlement agreement says no sound should be heard in adjacent structures, but the applicant has made it clear that they think that's okay and that's just a part of city living.
Okay. I don't, have you talked about these text messages and submitted the exhibit with the text messages that end in late March of this year. Have you complained to the proprietors of Buddy's since March?
No, because it has been, since their patio was closed by the Department of Buildings, it has been much calmer here. So that has been part of the thing that has alleviated some of this in recent months, is that the patio is not able to be utilized because it was deemed a danger by the Department of Buildings.
But the issues with vibration and sound emanating from the interior of the premises have been addressed?
I believe at this point that they might have been addressed. Again, I don't know, because other than what was just shared during this hearing, I don't have concrete sort of this is what we did. We just took the bass out of the speaker. I think that I would have to go back through my dates to see whether I don't think that we have experienced the vibration inside in any meaningful way since the bulk of the the text messages that you see there. So, you know.
So it's fair to say that all the measures that Mr. Mason and Dr. Hampton have taken has addressed your concerns, and to the point where it hasn't been an issue in some 4 months. Is that right?
For the vibration, that could be the case. It could also be that they knew there was a hearing coming up and I was recording stuff. I don't know.
Okay, but you've remained living in the space for the last 4 months, right?
Correct.
Okay, thank you. And so your concern is what might occur if the patio is reopened?
Yes, because it already has occurred in the past, right?
Okay,
So
and
it's already occurred in the past. It could occur in the future again.
And notwithstanding that, your complaints regarding all those issues has never resulted in so much as a warning to these proprietors. Isn't that right?
That is right, which again is perplexing to me because Inspector Ruiz came to my home and said he could hear it inside my home. So I do not know why that did not result in a complaint, and I do not know why he's not here when I listed him as one of my witnesses.
Thank you. I don't have any other questions for Mr. Almeida. Thank you.
Mr. Almeida, did you hear at the beginning of the hearing that Mr. Ruiz is no longer working for the agency? And also, I don't recall signing a subpoena that you provide to the agency for us to produce a witness.
Oh,
if parties want a witness to be produced, then a subpoena needs to be filed, and I would sign off on it. And I don't recall seeing a subpoena from you requesting an agency witness.
We did not submit a subpoena. I did not realize that was necessary. ABCA Legal told me that I didn't even need to list him as one of my witnesses because he would be here. So
because we thought,
and you were told at the beginning of the hearing that Mr. Ruiz, the reason why Ms. Plaitis testified today, why she went out, is that he no longer works for the agency, sir.
Are you thinking of Mr. Condon? Because I think Mr. Ruiz still does work for ABCA. It's Mr. Condon was the original inspector. Mr. Ruiz was just the inspector that came to my home on April 13th.
I believe that Mr. Ruiz. Well, all right, let me not. I'm not involved in personnel, but I thought that Ms. Plaitis testified this morning why she is the investigator, why this case was assigned to her. So she's the third investigator who's been on this case, sir. All right. I have a question I want to ask you. When was the last time you heard, do you know when is it that, if you know the patio, that they were unable to use the patio since when?
Since March 23rd. They used it for a little bit after the stop work order was issued, but then DOB came back around and made sure that they stopped using it. I don't know exactly what that date was off the top of my head.
But it was, all right. I stand corrected. Mr. Reeves is still an employee of the agency, but I said before, I don't recall, at least I haven't signed a subpoena for you requesting a specific witness. All right. So, but your testimony, is it your testimony today that over the last 4 months, you have not been aware of any violations or perceived violations by this establishment? Is that correct?
Of the vibration in our home, we have heard general music in our home from the patio.
What do you call general music, sir?
Just whatever's playing on the TV or on the speakers.
Have you raised a complaint with the licensee during this period to say that you have heard noise in your establishment?
No, we have not.
We
felt like we had so much already, but now I guess we realized we didn't.
I'm just asking. I don't know whether you did. I'm just asking you.
Yeah, I mean, to be perfectly frank, Mr. Chairman, this has been a very draining experience. So I've kind of taken the last few months to try to not be quite as on about it as I was when I was really experiencing the bulk of the vibration coming through the wall. So I would love to be in a position where I don't ever have to think about what's going on next door. That's what I would like here. That's how my life was before, and that's how I would like for it to be.
So tell me, what type of business was Room 11?
It was a wine and cocktail bar. So they initially had started out right on the corner because, again, as I mentioned, it was two spaces that kind of eventually they expanded into one. So when it was first just the one corner space, they had a very small bar, maybe like eight or nine seats at the bar, and maybe a handful of tables, like 20 seats at a handful. No, even less, at a handful of tables. And they served wine and cocktails, and it was a very hip vibe. They played music. It was a very active, sort of like hip, vibrant space. I would say it's my impression that it's not too dissimilar from what Mr. Mason and Dr. Grant are trying to do, but for the sports viewing component of it, right? Of course, at a bigger scale, because the space now has been renovated to be much larger, more open, and as I mentioned before, the patio physically expanded as well and is covered now. So previously the patio wasn't covered, so it wasn't in use quite as frequently, right? Because it was subject to weather seasons and all of that. So that's the type of establishment that they have.
And you've also testified that you had frequent room 11.
Correct. Yes, I spent more money there than I would have liked to admit in my young age.
All right. So you said they played music. So how did they play music? Because I'm told that these owners are using a jukebox. So how was music played in this other facility, this other club?
So I think that my apologies. I think they just had ambient music inside. There was no heavy bass. It was not extremely loud. It was just enough to sort of set the mood of the bar. But the bulk of the noise that was in there was by far, it was people's voices, not sound, not heavy bass, no like dancey type music, more loungy, cocktail bar, wine bar type music.
All right. I don't have any other questions. Any other questions by any other board member? Go ahead, Mr. Short.
Oh, I think you're muted.
I can't hear you, Mr. Short.
About that. Mr. Almeida, what year exactly did you move in to your home?
2011.
2011. So that's the same year that the Room 11 opened up, correct?
Yep.
Did you ever come down to testify when Room 11 opened up?
No, I did not.
Okay, and the owner of Room 11 was up in his age a little bit, wasn't he? Was he about 50?
Yeah. Oh, I'm sorry. He was. You're thinking of Paul Rupert. He was one of the owners of the bar. Yeah, he was the major investor.
I remember him coming in to get the open it up. But I'll just simply say this: when you lived at Catholic University, how was the noise level down there?
Oh, it was so quiet.
All the time?
Oh yeah, I mean it's bucolic over there, right?
I know it's very large, right down the street from the Washington Hospital Center and veterans, and so you got ambulances going up and down the street all night long. I do know that, right up and down Michigan Avenue.
That's true.
Okay, and so it's just that was a busy area, period. Correct?
Yeah, I mean there's city sounds, right?
Okay, all right, okay. Let me ask you this: before you went to Catholic University, what type of neighborhood did you live in, and what was the noise levels?
I'm sorry, say that again. You broke up a little bit.
Did you ever live in a city before you moved to your current address, other than Capital University?
Yes, I have lived in the heart of Rome for a year when I was in college. I lived
Let's talk
in.
about the United States.
Okay,
and
all right.
similar cities to Washington, D.C.
I've been here since I was 18 years old, and prior to that, I lived in South Florida for a few years, and then before that, I didn't live in this country. So
Well,
I
okay,
think
well,
DC is
I've
the
got
bulk of
that.
my.
But South Florida isn't that quiet in most neighborhoods. That if you were in one of the Fort Lauderdale or West Palm Beach, or they're not as quiet as out in the country. So did you live in the city or did you live in the country?
Well, at that point, I lived in a like a suburb, so it was very quiet. There was no. But that was when I was
So
in
normally
college.
you are very used to quiet, calm type atmosphere. So that must have been kind of a shock for you to move to Lamont Street and 11th Street, wasn't it?
No, because I'm originally from São Paulo, and I've lived in major capitals, with exception of my time in Florida. That was like a little blip of my lifetime. So I'm pretty used to cosmopolitan city living.
Well, I'll just say this: 11th Street is a pretty main drag, then you're bordered by Georgia Avenue, and then you got 14th Street. And I know that ambulances and fire trucks are all night long on 11th Street, especially on weekends. But at any rate, I'm just trying to get your feeling about you moving into 11th and Lamont Street the same time that a establishment opens up, and now you want the same noise as you were when you're in St. Paulo. Is that what you want? Same noise levels that you when you lived in Europe?
I mean, I think the same noise levels we had when it was room 11 is the fair thing to say.
What's that again?
I think the fair thing to say is that we want the same noise levels we had when it was the previous establishment, which was room 11.
And you were okay with that?
Yeah, yes, we are okay with that. Absolutely.
Well, I'll just say this to you, sir. Welcome to Washington, D.C. I've been here for 76 years. Welcome to Washington, D.C. I worked for the fire department for 33 years. I know a lot about the city in your area. There used to be a streetcar turnaround there at 11th and Monroe Street. The streetcar used to come. So that was 11th Street's always been busy. And so how many nightclubs were on 11th Street when you moved into your now residence?
Just Wonderland is the only bar that I think is probably categorized as a nightclub, I think. But they do not play music outside, as an example.
Okay, well, how many other? Because the testimony today we got was there are several within 400 feet of the.
They're mostly restaurants, and I would say not all of them play music outside, and not all of them directly abut a residential zone, such as the one that I live in, or even a residential building for that matter. Some of them are sort of more standalone. Some of them are retail spaces within mixed-use buildings where the rules are different. So there's not quite as many. Of I think direct comparisons of our situation here.
My last question. Do you think that you'll ever be let's just say, let's get used to living in Washington, D.C., in an area where you have several, not one, but several businesses, restaurant or those types of, do you think you'll ever get used to that? Or do you think that maybe they should close and make it quiet so you can be happy?
Oh, I don't think that's a fair thing to say because I've
I just
lived
asked
in.
a question. Can you answer the question?
Yes, I love living in the city in DC, in this neighborhood for as long as I have. I lived in DuPont Circle at one point, which on 17th Street, which has lots of businesses and rowdiness, but there's a certain I'm not here to say that there should be no businesses on 11th Street. I didn't move into this neighborhood thinking that it was going to be bucolic, but it's
Mr.
different.
Almeida, we've been here for a long time today, and I thank you for your honest and kind words and your testimony today. Welcome to Washington, D.C. Thank you very much for your testimony.
Thank you, Mr. Short.
That's all I have, Mr. Chair.
Yes, Mr. Short. Any other questions by any other board members? Go ahead, Mr.
Thank you, Mr. Chairman. Mr. Almeida.
I'm sorry, go ahead, Mr. Grandis. I didn't call your name. I want to make sure that I'm recognizing you for the record.
And you have, sir. Thank you. Mr. Almeida, the issue you all brought before us today is not a new issue to us. And we appreciate when a licensee and a resident try to resolve this type of issue. And I think it sounds like the licensee and you all each have tried to resolve this issue, but do not have an agreement that it's resolved for each of you. So we've been hearing about sound, and then we hear about vibration. Do you know if any of the discussions you've had has talked about getting a licensed sound engineer? Because that is something that is not unusual in DC when businesses abut residential. So I know we've heard testimony about adjusting the volume, but do you know if you all have ever had discussions working together on getting a sound engineer?
Yes, so during our ABRA mediation, that was one of the things that we discussed, and I followed up with in the email that we submitted as an exhibit, was specifically that hiring a acoustic professional to be able to assess the situation and make recommendations.
And what happened? I'm sorry.
There was no follow-up from the applicant's part after that.
Okay.
Hold on. Mr. Grandis, please. I need to withdraw the question that you just asked. We should not be talking about what happened at mediation.
Oh, I didn't mean the mediation. I wasn't asking. I was asking about the sound engineer. I agree with you.
His response is, yeah, so I need that to, okay. Not to touch that issue.
Well, I'll address it.
Mr. Morris, I need you to keep me on my toes, sir. You need to make sure I'm paying attention, Mr. Morris. You need to.
It's late in the day for all of us, Mr. Chairman. I'll do better. Thank you.
I can't do everything. You need to object. And it's just, in all fairness, we're not supposed to discuss what happens in mediation or settlement at these.
My question was about sound engineer, not about negotiations.
But I know, but
I agree with you, and I appreciate your advice, sir. Often there is concern about sound when it's actually vibration, and perhaps having a vibration specialist look at this may come up with a very easy solution for each side to allow them to have the entertainment they want, and as well as not having vibrations going through your building wall, possibly through yourself. So I just wanted to make sure that you all were aware that this is not a new issue in Washington, D.C. One of the beauties of Washington, D.C. is that we can live in every neighborhood, and every neighborhood can have nightlife, and that's really wonderful. So I'm just bringing up a suggestion on perhaps, because it does sound like each of you all want to live in harmony, and maybe this is a way to try to get to there. Thank you, Mr. Chairman.
Thank you. Any other questions by any of the board members? Any other questions by any of the board members? All right. Mr. Morris, any questions based on the questions that were asked by the board?
No, thank you, Mr. Chairman. I don't have any further questions.
Any redirect? Mr. Nod?
No, but I did just notice that Mr. Ruiz popped in and then now is not here, so.
All right, well, let's deal with one thing at a time.
Mhm.
All right. Do you have any redirect? Any other questions for Mr. Almeida? All right. Is there another witness that you wish to call?
It would be Mr. Ruiz who just popped in and then left. I don't know what happened there.
All right, so you plan to call Mr. Ruiz as a witness, is that correct?
That we had, and if he's not here, that is. But it was interesting he was here.
All right. It's the beauty of technology and the beauty of text messages and trying to figure out what's going on, and at the same time looking at I've had an opportunity previously to browse your PIP, and I did not see all of that earlier. So I think they uploaded the documents now. And so I heard you mention a witness, Mr. Ruiz, but the previous documents that were uploaded for me to look at, I did not see that witness list. And so now that I was told that Mr. Ruiz was hanging around there, but he was not aware that he was being called as a witness. I think he was just being curious to listen to the hearing. I'm now looking at your PIP and I see that he is listed as a witness. So if you are calling him as a witness, it appears that Mr. Ruiz is available, and I will ask that his rights be elevated so he can testify. So are you calling him as a witness?
Yes, right? You're going to question?
Yes.
All right. All right. So, Mr. Ruiz, can you come back on camera, please? All right. And as I said before, you know, when we do all these hearings virtually, I'm trying to do a whole bunch of things at the same time that when we meet in person, I have the legal, my lawyers are sitting behind me who's telling me what I'm doing or what I'm doing wrong. So now that we're doing these things virtually, and I will say that I have to depend on text messages to speak to the lawyers. I'll say that. So to speak to our lawyers to make sure that I'm not, everything is going. Anyway, all right. So Mr. Ruiz, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth? You're on mute, sir.
Can you hear me now?
Yes, sir. And let me correct the record. It appears that from your parents here, you are still employed at ABCA, and you know I think I put out there that you're no longer working for the HNC. That is my error, and so I want to correct the record that as far as I'm concerned, and you've been here, you're still an employee in good standing at ABCA. All right.
Yes. Just started my shift, actually. So.
Okay. Mr. Powell, is your witness, sir.
Okay. I'll be examining Mr. Ruiz. Mr. Ruiz, is it true that when you came to our home on Thursday, April the 13th?
I'm sorry, Mr. Almeida.
Yes.
Can you establish for the record who is Mr. Ruiz?
Oh, okay. Yes. Sorry. Mr. Ruiz is an ABCA inspector?
No. You asked him who he is, sir.
I'm sorry.
Ask him who he is.
I'm new to this. Mr. Ruiz, could you describe who you are and what you do and why you're here?
Yes, I'm an investigator at the Alcoholic Beverage and Cannabis Administration, and I'm here because I conduct investigations in the District of Columbia for licensed alcohol license establishments.
Thank you, Mr. Ruiz. Do you remember coming to our home on Thursday, April 13th, 2023?
Yes.
Okay. Is it true that when you came to our home, you confirmed to me that you could hear the amplified sound from the patio inside our home?
I did not hear it from inside. I believe you showed me a video that day from another incident that showed you the video. I did mention when I was walking in that I could hear noise from the patio.
Okay, so you're saying now that you did not hear noise inside my home when we were sitting there talking about it?
No, I don't recall hearing noise.
Okay. Can you explain why there is no mention of my email complaint to you on March 18th? I'm sorry, that described the 2 dates when the patio was open beyond the allowable hours on March 18th and April 3rd.
No mention where exactly?
Anywhere in the investigators' reports, there's no record of me filing that complaint.
I don't keep records of complaints. I respond to complaints to my management. If there's no violation, there's no report written. And if this was a protest investigation, I didn't write the report, so I could have no control of what was placed into it.
Okay. So, when you did visit the establishment, did you verify if the applicant was complying with their certificate of occupancy?
For that particular day?
Or any of the times that you visited the establishment?
So, yeah, I believe it was 2 times during that time. The first time was because of a complaint for the after hours of the Summer Garden or Sidewalk Cafe. And that I did make a visit to the establishment, met with the owner, asked to review a settlement agreement and the license, reviewed the settlement agreement with them in person to go over the hours of their Sidewalk Cafe, and informed them of, they have to pay attention to those rules. And then the next time was in regards to music being played on the speakers. And then, we talked about the settlement agreement having some restrictions in there. And then when I went to the establishment after speaking with you, I met with the owner again. We looked at the settlement agreement in regards to that. There was music being played at the time when I went to the establishment. It was at a conversational level, in which, I discussed with the owner in the settlement agreement, if I remember correctly, I don't have it in front of me. It states loud music cannot be played in the area, and I just instructed him to monitor his sound levels, ensure that it's not played, beyond that area because it's not supposed to be heard across the street or adjacent on 11th Street, I believe it is you're on. Right. Vermont. But prior to speaking to him, I did go across the street to check if I could even hear the music. And again, it was conversational level. It could not be heard across the street. So at that time, I basically educated him to make sure he understood what exactly is required of him in the settlement agreement of his license and his hours, and did advise him that future could cause to be violated, to cause to get a violation.
Can you just? Sorry, go ahead.
After that, I've monitored a couple times, and I didn't notice violations. In fact, we had issues with a neighboring establishment, but after that, I didn't receive any more complaints to look up, and I did monitor a couple times, and they were being compliant.
Can you describe to me the standard with which you, as an inspector, are trained to substantiate a complaint when you go in someone's home?
For a noise complaint?
Correct.
So, basic standard is that when we go into a person's home, and we hear noise, whether it's bass, vibration, or music, then that would indicate a violation of 25-725.
So that's it. If you hear anything, then you can substantiate a complaint.
Yeah, there's a noise vibration caused by amplified sound.
Okay. All right. It's surprising to me that you were not unable to substantiate the complaint when we met because.
Mr. Almeida, please ask the question, sir.
No, I think that's everything that I have for Inspector Ruiz. Thank you, Mr. Chairman.
Mr. Morrison, a question for Mr. Reeves. Mr. Reeves. You're on mute, Mr. Morris.
Thank you. No, I don't have any questions for Mr. Ruiz. Appreciate him joining us. Thank you.
Mr. Ruiz, how many times did you personally monitor this establishment, sir?
In the past couple of months, probably 4 times that I've been by the establishment.
And are you on the evening shift?
I am. I work 5:30 to 4 Sunday through Thursday, Monday through Thursday.
And so normally when during the 4 times you monitor it, you'll monitor it during the evening, is that correct?
Correct. They've been usually around after 11:30, between 11:30 and midnight.
And during the period of time that you have monitored the establishment, have you personally observed any ABRA violations, sir?
No.
All right. Any other questions any questions by the board members of Mr. Ruiz? All right, thank you. I'm sorry, this is Mr. Almeida's witness. Mr. Morris, any questions of Mr. Ruiz based on the questions that I asked?
Just one, Mr. Chair.
Based on the questions that I asked.
Exactly. I just have one quick follow-up. There is the 4 times that you checked on this establishment, would any of them have been reflected in the protest reports, or would those have been additional to those?
I can't say. I'm not sure exactly when this protest investigation occurred. It was the times I went were in the month of April and May. And I'm not sure if it was being conducted. I wasn't notified or asked about it.
Okay, but you did not conduct those investigations for the purpose of preparing the protest report.
No, they were based on the complaint.
Thank you.
This is your witness, Mr. Almeida. You have the final say. Do you have any redirect of this witness?
No, we do not, Mr. Chairman.
All right, thank you, Mr. Reed. Thank you very much for your availability. I did not know that you're supposed to be a witness today, but thank you for being online and being available to testify. Thank you very much, sir. You're free to go.
You're welcome. Have a great night, everyone.
Thank you. Mr. Nalor Almeida, do you have any other witness that you wish to call?
No.
No, we do not.
No. Do you arrest, sir?
Yes.
All right. So at this time, we're going to have closing. So it is, I'll say it's 3 minutes to 6. So let's take a 10-minute break. So at 6:10, we will come back to do closing. All right. So we are off the record until 6:10. Thank you. We're back in the record. All right. Now we have, it's time for, let me make sure, 1, 2, all the board members. All right, it's time for closing. And so I'll give you both 5 minutes to close. What I need specifics. What is it that the applicant will, goes first. And so 5 minutes, I need the applicant to be specific what it is that the licensee wants the board to do. And after the licensee gives his closing, then the protestant will give his closing also. And you have 5 minutes, and I need you to be very specific what it is that you want the board to do. All right, so go ahead, Mr. Morris, closing.
Thank you, Mr. Chairman. Thank you, members of the board, for spending so much time on this matter today. The board heard testimony from investigator Platas that there's been, over the course of the 2 protest reports, there were 20 visits to the establishment, that most of them occurred during the late evening hours, and none of them resulted in any kind of ABCA violation or any substantiated issue regarding an issue with noise or any other violation of the existing settlement agreement. We heard testimony also from the investigator that there were 5 calls for service to the police in response to complaints about noise in the fall of 2022 after the establishment opened. None of them resulted in any violation or any substantiated issue with regard to noise. And we also heard testimony from Mr. Ruiz that in addition to those 20 ABCA investigator visits and 5 police visits, that he himself conducted 4 visits to the establishment in response to complaints. And on those visits, at least two of those occasions, he went over the settlement agreement with the owners of the establishment. He was out on the patio and near the patio when it was open, when the televisions were on. He went into the home of the protestant, and he could not hear anything in the home of the establishment and could not determine that there was any issue with noise either inside or outside the establishment. Mr. Almeida himself testified that January through March were when he had the most problems and issues, and the text messages that he submitted demonstrate that he reached out to the applicant about it, that measures were taken, that music was turned down. We heard testimony from Mr. Mason that all sorts of vibration and noise mitigation measures were taken inside, and that starting in the springtime, starting at late March, they worked. Mr. Almeida testified that he had no further complaints and didn't have any issues. Now, I'm sympathetic to Mr. Almeida. I know this is his home, and being able to live peacefully in your home is important, and I'm sympathetic to that. But I also am sympathetic to and I hope the board will be as well, to these business owners' ability to run their business in a way that serves the community that they are part of, and that includes the ability, as they are licensed, to operate a summer garden, and subject of course to the restrictions, the existing restrictions in the settlement agreement. The settlement agreement provides for no loud or live music, and provides for noises emanating into adjacent residences. It provides for efforts undertaken by the applicant to ensure its patrons are not loud or disturbing of nearby residents and businesses. And again, 29 times we have testimony of people coming out to the establishment trying to see if there's a violation, either responding to a complaint or responding to the issues raised in this protest. And at no point, not one of those times, was there even so much as a warning issued turn it down a little bit. You're violating this. No point. At every point, we heard from Mr. Ruiz, from Investigator Playtas, that at every time. So the conclusion that seems inescapable here is that these applicants and licensees are operating their business according to the law and according to their settlement agreement. And I want to just be very specific here. Because the issue that Mr. Chairman put before the board and put before us today was, are additional restrictions required to be put into the settlement agreement as part of the renewal? Everything that Mr. Almeida has complained about, every bit of evidence that he has put on regarding alleged violations by the licensee, every single one of them, if substantiated, would have been a violation of the existing settlement agreement. There is simply nothing that needs to be added to the settlement agreement to ensure that those things, if substantiated, would rise to violations. The existing settlement agreement is perfectly capable. It was capable when it was Room 11 operating on it, and it's certainly capable now that Buddy's is operating under it to protect the interests of nearby property owners and to protect and preserve the peace, order, and quiet of the community. And again, 29 separate visits, different times of day, mostly at night. Mr. Ruiz said all of his were at night. Inspector Plata said most of theirs were late at night. So Mr. Almeida, I understand his frustration and I'm sympathetic to it, but his frustration is, what seems to me is his ability to direct ABCA to do what he wants them to do. He has called them out, he has complained, he has filed this protest, and ABCA has said this business is not violating any law. And that is, I understand that seems to be frustrating to him. But it's his ability to enforce this settlement agreement in a way that works for him is where his perception lies. Because this applicant and this licensee it has a settlement agreement that if it violates the settlement agreement, there would be a violation. But it either hasn't violated it or it's been awfully lucky in that 29 times ABCA investigators or police have been to the establishment to respond to complaints, and not a single time has a violation been found. Now, and I just want to make one final point, and then I'll be finished. The licensee has taken we had testimony that the licensee has taken substantial noise mitigation efforts with respect to the interior of the premises, such that the acts that they have taken to ensure their own compliance with their settlement agreement, as well as to ensure the peace, order, and quiet of Mr. Almeida, have addressed those concerns, such that there hasn't been a complaint in 4 months. There's absolutely no reason and nothing that has been presented to the board today that would in any way indicate that when their patio and summer garden reopens, that they wouldn't act in a similarly compliant manner to ensure that the neighbors are not disturbed and that the peace, order, and quiet of the community is not disturbed. So what we would request of the board specifically, we have already requested, and I think the board has already determined that the license should be renewed. We would just ask that it be renewed, subject to the existing settlement agreement that the testimony today has demonstrated protects both Mr. Almeida as well as everybody in the community, that without any further change, and that the applicants are permitted, as they have been throughout, as the testimony has clearly demonstrated, that they be permitted to continue to work to ensure their own compliance with that settlement agreement, and that no further restrictions be put on them with regard to any noise mitigation or anything else in the agreement. So I don't have anything further, and I thank the board for their time and their consideration and their thoughtful questions today. So again, just the specific request is that the license be renewed, subject to the existing settlement agreement with no further restrictions. Thank you, Mr. Chairman. Thank you, members of the board.
Thank you, Mr. Morse. Mr. Nile?
I'll read our closing
Or Mr.
statement.
Almeida, I'm sorry, I apologize.
Okay.
And I know who I was calling before. I'm not going with the way the names are written on my screen. Okay. All right, Mr. Almeida.
Thank you, Mr. Chairman. Despite the challenging experiences we've had as a result of the applicant's business operations, our protest, again, is not asking the board to revoke the applicant's license. Again, we have coexisted peacefully for more than a decade with our previous neighbors, Room 11 and Bad Saint, both of whom were directly abutting ABCA licensed establishments. This is evidenced by the fact that you have not seen us here before. We request that the board require the applicant to engage a third-party professional acoustical engineer to analyze their space and incorporate noise mitigation improvements within the premises to ensure that music, noise, and vibrations from the establishment are not audible or felt beyond the curb of the establishment or in any other premises at any time. We request that the board require the removal of exterior sources of amplified sound and require that levels for amplified music inside the establishment be at a level that results in no music, noise, or vibrations from the establishment being audible or felt in the abutting neighbor's premises or home located at 1106 Lamont Street Northwest. Ultimately, we're asking the board to impose these conditions to ensure that the applicant runs a business indoors and outdoors that is appropriate and respectful of the predominantly residential RF1 zoned setting it has chosen to open in, so that we may live in our home with peace, order, and quiet. We'd like to thank you for your time and attention.
Thank you very much, Mr. Almeida. All right, the record is closed. Do the parties wish to file proposed findings of facts and conclusion of law, or do they wish for the board to make its determination on what's presented today? And proposed findings of fact and conclusion of law, basically, it's to wait for the transcript. You read the transcript, you say this is what was presented. This is what was presented. This is what the law. This is what the board should do. That's an additional work if the parties want to do that, or you could waive it. The board will make a decision on the evidence and the testimony that was presented today.
I think we're going to ask for the findings and facts.
I'm sorry.
We're going to ask for the findings and facts.
You want to do findings and facts? Okay, so if the parties choose to file proposed findings of facts and conclusion of law, then 90 days from when the board receives the proposed findings of fact and conclusion of law. So therefore, your findings of fact and conclusion of law, they're due to the board 30 days after receipt of the transcript. The transcript will be emailed to the parties in approximately 3 weeks. So the transcript will be submitted in approximately 3 weeks. And then you have 30 days from the submission of the transcript to provide your proposed findings of fact and conclusion of the law. All right. So the record is now closed. So let me officially close this matter before I close the hearing. So give me a minute. And if you change your mind, please advise the board as soon as possible if you change your mind and decided not to file the proposed findings of fact and conclusion of law. Okay? All right. All right. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Official Code Section 2575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 23 PRO 00004 Buddies DC, pursuant to DC Official Code Section 2575 B4A of the Open Meetings Act, and deliberating upon case number 23 PRO 00004 Buddies DC for the reasons cited in DC Official Code Section 2575 B13 of the Open Meetings Act. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. I will now take a roll call vote on the motion before us that has been properly seconded by Mr. Short. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. As it appears that the motion has passed, I hereby give notice that ABC Board will recess its proceedings to hold a closed meeting pursuant to Section 2575 of the Open Meetings Act. Thank you very much. Give me one more minute so I can officially close the record for the day. And then you all are free to go. So just let me close the record for the day. As chairperson of the Alcohol Beverage and Cannabis Board for the District of Columbia in accordance with Title III, Chapter 405, Office of Open Government, I move that ABC Board hold a closed meeting on July 20th, 2023 for the purpose of discussing and hearing reports concerning ongoing or planned investigation of alleged criminal or civil misconduct or violations of law or regulations and seeking legal advice from our legal counsel on the board's investigative agenda, legal agenda, licensing agenda for July 20th, as published in the DC Register on July 14th. Is there a second?
Bobby Cato seconds.
Mr. Cato, I second the motion. I will now take a roll call vote on the motion before it has been seconded. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. As it appears that the motion has passed 5-0, I hereby give notice that ABC Board will hold this closed meeting. Pursuant to the Open Meetings Act, notice will also be posted on the ABC Board Hearing Room Bulletin Board, placed on electronic calendar on ABCA's website, and published in the DC Register in as timely a manner as practical. We are now adjourned for the day. I want to thank everyone for their active participation in this hearing today. And now I ask all board members to return to executive session for further action. Have a great day. Thank you very much.
Thank you very much. Thank you.
Thanks.